Good morning, ladies and gentlemen. How are you guys doing this morning? Lana will be here shortly. It's Bella right now. Hi, DB. Good morning. Good morning, Yuri. Do we have you all day today, Yuri? I hope so. Enlightening. If you can't tell by my voice, I just woke up. It's 5:30 in the morning on the West Coast. Hi, everybody. Okay, I'm going to get tea. And then you guys are going to have tea and comments for us. It's a great day, Angie. Yeah, yeah, it is. I have a feeling that the justice train is coming for Karen. And I have not, she's going to be free because she's actually innocent. And I don't think that I felt this way, like really felt this way about her chances in a long time. Morning, Marky. Voice started talking to you. Yeah, I know what that's like. Yesterday, when I ended the stream, it was like 2 hours later. My computer's closed, and it's like just YouTube's playing. It's like Law and Crime or something. I have no idea. Just started skipping around. It's like, what is happening? What are you doing? Mind of your own. Okay, I need tea and coffee, I think, today. Be right back, guys. Can we take a wager on what time we think that Bev is going to waltz in today? Do you think that she feels some type of way about what went down yesterday? Because she was pretty red. I can't even believe. And she's getting so snappy with Alessi, too. Okay, here. She's taking a sick day. Octavia, good morning. Okay, let's see what you guys are saying. DB is saying 9:10. Oh, Southern Sass agrees with you. Good morning. You're so nice and sweet. A Lady Leo gives it at 9:16. Okay. Yuri goes at 9:12. You know, oh, I think I see some agreeing. Okay. Murky's agreeing. All right, you guys, listen. She usually does like an 18 after, right? Like 18 minutes after, give or take. Everyone remember what you wrote in here if it's not too early for you. And let's see when she takes the bench. Chance. Chance. Yes. Jinx. Ditto. There were some really hilarious tweets yesterday. And I think the best tweets yesterday were from the camp of Can't Read is Guilty. And I was just like, oh, what planet do you guys live on? Where are you guys living? Good morning, everybody. Good morning, Emma. MW. You are peach mimosas? Wait, what? I just got my tea. I feel like I need to catch up. You guys, I want to see if anybody is tweeting and saying that they are waiting for some fireworks to drop. I haven't looked at motions yet, so I have no idea about motions this morning. We'll find out soon if some motions have dropped. Mhm. I feel badly, though, for the people of Massachusetts. What planet is Massachusetts on? Massachusetts used to be my favorite. Well, not like, but Boston used to be my favorite place outside of where I live. And then this happened, and I'm like, wait, what? Not like it should affect Boston, really, but I feel bad that they have to pay so much money. Hi, Carson. It's mommy. You can't miss this. Yes. Have us on your flight to Cancun. Enjoy Cancun. That sounds like amazing, amazing times. Karen's going to need to go to Cancun. It is a gong show, Octavia. I don't know what they're doing over there. I just change the country every time, but I call it something donkey show. A Dominican donkey show. Maybe today it'll be a Colombian donkey show. Mhm. Karen is going to own Cancun soon. Yes, as she should. As she should. And if I was a citizen of Massachusetts, I would be so pissed off at Norfolk County because I'd be like, this is not where I want my taxes going. This lady is innocent. What are you guys doing to her? Stop wasting my money. Okay, tea time. KP. Oh, your doggy is so sweet looking, KP. Did Bev rule against Crash Daddy talking about the shirt because he doesn't have a degree in textiles? This is so insane. um, I almost have, okay. you're gonna have to forgive me because it's just how early it is here. I don't want to speak wrong. I almost have a memory of her doing that yesterday, but I'm so tired right now and no caffeine in me that I don't know if I can say that definitively at this point. But I think that I swear she did that. Was I dreaming? There's Ello. She's gonna tell us about it.
Good morning, Karen Reed, child watchers.
There's Hey,
Can
Lana.
you hear me?
Yes, can you hear us?
Yes, I just entered chat, love. Can you hear me? Well, we're gonna see if the logistics are better over here. But Jax, what word did you learn this morning?
Coup contra coup.
He did. OMG, Jax, you did.
Jax,
Jax,
what do you
we're
think
naming
about
doggies that.
Jax? Do you think Karen Reed's innocent?
Yes.
Oh, yay! How do we break it down?
You.
Do you think, okay, so if you had a soccer game and the other team started with 2 goals and you started with 0 goals, do you think that's fair?
No, I would karate kick them.
You'd karate kick them? Would you let the ref know what's up?
Yeah.
Yeah. Coup contra coup. I love it. Coup contra coup.
I love that you taught him coup contra coup, but did you tell him what it meant?
I told him he can use it any way he like.
Oh, okay. That's fair.
No, I said, no, we were talking about injuries, sustaining injuries. Like, we were talking about, okay, like a concussion, you know?
Mm-hmm.
So I was like, coup contra coup is a little bit more of a medical term. But think about your head and some injuries that you would sustain. Coup contra coup, baby. So I just got to get him thinking about, you know, some injuries.
Yes.
Can't just go blasting them all like
Athlete
PhD.
injuries.
Yeah.
Hey, Lana.
Yeah, so how can I be of service?
Yes, please be of service until my brain catches up. Yesterday, or maybe even today, but I swear it was yesterday. Did Bev already rule on whether Dr. Renschler can Renschler can opine about holes in the fabric because he doesn't look at
No, I don't think anybody can that's what Hank was talking about. He doesn't think that Dr. Renschler should be talking about holes in fabric because he's not an expert in holes in fabric. You know what?
Did she rule?
I think that any grandma out there that you know, does crocheting or a seamstress. I mean, come on, you want to get a seamstress in there? Can you imagine if they call a seamstress to the stand?
Yeah, no, I can see Hank doing that. I can see Hank making the defense do that and then saying, "How'd you get here today?" And she has her walker.
Jax, how many kids are at this little summer shindig? There's 20.
Yesterday and the day before, there was only 13.
Only 13?
Oh.
And then you only have 13, like, so both days was 13?
I think so.
Okay. Okay. Do you have any males teaching you, or is it just females? Just females? Okay.
Good morning, Shelly.
All right. All right. Hang tight. Okay, so coup contra coup. I think this is where we're going. Oh yeah, we're gonna come in the back way, Jax. Okay. Oh gosh. Okay. We just. Okay.
Maybe I can help with like spots if you want to.
Mm-hmm.
We just make our own rules around here, Jax. Okay, so right here is where I'm gonna park, like, and then I'm gonna walk right here to the side. Okay. So, because they have a little ordeal.
Go by that like bush.
Yeah, but see all this stuff right here? We're not gonna get caught up into this, okay, honey?
No, park like over there.
Yeah.
After
It
yes or
didn't start
what?
yet.
Yeah.
It did-
Okay,
actually, yeah, let's just go over here because it didn't start yet.
Okay, yeah, but it starts in 2 minutes, so I think you're okay to be by the door.
No, it
No?
does not start in 2 minutes.
How many minutes?
It starts at
Getting
Okay, let's
drunk.
park on this side. Okay.
I was just not park over there.
Okay, yeah, we'll just park over here, and we'll walk over there. Yeah, because all that logistics right there, we don't get down
I
like
think
that.
you could park in the spot.
Okay, yeah, this spot, does that look good for you?
Yeah.
Okay.
I could just walk.
Yeah, these are legs.
But I'm gonna wait until it's done.
Okay, honey. What other words should we learn this morning? Say a word, or tell me a word that you want to learn that's like what's another word for handsome?
Skippity.
Skippity.
Who loves that word?
Jax, do you want me to call you? You look skippity today. You so skippity.
Hello.
Jaxie, what is
It's skibbity.
yeah. What is let's see. What
Tell me another word for handsome. He's got
okay,
it.
where is Cristiano Ronaldo from?
Portugal.
Portugal. Where's Lionel Messi from?
Argentina.
Argentina. Where's Lamine Yamal from?
He's from. He plays on the Spain team, but I don't know where he's like from.
Is he from Barcelona?
No, that's a club.
That's a club.
Yes.
Okay. Well, who name? Where does Holland? Where's he from?
I think Uruguay.
Is he from Sweden?
Yeah, Sweden. I think.
Where's who else? Who else do we like?
Mbappe.
Oh yeah, where's he from? Mbappe.
France.
He's from
You
France.
better bring up Neymar, or we're gonna be upset.
Oh, where's Neymar from?
Brazil.
Brazil. Where's Hope Solo from?
Who's that?
Female goalie for the United States team.
I don't know who that is.
Okay, she's from Seattle. Where is who else? Oh, where's Petrie from?
Stop doing women. I don't know.
No, Petrie isn't a woman. Isn't that his name? Oh, Lewandowski.
Oh, he's.
Come on.
No.
What teams do you play for?
I don't know.
You know what team Lewandowski plays for? What jersey did I just get you? The red one.
Man United?
Yeah, who is it?
No.
Oh, Manchester?
Yes.
Who plays on that team?
Fernandez. Garnacho.
Mm-hmm. Who used to play on that team? Ronaldo, good boy. We're just doing our tests here. Good morning. All right. What do we got here? 8:52. So Bev will be about 16 minutes late today. Probably a 9:16 start.
Is it time to go in?
Yeah, I'll walk you up, baby.
No, you don't have to walk.
Oh, look. Fan.
Oh, we got a fan.
If you guys want to take a guess at what time she's going to get on the stand, we kind of did that a little earlier. If you got here a little later, have some fun with it.
Yeah. And those of you guys just joining us, Jax, what word did you learn this morning?
I forgot.
You already forgot our word. Coup. What'd you learn?
I forgot.
Coup contra coup?
Coup
No, it's not Coo Poopy Doo.
I hate Scooby-Doo.
Is Karen Reed innocent?
Yes.
Yes. Woo! Shake the cowbell. All right, guys. I'll be BRB.
Mama, there's too much.
BRB. He is brilliant. He really didn't forget, you guys, in case you didn't catch that. He's pulling her leg. He's good like that. He's one of the smartest kids I've ever met. More cowbell. More cowbell. Oh, hi, Pixie Dot. Welcome in this morning.
Welcome. Good morning. All right. Jax learned. I was like, "Do you know what railroad means?"
He did
Yeah.
not.
Yeah, I told him what getting railroaded means.
Like, let me teach you about similes. Let me teach you about idioms.
I about had a heart attack the other day when Jack said he wanted to be a police officer. I fell over.
I think it's called a phase.
I said, what about being a lawyer? I said, you don't want to be a lawyer? He's like, I want to save people. I said, well, lawyers save people. He said, I want to save people like right away. I said, I was like, you want that instant gratification, don't you? Don't you? So I said, you know what, Jax? We need more people like you to be cops, so I guess I can get down with it. I said, how about being a detective? You know, you want to work your way up. I was like, don't think that this gets you out of going to college, because it doesn't. So that was our talk the other day about fell out of my. I said, where is this at?
That would be your karma, though. Like, my mom always would tell me, like, however I treated her, she's like, you're gonna get that in spades. Wow. And I'm like, what? Yeah. So he became a cop. And be like,
did anybody love the title of this video, by the way? It says, Karen Reed, day 31, non-lawyer analysis.
Non-lawyer coverage with F.
Yeah, do you like that? I want a Coke. It's McDonald's. I want a Coke.
I literally thought I was in the wrong thing again because you like to prank me all the time.
This is my literally. Karen Reed, day 31. Oh my God! So how about Andrea freaking Burkhart? Hank was saying thrust. Did I say that to you?
Yeah.
And she's like, we wish your mom didn't know what the fuck thrust went.
She goes, we know you don't know about thrust, but we wish that your mom didn't know about thrust, Hank. That was the best because Andrea's really like, she's passionate, but she's like even keel for the most part. Like, and she just like balls to the wall, like, I spit out my drink. That was good.
Oh God! I mean, when I got that clip, Lady Di, if you're in here, yeah, that's all. Thank you so much. When Lady Di sent that to me, I was like, I was like, see, that's why. Thank you so much. Have a great day. I was like, yeah, that's why I mess with Andrea. Andrea gets it. She's like, we wish your mom didn't know what thrust meant.
She has to be pissed to say something like that. Like,
you know what? And I listened to Melanie Little on some random, like, I don't even know what it was, on something else, and literally everything that she said, we said for the record. But like, it was nice to see, you know, because I want these lawyers to get fired up, but I want them to do something about it. You know what I mean? Like, it's like anything. You have a platform, you have a voice, and you have, you know, people are going to say, like, you're more credible than someone like me that's not a lawyer to say whatever, but there's got to be something that can be done about this.
So, do you see? Because
just
I don't
keep blasting
watch.
these people. I think that there's no such thing as decorum anymore. I mean, I literally lived it. I had a judge saying to me, "What do you mean by objection by foundation?" And I'm like, "What?
What do you mean?
What do you mean?" Like, I had a judge say that to me. I'm like, "Objection. Can we lay some foundation? Foundational. Objection. Foundational. What do you mean, Miss Oriani? What do you mean? What? What do I mean? What the fuck do you mean?" I couldn't even believe it. I'm like, foundational. Like, can we get a date? Can we get a time frame? Can we get? How about also relevancy? How is this relevant? That some kook in Colorado that I've never met before filed a protection order against me. How the fuck is that relevant right now?
It's so not relevant when you know who the kook is.
It's not relevant. It has nothing to do with shit. And then how is a YouTube video of mine from 4 fucking years ago? Lay some foundation. That's a screen recording. I didn't make that video. That could have been altered. Lay some foundation. Who screen recorded this? What's the date and time stamp on this? I shouldn't be testifying to introduce this piece of evidence because I didn't fucking create it. So I'm objecting to myself being asked questions of a document or whatever you want to call this video. Ms. Oriani, are you saying that you're objecting to a video that you made? What? I didn't make this video. Ms. Oriani, you want the courts to believe that that's not you on the camera? I said, now you want to be cute. I said, I guess you don't get it. You want the courts to believe that nobody in your household can hear what's being said on the screen that we're all watching, that we all hear? I said, that's exactly what I'm telling you, because when I have earbuds in, it goes straight to my ears. You think that shit blasts through my house? No, that's not how it works. And you have no idea because you didn't lay proper foundation. I was losing it. We got it, Lana. We know it was a disgrace. This is all disgrace. But everybody just thinks that these judges are just like, because you're a judge, like you're an expert in everything. How can a judge tell a doctor like La Posada that she can't testify to and saying the word that is consistent with being a dog bite? Like, how?
Lana, because that's normally what happens, because that's the judge's area of expertise and that's the doctor's area of expertise, and they know when they cross and when they meet. Bev just sucks at her job. That's all. But yeah,
I don't know.
Fine.
I mean, a judge can literally like.
Bev sucks.
How can you be deemed an expert in one, or let's say like 50 courts, like 50 different cases, you testify as an expert? How damn dare, like, then this 51st judge comes along and deems you, yeah, you're not testifying to any of that shit. I'd be like, you want to know what you can do? You can suck my titties. That's what you can do. Like, how can you say that? I think that they need to answer for their rulings. Like, that's the other thing is, like, you know what? If you have the balls to throw up an order, or you have balls to go against the grain, okay, give me some legal I want you to back your findings. I want you to and I think Alan Jackson did that yesterday when he wanted an explanation. And Bev was like, you're not getting one. My word is it's like your mom. Mom, why can't I do that? Because I said so.
Mm-hmm.
That's Bev. Because I said so.
That doesn't work in court, you guys. And I think that Jackson, who always has so much decorum, just lost his. he still had decorum, but he interrupted her a couple times, which he doesn't typically do to any judge. And
what are these people doing? I mean, does anybody know how to drive around here?
I think he literally is just not taking any more shit. He's over it, and he shouldn't.
I can't wait till Bev finds out. I mean, I can't believe. Okay, so I guess Karen Reed came out and said that Welcher's the last witness.
So our friendly wager, mine and yours. So I won.
Well, but guess what? Also, Karen Reed said she said it'd be over on Tuesday.
Do not.
So who knows? Maybe Karen Reed's psyching these people out. If I was Karen Reed, I wouldn't be telling them shit. TBD. Yeah. That's all I'd be saying. TBD, baby. Mm-hmm. I'd be telling all these people that had all this B-roll film to just hand over to the Commonwealth. Like, why did you keep all that shit? You dumbasses. I'm sorry, I think that Gretchen Voss and Ted Daniels should have had to testify to get that shit in.
It is such a clusterfuck up there that Hank can just
playing like, clips from TV.
No, like it's like some demonstrative like exhibit, but no one's testifying to it. Just before anyone gets on, he's just playing some random clip, no explanation, no talk. Like you're giving a demonstration about something. What are you presenting, sir? What is this about? This is bizarre to the jury.
Fourth graders could do a better job.
No, it's not. This isn't Hank's fault. This is Bev's fault for allowing it. You don't allow that. Who's allowing that? It's weird.
Is there a froggy noise?
Always, yesterday too. And I thought it was because when you passed something when you were driving, but then when you got back, it happened in the house too. So I was like,
okay, no, it's okay. I'll go in and come back out. I'm definitely gonna be. Is it better now?
It happens like you know when you're on the freeway and you're passing like medians or something. It happens every once in a while. It's like a few seconds. Right now, it hasn't happened since you asked.
Since I probably.
I'll tell you.
It's another gorgeous day, though. It's another beautiful sunny day here. What's the temperature?
There.
69.
Right there. Maybe it's only when you talk. Well, it's got a deal until like I don't know, till tomorrow or something. See, it hasn't happened. Talk.
Be quiet, Bella.
It didn't happen.
All right, guys. I don't even know what Hank's gonna do today, but he's gonna try. Did it happen?
Just once.
All right.
1.5.
Bye. I'm coming back in.
Okay. I don't think it's gonna change. Okay. And when you do come back in, Lana, let us know what kind of bingo we're starting the day off. I got to get in, you guys. I got to put the bingo link in. Apparently, I forgot. The caffeine might be hitting. Oh. Okay. I suck at multitasking. I'm really bad at it. I like all my focus. The only thing that I can multitask is like really well. Like I'm very, knock on wood, someone really efficient at is driving insane. Like I can beat anyone driving. And that takes a lot of coordination. I don't know why that kicks in. It's going to be 96 there. Oh, that's so lovely, Lana. I just opened my phone and that's sitting there. Okay. I am coming in. Let me turn down the volume. Thank God. I hate that. Such a rookie mistake. If you guys don't know what I'm talking about, when you are on a mic live, your head of the broadcast in a few seconds. Let's hear it. And then if you turn on YouTube, it lags. So there's like an echo if you have your volume up.
Okay. Can you hear? Is it better now?
It hasn't happened yet.
All right, here we go. Back at the desk.
Thank God. I'll let you know when it does. Keep talking.
I shouldn't be doing it now.
Really? You figured it out?
I don't know. Okay. Derek Ellington, on June 1st, 2025, the defense produced to the Commonwealth a new report from defense expert Derek Ellington.
Wait, can you wait like before you read that, like just 15 seconds so that I put this link in and then you just pin it so I don't have to ever do it again?
Yeah, sure. Sounds good.
Or, I mean, if you want to pause your thought.
You're good. Go ahead.
Okay, did it. Get it.
Okay.
And then you could go ahead and read.
Oh, well.
Yeah, no frogs so far, DB. Okay. You did. If you figured that out, I'd be very, very impressed.
All right, the first bingo game that we're going to start with is a surround Bev's head.
That's good, actually.
It is every square that touches Bev head, and we're going to do it for a $10 holla. So there you go. Okay. Really quick, all I have to say about this is that the defense previously disclosed to the Commonwealth a 13-page report from Mr. Ellington dated March 3rd. That was back, and they had to get the disclosures in. And then Mr. Ellington, then on June 1st, 2025, the defense produced to the Commonwealth a new 16-page report from Mr. Ellington dated the same day. And Mr. Ellington identifies the materials that he relied on for his new report, all of which were available to him at the time of his prior report. And so on June 2nd, 2025, the defense provided a one-page amended to the June 1st report, clarifying a notation on John O'Keefe's cell phone. A copy of the amended is attached. Mr. Ellington now purports to discuss and opine on industry standard best practices for handling seized devices. I don't understand why he's saying that would be something that he's going to opine on now. Like, everybody knows if you're a forensic digital expert, like, that's the foundation that you're laying. So I like, Hank's a piece of shit. But that's like, by that sentence doesn't make any sense, that you're now going to opine on the best standards. Like, what do you mean? Like, that would have been in his like CV, that he can opine on that. Like, I don't think that you would need to state that, but whatever. He's making it like a big deal. Like, oh my God, this guy's going to opine on the standard best practices for handling and seizing devices. Oh God, Hank. So
that was hilarious. It was like premature E. Oh my God, Hank.
There is no evidence. There is no evidence to support that the devices were handled properly by law enforcement, and thus allegedly there is and will always be a high level of uncertainty regarding the validity and accuracy of the O'Keefe and Reed mobile device data. That was in his report. So it says, his new opinions and analysis could and should have been addressed in his prior report if the defense intends to raise these issues. It is far too late to do so now, after the Commonwealth has completed its case in chief and its digital forensic experts have already testified. Moreover, the defense has indicated that they intend to call Mr. Ellington tomorrow. So, did we all miss when Mr. Ellington got called? Were we all sleeping? The Commonwealth, the Commonwealth has not had and will not have suffice time to prepare for these new opinions. So my thing is that, okay, great. If Bev denied his new opinions because it's last minute, he most certainly could testify to his March 3rd, 2025 report. And so Karen decided to yank Mr. Ellington from the ticket. I mean, Hank's the one that says it, that, hey, Alan Jackson just notified us that they intend to call Mr. Ellington tomorrow, and this was written on June 3rd. So when did she rule on this? And that's why I'm saying I just can't imagine, dude, Karen Reed tossing out 15 to 20 G's. And they're not going to use them? Like a digital forensic expert. And all it was is a Commonwealth's motion to preclude new opinion testimony by defense expert Derek Ellington. And it's not to preclude him, period. It's just to preclude the new stuff. And so, it's no different than like, ARCA was still going to testify, even if Bevy Poo wasn't going to let Wolf show that new stuff that they did. Accompanying his new report were several new spreadsheets of information that he created and that were not previously disclosed to the Commonwealth. And you want to know what pisses me off? I'm going to tell you what pisses me off is that if by chance Hank is not lying and that he had all of this stuff to begin with, and Ellington didn't put in a report and talk about best practices just right off the rip, like that's what Cyray's affidavit had in it, like for the first just like couple paragraphs of his affidavit. And so like I'm just really disappointed to see this last minute bullshit that I don't know why I don't know. I just don't like it. I don't like it. I want to hear more about it. I want to know why they wouldn't have a forensic digital person testifying. Okay, guys, we're back. It's 9:15. She's late. Told you. 9:16 we would start. Looks like Bella won a steak.
For the Honorable Beverly Canoni, Justice of the Norfolk Superior Court and for the County of Norfolk. Draw near, give your attendance, you shall be heard. State of Commonwealth of Massachusetts. Court is now open. You may be seated.
2 people got 9:15 when they guessed this morning.
All right. Good morning, Council. Good morning, Ms. Reed. Good morning.
It says 9:16.
I have to ask you those same 3 questions. Were you all able to follow my instructions and refrain from discussing this case with anyone since we left yesterday? Everyone said yes or nodded affirmatively. Were you also able to follow the instructions and refrain from doing any independent research or investigation into this case? Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left here yesterday? Everyone said no or shook their heads. Thank you. Can we have Dr. Renschler again, please?
Bev, I can't believe that you couldn't wear your hair up not one motherfucking day. Not one day were you like, I just want to throw this up in a messy high bun. You couldn't even do it one day for me. Not even one day. What a boring, straight, flat.
Who has bangs like that as a grown-ass 70-year-old?
Good morning.
Good morning, Your Honor.
Not one day could she do it for me. Now, Dr. Renschler, get up there with your iWatch and your laptop. Let's go.
All right, Mr. Jackson, whenever you're ready. Are you ready, Doctor?
I am, yes, Your Honor.
Okay.
Thank you, Your Honor. Dr. Renschler, good morning.
Good morning. Yesterday, when we last left off, we were discussing materials that you had been provided to review, and you described much of that material in furtherance of your answer that you were asked to review certain data and undertake certain testing as it relates to testing that was done by Aperture, correct?
That's correct, yes.
Did you prepare a PowerPoint presentation to illustrate the analysis and methodology in your review and testing of this case?
I did, yes, sir.
Did you bring that with you today?
I did indeed.
Your Honor, I have a flash drive I'd like to have marked as next in order.
Okay. Is there an objection?
Not for identification.
Okay, so it's marked for identification.
Identification, these titties, Bev.
KK for ID.
Did she just say KK?
Let me know whenever, pardon me, let me know whenever you're ready, Dr. Renschler.
Sure, you want me to bring up the PowerPointer?
If you could bring up the first slide, let's start with
Sure.
that.
Let's see here.
Okay, so remember at the end of yesterday, they were talking about slides that had to be like redone.
Is this representative of the PowerPoint that you presented, or sorry, that you prepared for presentation for the jurors?
It is, yes, sir.
Okay. Are there several blank slides, just sort of placeholder slides as we walk through your analysis that the jurors will see?
There are, yes.
Okay. Let's talk about first of all, what was the purpose of your investigation? What did you seek to undertake?
So the purpose of my investigation in this matter was to evaluate the evidence, and particularly as it pertains to the alleged theory of what occurred in this case.
All right, so I'm going to strike that answer, ask the question again.
Sure. Did you seek to undertake an analysis of Aperture's testing or part of their testing?
I did, yes, sir.
All right. With regard to that testing, what was the reason that you undertook to analyze Aperture's testing?
Why? Why? To the form,
Ultimately, were
Mr.
you
Jackson.
in receipt of a PowerPoint presentation and a report from Dr. Judson Welcher?
I was, yes, sir.
Okay. Did you have an opportunity to review that PowerPoint presentation in whole?
I did, yes.
Were you able to look at his report and read his report and review his report?
I was, yes, sir.
Did you undertake an analysis based on his reporting and his PowerPoint presentation?
So I'm going to see you both at Sidebar for just a minute, please.
Okay. So let's just get this. This is what Hank's going to do. He's going to object to every leading question. Remember, we're not allowed to lead. So you have to ask a question that's not leading.
But you have to quantify that by saying we are not allowed to lead in direct, redirect.
You're not allowed to lead in direct examination. In cross-examination, you can say things like, now isn't it true that blah, blah, blah? Like, that's a leading question. Like, in fact, blah, blah, blah. So Hank's over here objecting to leading questions. And I bet you Alan Jackson's up there saying, listen, I'm laying foundation. I'm letting him explain to the court. If you want me to just say, Mr. Jackson, just ask him what he was hired to do. But he's laying foundation to tell the jurors what he was hired to do. But we already went through this yesterday. Mm-hmm. And I guarantee you, Alan Jackson saying, Your Honor, we went through all of this yesterday. Okay. I'm trying to expedite this.
But remember that
do you have an issue with
remember
I would be asking Hank, what's your problem with it? Is it misleading the jury? If it's not misleading the jury, then what's the problem? That's what I would be saying.
That's your oral argument at Sidebar?
That's my oral argument at Sidebar is, am I misleading the jury? For judicial economy, I'm asking him, were you provided a PowerPoint done by Aperture?
Can we stipulate to this for judicial economy? And Hank would say no.
And then I would ask Beverly Canone, what foundation are you looking for?
Well, anything you're about to have him opine on, Mr. Jackson.
I'm literally asking him, you made a PowerPoint, right? Why did you make a PowerPoint? You want him just to say, oh, because you asked me to? It's got to be a little bit more in depth than that. Well, I get that I asked you that, Mr. Dr. Renschler, but were you provided? What materials were you provided? Again, didn't we already go through this?
But remember yesterday, Hank got up there and had, outside the presence of the jury, a bitch fit about the defense led this witness, Dr. La Brasada, to questions about her CV. Yeah, dude, that's what happens.
Yeah,
for
well, because
judicial economy.
they didn't. But guess what? He didn't really lead that in so much that he designed and made questions so that she, by answering it, would cover
Laid
certain
foundation.
things.
Yeah, and it lays
That's called
foundation.
veteran. That's being a veteran attorney.
Mhm. No one wants to bore the jury with that stuff, but you have to. It's a proper way of doing lawyering 101. But I just love that Hank messed up so bad yesterday that he forgot lawyering 101, which is always know the answer to the question you ask before you ask it. Basic thing. And he asked her a question and effed up. Okay, we're back.
Well, Hank's also opened every single door, and Bev's just erroneously not allowed it. He's opened every door.
May I?
Yes.
Did you undertake to review analysis and testing that was done by Aperture as reflected in the PowerPoint that you reviewed, as well as the report that you received?
I did, yes.
Did ARCA, yourself included, undertake testing based on your review of the testing by Aperture?
We did, yes, sir.
Okay. Tell me, what was the biomechanical analysis, that's the second point on your PowerPoint, what was the biomechanical analysis that was undertaken after you reviewed the Aperture reports and Aperture testing? What did you undertake to do?
So I touched on this yesterday a little bit. A biomechanical analysis,
We know.
there's certain steps that you have to do to actually perform a biomechanical analysis. First of all, you have to determine what the injuries are. What are the diagnosed injuries? Second, you have to determine what happened to the individual. So in this case, what would have happened to Mr. O'Keefe? His kinematics, how would his body move? Was it contacted by anything? Was it contacted by the Lexus? If so, what forces were produced on the arm, on his body? Were they sufficient to cause the injuries that he sustained? And in this case, it's a little more involved. We have, was he hit by the car? What happened after that? Did he somehow move into the yard? And then did something happen in the yard to actually cause the skull fracture? So in order to determine if that's what actually occurred in this case, you have to look at each of those three separate events. And you have to evaluate that from a biomechanical analysis by looking at the force, looking at the kinematics, looking at a human tolerance, and determining or attempting to determine what happened. Now, if you try to determine what happened, not only do you have to prove that that was the case and the facts support that that's what occurred, you also have to eliminate all other possibilities. Because if you're saying this is how it happened, not only do you have to show that that's true.
So next question, and I'm going to strike that. Next
Oh,
question.
Is there an element of differential diagnosis that goes into biomechanical analysis?
There is, absolutely.
Explain that for us, please.
Let me demonstrate. So there are several peer-reviewed articles that I reference.
Is this slide number 2, by the way?
This is slide number 2.
Thank you.
Correct. This is injury reconstruction biomechanical analysis of accidental injury. And that sets forth the methodology that I just described. It's well written about, well reviewed in peer-reviewed articles. This is the method you need. If you're going to opine on biomechanics, this is the method you need to do, the steps you need to go through in order to provide an actual opinion.
And describe that method just a little bit further. Does that include testing?
That includes testing.
Does that include both lab testing and field testing if it's possible?
Absolutely, yes.
Explain that.
In fact, let me explain. Let me get through here. You know, I just had a couple examples here. This third slide, another reference about biomechanical analysis. Again, it's all throughout the literature, very well established how to do this. Now, it's all based on the scientific method, okay? And the scientific method, which, it was really established back in the 1620s, but this tells you how to do a proper scientific analysis. So you have an observation, you observe something. So in this case, you might say, all right, there's superficial abrasions to Mr. Keefe's arm, and there's a shattered taillight. Are those two things related? Well, the first thing you do is you research the topic area. You look through the literature, you find or look for any examples of that happening. You see if there's any reports or peer-reviewed articles written about this very occurrence. Can you actually demonstrate that if your arm hit the taillight would shatter and cause those abrasions? If this occurs or is a common occurrence, it should be in the literature. You should be able to find information about it. Then you form a hypothesis. Either you say, I think this injury is related to hitting the taillight, or it's not. Whichever one you choose, that's where you then start to go into your experimentation. You have to develop tests to get data to actually back up your hypotheses. So if I said, well, I think the injury is related to it, what would you do? You would go and you would test it. You would get an arm. In this case, we got a hybrid 3 dummy arm, and we got an exemplar vehicle, and we hit the vehicle with the arm. Or we hit the arm with the vehicle, we ran into it, to determine what's going to happen when that occurs. Do we get the right circumstances, the right loading to actually occur in that case?
Load.
So this, and then you go back and you analyze that. And if your results don't match up with your hypothesis, you have to reevaluate. You have to go back and see if we don't get that type of injury, if we don't get the kinematics or the force associated with what we see, you have to reevaluate if your hypothesis or what you think happened is actually true or not. So you have to continuously go through this process. And that's what experts do. That's how you perform an analysis. And that's what's important. I have 3 kids. I have a 9-year-old who's actually.
So I'm going to ask you to wait for the next question.
Okay, sure.
Was there an example that you could use of sort of a real-world example that you might want to use to explain some or part of the scientific method?
There is, yeah, and I would like to explain an example of what's important with that. So I was going to say I have 3 kids, a 9-year-old who's actually turning 10 today. Happy birthday, Kai. And I have 2 older ones.
All right, we're gonna stop this. Another example.
Go ahead. Less editorializing.
Minus all the personal.
I'm sorry, Your Honors.
Go ahead.
Details matter, okay? Details in an investigation matter, and details matter here. You need details. You have to explain how things happen, okay? As an expert, I can't come in and just say.
Sustained. It needs to be more question and answer.
Why do details matter?
Because your opinions have to be based on the facts and the evidence.
Why is that?
Because that's what determines your conclusions. I can't come in and say, I think.
Next question.
What if you don't have all the details and facts?
If you don't have details, if you haven't performed a proper analysis, then you can't come to a conclusion that something happened. You can't depend just on your experience. You have to have the analysis, the evidence, and the details to come to a conclusion in a case.
How do you best get details to come to a conclusion in a case?
You need research. You need peer-reviewed articles. You need evidence. You perform testing. You have to demonstrate what you think happened is A, possible, and B, actually did occur. And in order to do that, you need hard evidence to demonstrate that that's what actually occurred in this case.
Do you get that through both lab testing and field testing?
The form. Ask it differently, Mr. Jackson.
Can you get that in lab testing?
Absolutely.
Can you get that in field testing?
You can get that in field testing as well, yes.
Are those integral to an analysis?
They are. If you don't have any other evidence, if you don't have research, if you don't have peer-reviewed articles showing or demonstrating what happens, you have to formulate, you have to get that evidence. And the way to do that is through field testing, if you have no other evidence and no other source of information to provide that type of evidence.
Let's go to the next slide. Did you undertake, and this is a placeholder, did
Yes.
you undertake the scientific method in this case?
I did, yes.
What was the hypothesis of the incident that you utilized in furthering your analysis?
So the first step, the first part of this event is contact between Mr. O'Keefe's arm and the vehicle.
Could you describe for the jurors what hypothesis you used based on your review of the information you got from Aperture?
Sure. So the hypothesis that I looked at, Aperture, their testing and report indicates that Mr. O'Keefe had his arm out at a 90-degree angle.
Sustained.
What do you see? By the way, where are these from? These two slides.
These two slides are from the PowerPoint presentation that Aperture provided.
All right. So you didn't create these?
I did not, no, sir.
Describe the angle of the arm in the left photograph with the drinking glass in the hand.
So the angle of that arm is approximately 90 degrees. The other photographs in the PowerPoint demonstrate that for someone the same height as Mr. O'Keefe, the arm would be about 90 degrees with an individual standing erect. That's what was demonstrated in their PowerPoint.
Do you note anything in their PowerPoint, the Aperture PowerPoint, related to the clothing worn in that left photograph?
Yes, they have the surrogates wearing a hoodie or a sweatshirt, which is the exact same type and brand that Mr. O'Keefe was found wearing at the time of the incident.
Did that play a part in your overall analysis, the fact that the individual, the surrogate, as you use the name, was adorned with the same type of sweatshirt that was found on Mr. O'Keefe?
It did, yes. I mean, that's one of the details that we have to look at. Details matter, so we look at the clothing that was worn and the evidence found with respect to that actual sweatshirt.
I'd like to stay with that for a second. Why is that important? Why would the clothing matter?
Well, because that tells us, that gives us evidence of what may or may not have occurred. Mr. O'Keefe was wearing this sweatshirt when the time of this alleged incident occurred. So if there is contact between his sweatshirt and that rear vehicle, the taillight from the Lexus, there would likely be evidence of that. And we have to look at that sweatshirt to see the condition of that sweatshirt, if there's evidence on that sweatshirt, and be able to pair that or match that up to with what happened on the vehicle.
Is that part of a normal biomechanical analysis to evaluate clothing of the body as well?
Absolutely, especially when you look at automobile pedestrian impacts.
Why?
Because the clothing tells you or can tell you how the impact occurred, where contact occurred between an individual and the vehicle, what part of the vehicle, what part of the individual. So it either may or it may not, but it can give you very important clues about what may have occurred during the incident.
Is that part of the normal methodology that's utilized in the field of biomechanical analysis, especially as it relates to pedestrian motor vehicle incidents?
It absolutely is, yes. Look at the damage to the clothing. Look if you compare it up to the vehicle, to the ground, to other sources. It's another tool, another detail, and part of the evidence that allows you to try and determine what occurred.
Do you have experience in reviewing clothing of individuals that may have been involved in vehicle pedestrian incidents?
I do, yes.
How often has that played a part in your biomechanical analysis and the methodology that you employ?
It happens quite often when we look at automobile pedestrian impacts. That's really one of the steps that you need to do. You need to look at the clothing, you need to look at that evidence and see if that matches up with any other evidence in the case.
Would it be a proper methodology to just ignore the clothing in a vehicle pedestrian incident?
It would be, yes. I mean, it's really one of the first things you should do.
I'm sorry, my question was, would it be proper if you just wholly ignored it?
No, it would be improper. It would not be proper. It would be improper if you just ignored it.
Getting back to the slide at hand, and we're on slide, just to stay coordinated, is this slide 7?
That is correct, yes.
Okay. You've talked about the left photograph. What is the right, the short video?
So this short video is what I refer to as the paint transfer test that was performed by Aperture. And what they did was take a surrogate the same approximate height and weight as Mr. O'Keefe and had him stand behind a subject, an exemplar Lexus, the same year, make, and model. And they put paint on the rear taillight cover on the fender, and then they backed it in to the surrogate's arm, and the the reason for this is they attempted to show that where the paint contacts the arm, that it's the same area where the superficial abrasions were on Mr. O'Keefe's arm.
Did you utilize these photographs and videos from the Aperture report in conducting and building the field testing and or the lab testing that you ultimately undertook?
I did, yes, sir.
Can we go to the next slide, please? What's depicted in this slide?
So this is from the Aperture report, and the third conclusion is that the location and orientation of the lacerations on John O'Keefe's right forearm and arm are consistent with the geometry and the orientation of the right taillight on the Reed 2021 Lexus LX57.
How did you interpret the phrase geometry?
To me, geometry just means shape. So the way I interpreted this is the one test that was performed with respect to the taillight. This is the only test I saw that Aperture performed involving the taillight and the arm, is that with this paint transfer test, they concluded that, again, the area where the paint was transferred onto the arm is consistent, the same shape and orientation as apparently the lacerations found on Mr. O'Keefe's forearm.
Did this test, in your opinion,
Make it up.
establish force multipliers that were exerted on the taillight?
It has nothing to do with force. It doesn't describe the force exerted on the taillight or on the arm. It doesn't describe how the arm would have moved as it hit the taillight. It doesn't describe how the taillight would fracture. It doesn't describe how you would actually get the lacerations on the arm. Again, all this does is generally, and I made an error there. This report, and you can see the slide says laceration. Mr. O'Keefe did not have lacerations on his arm.
What did he have?
He was diagnosed with superficial
Is
abrasions.
there a difference between a laceration and an abrasion?
There's a distinct difference, both biomechanically and medically, yes.
Is that an important distinction?
That is.
Why?
The first step of the biomechanical analysis is identify the injuries, and you have to take the diagnosed injuries identified by a medical doctor. So it's superficial abrasions. To put lacerations on, that's simply incorrect.
Strike.
So I strike the end of that.
Would you describe the injuries on Mr. O'Keefe's arm as lacerations?
No,
Would they be more properly described in another way?
it would be, yes.
What's that other way?
So they've been diagnosed as superficial abrasions. An abrasion occurs when there's rubbing or scraping of the skin, and it just rubs away the top layer, the epidermis of the skin. Now, a laceration is a jagged ripping or tearing of the skin, which gets down through the epidermis into the dermis. So abrasions take much less force, they're less severe than what a laceration actually is.
In a biomechanical analysis, if it's done properly, is it is it important to get the proper injury to the body as a foundation to the entire analysis?
That's core to the analysis, because you're trying to determine how an injury occurred. You have to know what that injury is. You have to have the correct injury to be able to evaluate it.
Let's go to the next slide. Bush. This is a placeholder. I want to ask you a little bit while this is up. We can turn the lights up.
Turn the lights up!
First step in the analysis. What is the first step of the analysis after you determine the injuries, the type of injury?
So in this step, after you determine the injury, what we want to do is we want to look at the physical evidence. So we have the abrasions on Mr. O'Keefe's arm, and we have the sweatshirt that he was wearing at the time. So the first step in any investigation is to determine, does the evidence from the arm match up to the evidence on the sweatshirt?
Did you undertake that analysis?
I did, yes.
Is that indicated in a slide a little bit later on in your PowerPoint?
It is, yes, sir.
Okay. Let's go to the next slide, please. What are we looking at in this slide?
So this explains the injuries. And this is from on the left side, that is the diagnoses from the autopsy. The right side is from the hospital. And you can see it says blunt impact injuries of head and extremities, abrasions and lacerations. The laceration is on the back of the skull. on the back of the head where the occipital skull fracture is. When you look at the extremities, everywhere where it talks about the extremities, it's superficial abrasions. So the first step in a biomechanical analysis, you review the medical records, determine exactly what the injuries are. And you can see there's a picture of the actual abrasions. Those are the documented injuries or abrasions to Mr. O'Keefe's right arm.
Are these acceptable sources? Well, let me ask you this. What are the sources that are reflected on this slide that you referred to or you relied on in coming to your opinions and conclusions regarding Mr. O'Keefe's injuries to his right arm?
Again, on the left side is from the autopsy report from the medical examiner, and then the right side is actually from the Good Samaritan hospital where Mr. O'Keefe was taken.
Are autopsy records, hospital records, medical records acceptable sources for a biomechanist to rely on in determining or coming to opinions and conclusions?
They are the sources you go to determine what the injuries are. Yes.
Did you see? You reviewed the entirety of the medical records as well as the entirety of the medical examiner's file. Is that right?
I did. Yes, sir.
Did you see reference to any fractures that were noted on Mr. O'Keefe's right arm, either his arm, his forearm, or his hand?
No, there were no diagnosed or references to fractures on any part of his right arm or hand.
I'm going to ask Mr. Wolk to display a couple of exhibits, the x-rays.
Okay.
So he's going to take over the TV screen.
Sure.
If that's okay, Your Honor?
Yes.
This is an exhibit that was marked yesterday. I want to say 226. I may be wrong, Your Honor. I'll get the right nomenclature in just a second. This is one of the exhibits, one of three exhibits that was introduced yesterday. Do you recognize what's depicted on this?
That's the X-ray of Mr. O'Keefe's right hand taken January 31st, I believe.
Did you review this in furtherance of your analysis?
I did, yes, sir.
Was it part of the medical record? Medical records or AE's records?
It was a series of the X-rays. Yes, was attached. It was part of the medical records that were provided to me and that I reviewed in this matter.
Thank you. Just for the record, so I can clarify, this is Exhibit 229A, as in apple. Do you see? Have you looked at X-rays before?
I have, yes.
Have you interpreted X-rays in furtherance of your analyses in years past?
I have during my biomechanical analysis, yes.
Are you trained to look at X-rays and determine whether there are fractures, hairline fractures, broken bones, things of that nature?
I've been doing this for 20 years. In graduate school, I worked with surgeons and doctors to look at X-rays.
Is that part of the normal methodology that biomechanists undertake in furtherance of injury analysis?
It is part of what we normally do, yes, sir.
Would it be an important part of a biomechanist's ultimate analysis and conclusions as it relates to an injury analysis?
It would be, and especially in this case, if we're talking about impact to the arm and the hand, very important to determine, as I said, not only what the actual injuries are, but what injuries did not occur.
Would it be appropriate to come to any opinions and conclusions in an injury analysis if you were to ignore X-rays, if they existed?
No. If X-rays exist, you need to review them. You need to determine what they represent and what injuries either did or didn't occur. You absolutely need to look at them.
Do you see any injuries represented or any defects represented in this X-ray of Mr. O'Keefe's right hand?
I do not, no, sir.
Can you describe what you do see or what you would expect to see if there were injuries, broken bones, torn ligaments, things of that nature, swelling? What would you expect to see?
You could actually see the fracture lines on the bones. They are evident along the hands or along the ulna and the radius. Any dislocations you see, there would be a difference in the space at the joints between the bones. Dislocation, then there would be increased space or even a decreased space if there's compression of the joints, the interphalangeal joints, the metacarpophalangeal joints, the wrist joint, there's no indication on these x-rays of any fractures or any trauma or any type of injury to the bones or the joints.
Can we go to 229B as in Bravo with the court's permission?
Yes.
You
see what's depicted in this photograph?
I can, yes, sir.
What is this?
So this is a x-ray. The forearm shows the ulna and the radius, which are the two bones in the forearm.
Do you see any defects, injury, trauma to these bones or anything associated with those bones?
I do not. And when you're viewing this on the software to look at the x-rays, you can actually adjust the contrast. So you can adjust the brightness and the darkness, and it allows you to go through the whole range to better evaluate whether there are any fractures. This is a little bright, so when you're looking at this, you would actually decrease the contrast a little bit.
In terms of your review of this particular photograph, what did you note in terms of trauma or injuries at all?
I did not note any indication or any signs of trauma or injury to the forearm or to the wrist in this case.
If we could go to 229C as in Charlie, what are we looking at in this photograph?
This is the right humerus, the right upper bone of Mr. O'Keefe's right arm.
Do you notice, or did you note, did you review this in furtherance of your analysis?
I did, yes, sir.
Did you note any defects, trauma, injuries at all with regard to the bone is the
humerus.
The humerus?
I did not, no, sir.
What about the joints associated with the humerus, top or bottom?
I did not note any injuries or damage to either the elbow or the shoulder joint either.
What is your opinion and conclusion, having reviewed all three of these x-rays, with regard to the condition of Mr. O'Keefe's right arm, starting from the arm, the forearm, and the bones in the hand?
There's no indication of any type of acute injury from the x-ray to Mr. O'Keefe's right arm, either his hand, his forearm, or his upper arm.
Thank you. We can switch that back. And if we can go back to your PowerPoint. Can we go to the next slide, please?
Maybe. Let me see if I can start back on it here. Okay, there we go.
What are we looking at in this slide?
So again, this is the hoodie or sweatshirt that Mr. O'Keefe had on at the time of this alleged incident.
Did you consider these photographs in conducting your injury causation analysis?
I did, yes, sir.
What role did these photographs of Mr. O'Keefe's hoodie play in your injury causation analysis?
So this shows the hoodie, and it was inspected by the police department, and it was noted, as you can see on the right sleeve by the triangles, there were 9 different punctures or holes noted in the sleeve of the sweatshirt.
Can we go to the next slide, please? What are we looking at in these series of photos?
So let's come to Sidebar for a minute, and Mr. Jackson, bring your PowerPoint, please.
Bev, what's the problem? Bev, what's the problem? So he is going to line up, and then this is where the objections are coming in, because he is not a seamstress. He does not know fabric, and if it is tight, loose, brand new, it would have just, like blah, blah, blah. Well, last trial, here's a little pic for you. This is transparency paper, and when you put over the marks of like his abrasions, superficial, and you line them up, you can line them up, and it's like
Either way you slice and dice it. They align. Like that's his elbow. And then look at wherever all that stuff is. I don't know if you guys can, if you're able to see it like that, but it's exactly where all the marks are. So, whatevs. The puncture holes. So, that's what that is. That's what he's going to do with all parts of the sweatshirt. Well, Bev is just, whatever. I want to show you guys something. This is what I was talking about yesterday. Okay. Right here. Let's see how it says 170. This is John's health data, and it goes from 12:11 until 12:21 when it's counting John's steps. And so what I'm saying is that out of the 170, that did any of his initial stops when he got out of the vehicle, if Waze is off by 3 minutes, it would have some of the steps in there. Because if you take 12:23, 12:24, you subtract 3 minutes, you're getting down to 12:21. And so I think some of the 170 steps takes into account the steps leaving Waterfall, and then see how it's not within the 10-minute mark. It's only 9. So if you're within it, if you get out of a vehicle and you start walking, it's going to count it with, it's not going to break up the trip. And then John then goes from 12:25 until 12:31 without taking any steps. And then his 12:31, and it's the, as you can see here, (12:31 to 12:32), John's health data, 36 steps. Because if he would have gotten out of the vehicle when all of those people were there, Ryan Nagels of the worlds, if he would have waited till and is talking to Karen for 5 minutes in the car and then gets out, everybody would have seen him getting out. So there's just no way that the 12:31 in, I think it's like 52 seconds to 12:31 or 12:32 in like 9 seconds. Those 36 steps are taken by somebody else with his phone, because I believe that he opened up the door to the garage and the dog was in there because he opened up the wrong door. And chances are it was, if the lights weren't on in that garage and it was all dark, the dog got startled and then lunged right at John. And that's why he doesn't have any movement from 12:25 to 12:31. That's my take. And then if you go off of when Jen starts going crazy with her, let's see, right here, between 12:35 and 12:45, 148 steps. But before that, remember I told you she's like not moving at all. I believe that she did talk to John at 12:28. Oh my God, actually, holy ballsack. Oh my God. Who answered John's, holy shit, I just had an aha moment. Who answered John's phone at 12:29? Ooh. Oh shit. Oh my God. This is, oh fucky. That's why it had to be such a big deal. They lied about that. Oh, snappy, snappy. John would have been unconscious immediately when he went down. Meaning that he was either oh boy. This is why non-lawyer streams are the best. Holy sack. Okay. Okay. Whew. Let me see when she's doing her stupid fucking text. Where's your stupid ass, Jen? Hold on 1 second. Let me pull this up. Jen's stupid ass. Come on. Okay, great. Not that one. This one. Okay. You deleting hoe. Okay.
No one's going to stop her from telling us, you guys. She's going to tell us.
I'm going to tell. I'm going to tell. Okay. One step, 4 steps, 12:25, 12:35, no steps. Oh my God. 12:25, no steps. Twelve.
That was real time. Lana brains at work.
Right?
Behind the scenes. Mm-hmm. This is all in real time, you guys.
1 step, 4 steps, no steps, 10 straight minutes at 12:25 and 16 seconds. When she's saying she's walking over and looking. She's not, because she would have taken 4 steps out the go. Hold on. Oh my God. If I'm sitting on a couch right there, 1, 2, 3, 4. There's a bench right there. I saw him walk up to the door. See that bench right there? You could be sitting right here on that bench for 10 straight minutes. John's laying right here, knocked out. You're sitting right there on that bench.
We're about to be back. Pontificate about it.
Oh my God. Okay.
Jurors, I apologize that took so long, but it was necessary to do rather than sending you out, so. Sure. Thank you. Tori, can you give me a couple of these?
I was asking Tori.
Okay.
Bring it, Alan.
Dr. Renschler, my eyes aren't good enough to see the upper right-hand corner. What slide number is this?
Number 12.
Number 12, thank you. Did you look at these photographs and consider these photographs in furtherance of your ultimate conclusion?
I did, yes, sir.
Can we move to slide 13, please? Did you also look at and consider these photographs in coming to your ultimate conclusion?
I did, yes.
Can we move to slide 14, please? Did you look at and consider these photographs in coming to your conclusions and opinions regarding this case?
Yes, sir.
Can you move from slide 14 over to slide 18, please?
Can I switch through real quick?
Sure.
Yep. So we 18.
Let's go to 18. What are we looking at in slide 18?
So this is Mr. O'Keefe's right arm at autopsy, and they're holding up a ruler to demonstrate the size and dimensions of the abrasions.
And what are the yellow indicators?
Those are indicators I added based on the length of the ruler to show the approximate size, length, and width of those abrasions.
Was it important in your biomechanical analysis to measure and denote all the injuries?
It was, yes.
Did you actually count the number of injuries on Mr. O'Keefe's arm?
I did, yes.
How many injuries did he have? How many distinct and separate injuries did Mr. O'Keefe's arm present?
Conservatively, I counted 36 different superficial abrasions on his right arm.
And did you go through all the photographs in an effort to count and distinguish one abrasion and one defect on his skin from another?
I did, yes, sir.
And you said conservatively 36 separate abrasions, correct?
That's correct.
What does that mean in terms of the mechanism that you would expect to cause that abrasion?
Well, you need 36 different points of contact with to get through the sweatshirt and get to the skin to actually cause abrasion to the skin. 36 different separate points of contact to the skin.
How many defects, remind us, how many defects were noted by the crime lab in Mr. O'Keefe's right sleeve?
9 defects.
Can you scroll to slide 22 quickly, please? What is this?
This is a slide, again, from Aperture from their PowerPoint. It's the only slide, the only photo, the only indication of the hoodie that I found in their analysis. And it also has pictures showing, looks like they try to line up the top of that taillight cover.
Sustained.
Do you see there's some sort of marking on that lower left photograph with some yellow lines?
I do, yes.
How did you analyze that marking?
I analyzed that. It goes through the part of the taillight cover and then goes through part of the upper arm of the surrogate.
And there's a parallel line to it a little bit in a V shape. There's a parallel line below it. How did you analyze that line?
I analyzed that as apparently showing that the area of the taillight.
So not apparently, what did you
How did you
analyze?
interpret
Sure.
that?
I interpreted that represents that area of the taillight corresponds to the area of the upper arm.
And there's a red dotted line around the taillight, correct?
Correct.
How did you interpret what that represents?
That was the part of the taillight that fractured.
Did you put any of these lines on there, or are these all from aperture?
These are all from aperture. I did not put any of those on there.
You see the small, it's horizontal, I'm sorry, it's vertical photograph of Mr. O'Keefe's arm?
I do, yes.
Did you note anywhere in the aperture report a denotation of the number of abrasions, counting the number of abrasions on Mr. O'Keefe's arm?
There's no denotation, no indication that the number of abrasions were ever counted. No, sir.
Ultimately, based on your review of and all of your testing, did you come to an opinion or a conclusion as to whether or not the abrasions on Mr. O'Keefe's arm are consistent with striking the right rear taillight of the Lexus?
I did, yes.
And what is that conclusion?
That they're inconsistent with striking the taillight or being produced as a result of contact with the taillight.
Why did you come to that conclusion?
There's a number of reasons that I came to. First of all, the abrasions, the numbers don't correspond to the number of holes or...
Sustained.
Did you consider, without counting the number of abrasions and the number of holes, did you consider the abrasions?
I did, yes.
Did you consider the sweatshirt?
I did.
Was that an important part of your analysis?
It was, yes.
What else did you consider?
I considered that it was not possible to line up 36 different abrasions with
So I'm going to strike that answer, ask it differently.
Your Honor, if he could finish his answer. He was about to say contact with the taillight.
Yeah, so ask it differently, Mr. Jackson.
Sure. What did the 36 abrasions, conservatively, and their interaction with the taillight have to do with your ultimate opinion and conclusion?
Well, that you have to, if those abrasions came from contact with the taillight, you have to be able to correlate them and line them up with contact, 36 different contacts from the taillight.
And ultimately, based on your understanding of Aperture's review and the photographs that you saw, you were presuming, based on Aperture's testing, that Mr. O'Keefe was wearing that hoodie. Is that correct?
Sustained.
What was the condition? Let me ask it this way. There's a photograph in the Aperture report that we're looking at with blue paint on an arm, right?
Correct.
Is that your understanding, or did you test that Mr. O'Keefe could have been hit wearing short sleeves?
No.
What did you test? What was your presumption and assumption in your testing?
That he was wearing the hoodie that was found on him at the time.
With the 9 holes in the right sleeve?
With the 9 holes in the right sleeve.
Watch the form of the question, Mr. Jackson.
Sure. Let's go to the next slide, please. What is this?
These are the top two and bottom right slide are from the Aperture PowerPoint.
How did you interpret the two photographs on the right, the parallel lines and the red lines in that slide?
The parallel lines correspond to an area of the fractured tail light, and then the red dotted line corresponds to an area of abrasions on Mr. O'Keefe's upper arm, and there's a red arrow pointing to part of the fractured tail light.
Can we go to the next slide, please? What are we looking at in this slide?
Again, this is the paint test. This is the only test that was conducted by Aperture to look at the tail light and the arm in this case, and the interaction between the two.
Did you note whether in all of Aperture's data that you reviewed, whether or not there was any measurements to determine whether the abrasions were consistent with contact with the Lexus?
I did. There were no measurements at all taken with respect to that test. No measurements with respect to where the contact happened on the car or on the arm itself. There was no indication of where that blue paint extended on the surrogate's arm, say from the wrist up to where the laceration or the abrasions would have occurred.
Is that important?
It's very important.
Why?
Because you can't say that the area where the blue paint is corresponds to the area of the abrasions if you don't take measurements. If you just eyeball it, all you can say is by eyeballing it, it looks approximately the same. But that's not scientific. You can't come to an actual conclusion that where that paint covers the arm is where those abrasions actually were. They could lie outside, they could lie forward, they could lie above that painted area. You can't say with any scientific certainty that that area of paint corresponds to where the abrasions are.
In this motion video and the still photograph to the left in slide 24, is that what we're on, 24?
We are, yes, sir.
What did you note with regard to the positioning of the surrogate's arm? I think that's Mr. Welcher. As it relates to the taillight and the back of the SUV.
Yes, the positioning of the arm in the photographs as well as the one test that was performed, the arm is approximately 90 degrees, level in line with the rear taillight of the vehicle.
Did you seek to do any testing approximating the positioning of the arm as you saw it, as you interpreted it in the Aperture data?
I did, yes, sir.
What were you seeking to determine when you did your testing?
Well, if we want to determine whether the orientation and the position of the abrasions on the arm correspond to the tail light, you have to have the arm in the position that you claim it struck the tail light and then look at the abrasions. Because if you're looking at orientation and the direction of the abrasions, you can't look at how they exist with the arm. The only pictures of the arm of the abrasions are with Mr. O'Keefe's arm extended. But that's not how he would have had it according to the test. It would have been at a 90-degree angle.
Boom.
Renschler, were there any peer-reviewed articles cited in connection with Aperture's paint transfer test?
I did not see, I was not provided a single peer-reviewed article with respect to the paint test or any indication of any test or article looking at arm contact with the vehicle or a taillight cover.
Can we go to slide 25? What are we looking at in this slide?
So in this slide, the picture on the far left is the photographs provided from the autopsy in hospital with Mr. O'Keefe's right arm fully extended. Again, those are the only photographs we have.
What the photograph in the middle and to the far right?
In the middle and the far right, what I did was actually take that arm and then rotate the forearm to put it in a position that it would be in, as demonstrated by the paint test, with the arm at approximately 90 degrees.
What was the import of this undertaking?
Well, if you look at the paint test and the way the arm's at 90 degrees and having the car come and essentially contact and push the arm out of the way, that's going to give you or tell you the directionality or the direction of the abrasions. Because if you have your arm at a right angle and the vehicle comes and pushes and slides against it on that forearm, you would expect those abrasions to be horizontal, to be in line with that forearm.
Are they?
They're not. You can see some of them are vertical, some of them are angled, some of them it's hard to tell what the directionality is. But if your arm, again, is being struck and pushed this way, as it's pushed and as the car goes by, if this would occur in this manner, you would expect those abrasions to be horizontal in the direction that the vehicle is actually traveling.
When you say horizontal, do you mean horizontal from the elbow to the wrist?
Correct, or parallel, yes, with the forearm.
Can we go to slide 26, please? This is yet again the same video that we saw earlier.
That is correct. This is the paint test video, yes.
And what has to happen in order for the paint in this test to reach the upper forearm?
Well, in this case, to reach the upper forearm, there has to be contact between the forearm and the taillight cover.
Can we go to the next slide, please? What is this slide showing?
Again, this shows, you can see on the right, I added arrows to kind of show the directionality of the different abrasions. And on the forearm, they simply do not line up with the type of kinematics or the type of motion shown in the paint test. Again, of the arm getting pushed out of the way and the car traveling past. If there were going to be abrasions from the fractured glass as it moves along, again, it would be lengthwise parallel to the forearm.
If the arm was positioned as it was indicated in the paint test done by Aperture, would you expect to see this pattern of injuries on Mr. O'Keefe's arm if, in fact, it contacted the taillight and if, in fact, it was abraded based on the taillight?
You would not. You can't get, for instance, horizontal abrasions on the upper arm and somehow get vertical and angled abrasions on the forearm. The kinematics don't work out to actually produce those types of injuries.
Can we go to the next slide, please? What are we looking at in this slide?
So again, this is the paint transfer test, and it demonstrates there were no measurements taken, so we don't know the exact size or location of that paint or of the lacerations. And you can see the photograph on the right basically shows that after doing the test, a picture of the right arm was put next to it and basically eyeballed to say it's the same, well, it's only approximately the same area.
So I'm going to strike that. So next question.
Do you see any measurements, any tape measures, any laser measuring equipment, anything like that in that right photograph?
Nothing, no types of measurements whatsoever.
Can we go to the next slide, please? This is, on the left, the same video that we've seen several times, correct?
That's correct.
What are we looking at on the photograph on the right?
So on the right, it is the video of this test taken from the side of the vehicle.
Did you notice anything of note in this angle of the paint transfer test?
I did. I slowed this video down, and so as you can see, as it starts out, and you'll see the vehicle starts to slowly back. So there was no photographs showing the position of the arm in the back of the car. The video is from the side, and the top video, you can't tell where the arm is positioned against the tailgate. But whatever positions it's at, you can see as the car backs up here, look at the elbow and the upper arm. If the car backed directly in this direction, there would be no contact with that elbow or the upper arm. And remember, this test is to show where the paint would transfer and if that correlates to the lacerations.
You mean before we start the video, when you say there would be no contact with the elbow or the upper arm, you mean the biceps area and from the elbow up?
That's correct.
Is that based on the photograph on the right and the positioning of the surrogate?
Exactly. You can see right now, if the car just backed directly straight back, it would not contact the elbow or the upper arm.
Before you play the video, what did you note when the car from the angle to the right of the video on the right? What did you note as the car, just before the car starts to make contact with the surrogate? What did you note?
So in order to get that pattern on the arm, right as the car contacts the arm, the surrogate pushes his elbow forward, leans into the car against the light, and then rolls off.
Can you play that for us, please? Did you see what you were describing in that video?
I did, and I can slow it down. So you can see, even at this point, as the car approaches, it would not contact the elbow or the biceps. So as it comes in, watch the elbow all of a sudden shoot in. Surrogate turns his arm in and then leans against the light cover. So this is not indicative of someone standing there and having a car back into their arm. In order to get that pattern of pain on the arm, someone would have to stand there, and as the car approached and contacted their arm, they would have to actually push their arm forward and lean into it to get that pain pattern.
Is that, in your view, proper scientific testing?
Sustained.
Let's move to the next slide, please. What is this?
And so this is that same event, and you can see I slowed it down even more just so you can see the actual movement of the elbow and the upper arm to get that pattern.
Thank you. Can we move to the next slide, please? This is slide 30. And let's go to 31.
Yeah, this is 31.
I'm sorry, 31. What conclusions or opinions did you reach or could you reach after reviewing the totality of the results of the paint transfer test?
The paint transfer test, all it can show is the approximate of where the arm was covered in paint as the surrogate jammed his elbow in and rolled against the taillight cover. So it tells us nothing about what may have actually occurred, how the lacerations were actually, or the abrasions were produced. It doesn't talk about the kinematics of the arm to actually cause those abrasions. All it does is just say, under this specific condition, if someone was to stand there and then shoot your elbow forward and lean in, you would get paint on this approximate part of the arm, because we don't even have any measurements for it. That's the only thing that test demonstrates, and that's the only test that was conducted to look at the interaction between the arm and the Lexus in this case.
Did you reach any opinions and conclusions regarding whether the physical evidence is consistent or inconsistent with the injuries to Mr. O'Keefe's right arm?
I did, yes.
And what's the basis?
The basis is looking at the number of laceration or the number of abrasions on the arm, as well as the orientation and direction of those abrasions. And they don't correspond to how the arm would interact with the vehicle if it was at a right angle and struck by the rear of that vehicle.
Do you hold that opinion to a reasonable degree of scientific certainty, Doctor?
I do, yes, sir.
Can we move to the next slide, please? Actually, slide 33. If I may have just a moment, Your Honor.
Yes.
Did any of the testing that you saw in terms of the paint transfer test or any other testing that you saw included in the Aperture report and the Aperture PowerPoint presentation indicate that there was any consistency or any results that were consistent with Mr. O'Keefe's right arm being struck by the taillight, causing 36 plus abrasions to his right arm while wearing the shirt, or the sweatshirt, with 9 holes in it?
That's sustained. You have to ask that differently, Mr. Jackson.
Did you determine, based on the testing by Aperture, whether or not it was consistent, that paint transfer test was consistent with Mr. O'Keefe's arm being damaged by the taillight at speed?
I did.
Okay, and what is that conclusion?
That does not represent that at all. The evidence from that test, again, it's only puts pain on the arm. So in no way does that determine or demonstrate how, if the arm struck the taillight cover, how the taillight cover could shatter, how the movement of the arm could interact with the cover to produce those abrasions.
Did you go, I'm sorry.
There's just no evidence of that. There's no steps taken to demonstrate how, if that's even possible, would that actually occur in a case like that? First, you have to show it's possible. I saw no peer-reviewed articles, no research data, and the only test that was done that links the injuries to the taillight cover is this paint test,
Is that the paint test in which the arm was leaned into the car?
in which the elbow was shot forward and then the arm and upper arm was leaned into and against the cover.
Doctor, did you also go on to further your injury causation analysis by performing impact tests to evaluate the kinematics involved?
I did, yes.
Can you describe that for us, please?
Sure. So one of the steps involved in the biomechanical analysis is the kinematics, the motion. So we need to look at the motion of the arm. If the arm hit the taillight cover fractured, and you got abrasions, you need to be able to show that. You need to look at how the arm would actually move if it was struck by the vehicle. I've seen no peer-reviewed articles or research to demonstrate that. So what you need to do then is do testing to look at how the arm would actually move and whether it's possible to create those conditions to actually get that injury.
Did you use an ATD hybrid 3 arm for testing?
We did, yes. We used a 50th percentile male ATD hybrid 3 arm.
Is the use of that hybrid 3 arm accepted in your industry in terms of testing?
Yes, it certainly is. As I said yesterday, it's the gold standard for testing. And the arm itself is used just for that very purpose. In fact, there's a number of studies, they use the 50th percentile arm to look at airbag deployment. One of the issues with airbags for the driver is it comes out of the hub of the steering wheel. So if you're steering and you're turning your car and you hit something and the airbag goes off, what happens? It blows right into your forearm, and it can actually cause fractures. We see that quite often. So they perform testing with the 50th percentile arm to look at the forces and acceleration on the arm as airbags go off. Very similar to if your hand was hit by the back of the arm was hit by the back of the car and propelled forward. That's very similar to having an airbag deploy. Actually, this would probably be more severe. An airbag's almost like a giant pillow enveloping the arm, and here we have an SUV actually contacting the rear of your arm.
Can we go to the next slide, please?
Sure.
This is 35.
Let's see, here's 35.
There we go. Thank you. What's depicted here?
So this was testing done at 15 miles an hour. So this is with the hybrid arm and suspended so that it was actually impacting the right rear of the Lexus as the Lexus was traveling at 15 miles an hour.
Was there acceleration that was noted on the arm, force and acceleration?
There was on both the arm as well as the hand, yes.
What was the result of the damage to the taillight based on this test?
So in this test, there was actually no damage. As you can see, it catches kind of the hand and the forearm. And if you want to describe it as kind of a glancing blow, there was not enough force at 15 miles an hour on this glancing blow to actually fracture the taillight.
Is the position of this arm relative to the SUV consistent or inconsistent with the original spot that the surrogate in the paint test was standing as it related to the SUV?
It's consistent. We lined it up so it's consistent with that original location so that it would not impact the elbow or the upper arm. So at that position, if there's impact to the arm at 15 miles an hour, it doesn't cause the taillight to fracture. And it's also important to look at the kinematics. If you look at the acceleration data below, that hand and arm is accelerated. The hand's accelerated up to the speed of the vehicle in about 2 to 4 milliseconds.
How long does it take to blink your eye?
250 milliseconds. It takes a quarter of a second to blink your eye. So this occurs if your hand's hit at 15 miles an hour by a car, it's going to be accelerated up to the speed of the car about 50 times faster than you can blink.
Can we go to the next slide, please? And what are we looking at in this?
So this is lab testing at 17 miles an hour. So the housing and the cover was basically propelled into the forearm of the dummy at 17 miles an hour.
What was the acceleration that was noted on the arm?
So when you look at the arm, the acceleration here is almost 300 Gs.
What does that mean just to us?
So, 300 G's, if you look at weight, if you say the weight of the arm is 10 pounds, 300 G's means there's 3,000 pounds of force acting on that arm.
Is that enough to break a bone?
It's more than enough to break a bone.
Is that enough to to tear ligaments?
Absolutely, yes.
What about the bones in the hand? Are those stronger or the same resistance as the bones in the forearm? Or are they more delicate?
No, the bones in the hand are, as you can imagine, much weaker because they're much smaller. When you look at the carpal bones, the metacarpal bones, the metacarpal interphalangeal joint, which is basically your knuckles, they are much smaller, and it takes much less force to fracture your hand bones compared to your ulna or your radius.
Let's go to the next slide, please. What are we looking at in this slide?
So this is a 24-mile-an-hour impact with the arm of the dummy contacting the rear, again, tail light. And it shows you the motion, the dummy suspended, shows you the motion of the dummy and, again, the force and acceleration. Now, that right video I put in because that's real-time video. We've been showing the low speed, but look on the right. This is the actual speed at 24 miles an hour. That's what it looks like if you have your hand out and it's struck by an SUV.
Is the arm accelerated in this? Do the same physics apply? Is the arm accelerated up to the speed of the car in milliseconds?
It is, yes. It's all about weight, right? Because you have a 6,000-pound car and you have a 10-pound arm. It's whatever speed that car is going, your arm, your hand, whatever's sticking out there is immediately going to get accelerated up to the speed of that vehicle.
The video on the right is in real time. Like you said, it's sped up in milliseconds. Is that right?
That's correct.
Is the Hybrid 3 that's used in this test, is that suspended from above?
The dummy in this test is suspended from above, yes, like a pendulum, barely touching the ground.
Is the dummy connected to the ground in any way?
No, it's just its feet are barely touching.
What would happen if there were forces applied to that dummy that went perpendicular to the travel of the vehicle? What would happen to the dummy?
The dummy would swing out like a pendulum in that direction.
Based on your review of the test that was done, the 24-mile-an-hour test, were there forces on that dummy that were perpendicular to the car such that the dummy would swing out or be forced out or be propelled out away from the car?
No, there were no forces from the testing, and it's simple physics. Your center of mass of your body is basically at your umbilicus or your belly button. So in order to move the body, you have to apply a force at that part of the body. If your arm's struck, it's not going to move your body appreciably. All it's going to do, your arm's like a moment arm, it's going to spin you around. Could there be some motion forward or backward if you take a step? Possibly. But the center of mass of your body isn't going to move. You have to get struck by the vehicle to have the body actually move in a specific direction.
Can we go to the next slide, please? What is this showing?
So this is a slow-mo of the overhead from the real time. There was a GoPro that was recording that real-time video, and this is a slow motion of that video.
I'd like to ask you a couple of questions. As you see the vehicle contact the arm, what happens to the arm as it's being contacted in those milliseconds where
it gets busted?
24 miles an hour.
Well, the arm's accelerated up and pushed away from the body. So whatever part of your arm or body is contacting the car, that's going to be pushed forward away from the rest of your body. So not only is it loading the arm with an impact force as it strikes the arm and the hand, but then it's actually stressing the joints too. It's like ripping imagine having a car come and 3,000 pounds of force pulling your arm forward at the elbow, at the shoulder joint. It's putting a lot of force and pressure on that appendage.
What's the G-force for the 24-mile-an-hour impact?
G-force, let me see exactly.
Could you pause that video for a second?
Sure.
Because I want to ask you a couple of questions about it as well.
Let me see exactly what that G-force was.
Do you need to refer to something?
Yes, my report.
With the court's permission?
Yes.
Thank you.
I mean, the elbow had been shattered.
So at 24 miles an hour for the arm, the acceleration is 302 Gs. And for the hand, it's about 435 Gs.
Does that translate to over 4,000 pounds of pressure?
Well, for the arm, it's close to 3,000 if you say a 10-pound weight, and for the hand, that can be anywhere from 800 to about 1,600 pounds of force acting just on the hand itself.
Understood. Can you back this up a couple of frames?
Sure.
Pause it where I ask you. One more frame back. One more back. Right there. What's happening physically to the arm, to the right arm at the point of impact?
So there is a force on the hand, on the forearm, where it contacts. Now, your arm just isn't going to hit and the force be distributed evenly across the entire part of the arm. That's not how your arm is actually articulated. Even if it was, again, that's similar to an airbag deployment, where at these levels you would get fractures. But if it hits the hand, now, if Mr. O'Keefe's holding a glass at the time of this impact, think about that. What happens is you're holding a glass. It exposes the knuckles. So if you're holding a glass and your arm's at a 90-degree angle and the car comes back and hits your hand, it's going to strike right on the knuckles. The force is going to be applied right at that joint. And then it's going to likely hit along the forearm back near the elbow.
What's the shape of that arm in this still photograph?
Well, it's somewhat of an abnormal shape because the arm should be level with the body. The forearm should be even with the shoulder. But you can see as it gets pushed forward, it's accelerating that forearm away from the arm and the rest of the body.
Does that abnormal shape suggest anything to you in terms of what you would expect regarding the bones in that arm?
Again, there's thousands of pounds of forces acting on the arm and also on the joint itself, not just the arm or the bones we have to consider and how much force to fracture, but think of the elbow joint and think of the shoulder joint. It takes much less force to dislocate an elbow than it does to actually fracture it.
Did you see any evidence based on your review of the medical records, including your review of the x-rays, any evidence of any dislocation?
There was no evidence or indication or diagnosis of any dislocations or fractures to the arm at all.
Fractures or broken bones at all?
Correct, nothing.
Can we go forward another frame? And at this point, the arm has already been struck and accelerated, is that right?
That's correct.
Do you see the taillight material?
I do, yes.
Okay, it's basically now broken, is that correct?
That's correct. It has now been fractured, yes.
All right, let's go one more frame forward. And the taillight material, did you make note of that in this frame?
I did, yes.
What direction is that taillight material going relative to the vehicle?
It's going forward.
And where is the arm?
The arm has been pushed away. Now, you have to remember, as that arm, if it contacts and fractures the taillight, it's not exposed to the fractured pieces that still exist on the taillight itself, because those pieces that fracture haven't gone anywhere because they're against the arm itself. And then as the arm moves away, the pieces then move with the vehicle.
Are the taillight pieces upon fracture moving at the same speed as the arm upon contact?
That's correct, yes.
Is that a matter of physics?
That is a matter of physics, yes.
Is there any possible way for the broken pieces of taillight to out-accelerate the arm upon contact when the arm's being deflected away from the vehicle?
It is not. I don't believe it's physically possible. That was not demonstrated in our testing, and I've never seen that demonstrated in any peer-reviewed articles. Now, you can see here again also the light and the fragments are being propelled forward. So you also have to consider where Mr. O'Keefe was found. He was found in the yard about 10 or 20 feet from the road. There was no exact measurements. But if you look at the motion of the taillight, it's going forward. Now, if Mr. O'Keefe has to move diagonally to the top left of that corner, and if he's not hit with the center of mass, he can't get to where he ends up before the taillight fragments have already gone forward and been deposited on the ground. Average running speed is like 4 to 6 miles an hour. Even if this SUV is going 10 miles an hour, it the lights fracture, they're dispersed on the ground, and then Mr. O'Keefe somehow ends up to his point of rest. But you wouldn't find the fragments on him because they've already been pushed forward, come to rest before he even has a chance to get to where they find him.
Let's go to the next slide, please. What is this slide showing?
So this is just frames taken from that actual video showing the interaction from the top left, then you go down to the bottom left, and then the top right and the bottom right just shows you the progression of the contact and the movement of the arm.
Is the bottom left frame the same frame that you stalled on just a second ago at my request, showing the deformation of his right arm?
That's correct, yes.
Thank you. Next slide, please. And is that just a close-up of the same?
That's just a close-up of the same, yes.
Okay, next slide. And is that a final close-up of the arm after it's been deflected out of the way?
That's correct, yes, sir.
Does this also illustrate what you just described in terms of the trajectory of the broken taillight fragments?
It does, yes, sir.
Do you see any defect at all in the right sleeve of that hoodie?
There is no defect in that right sleeve of the dummy. No,
Was
sir.
the dummy's sleeve examined following this test? Closely examined up close rather than just a photograph?
It was examined and photographed, yes, sir.
Was there any defect in that right sleeve at all?
No defects at all were noted in that sleeve. No.
Next slide, please. What are we seeing here?
This shows some of the photographs taken of the sleeve and the arm to show that there's no defects whatsoever, and it shows the damage to the Lexus. And again, at 24 miles an hour, not only do you get damage to the taillight on the fender there, but you also get damage to the taillight on the liftgate.
Was there any damage on the taillight of the liftgate in the subject SUV?
There was not, no.
Next slide, please. What are we looking at in this video?
And so this was 29 miles an hour with a suspended hybrid 3 arm.
Was the arm in the relative orientation that you saw depicted in the paint transfer test by Aperture?
It was, and in fact, in this one, there's actually contact. We moved it in so that you would get contact with the elbow and the upper arm as well. So it's in the position after Dr. Welcher moves his elbow in and rolls his shoulder into the taillight cover. We evaluated that position with this test.
And do you see any damage to the liftgate taillight based on this test?
There's extensive damage at this speed, yes.
What about the damage to, damage would you expect to see to the arm itself at this speed and in this orientation?
Yeah, at this speed, I mean, we're talking 4,000 pounds of force on the forearm, and with the hands, 1,400 to probably 3,000 pounds. I mean, well above levels where you would get fractures.
Next slide, please. What are we looking at in this slide, these two photos?
This was the final test that was conducted in using a dummy, and it was impacted at 29 miles an hour. And this was a center of mass impact.
Why was it important, Dr. Renschler, why was it important to do a center of mass test?
Because if we have an auto pedestrian impact and you want to see where the pedestrian ends up, you have to evaluate how they were impacted by the car. In order to have the pedestrian move any substantial difference, it has to be hit at the center of mass. Again, it has to be hit at that belly button area to propel the body in a certain direction depending on the speed and direction. If there's no center of mass impact, how does someone get to the point of rest? You can't correlate a side swipe where the arm gets contacted and say if someone ends up 20 feet away, there's no way to correlate that arm impact caused them to somehow move 20 feet away. It wouldn't be as a result of the actual incident. It wouldn't be a result of the impact pushing their body in that direction.
From a physics standpoint, is it reasonable believe that your arm could be struck, just your arm could be struck as it's out in front of your body, and you could be propelled backward, say 7, 8, 10, 12 feet as a result of that strike?
No, it's not reasonable. That's not physically possible. And you look at the arm itself, and we're looking at talking about the injuries and the abrasions compared to fractures. So if Mr. O'Keefe's arm was hit at 24, 29 miles an hour, what this suggests, and there were only abrasions, what this would suggest is that if the taillight doesn't cover or fracture, you can have your arm hit at 24 miles an hour and you wouldn't have any injuries at all, which from a biomechanical standpoint doesn't make sense. If the claim is that the fractured taillight's the only thing.
So I'm sustaining the objection to that. I'm going to strike that portion. Mr. Jackson.
Let's go to the next slide. What are we looking at in this video?
So here's the video showing that strike at 29 miles an hour with the center of mass impact to the dummy.
What's the import of this particular test? Why was this important, and what did you conclude following this impact test, the center of mass impact test?
There's a couple of reasons. A, it shows there was extensive damage to the rear of that Lexus. So if you had a center of mass hit, you would have damage to the liftgate, to the fender, to the sheet metal. You would have substantially more damage than what we had in this case. And secondly, which I believe is just as important, it shows the post-impact trajectory of the dummy. So again, if you're struck on the corner by the Lexus, the dummy goes straight back in line with the vehicle. There's no force and no direction to actually cause that dummy to move off into the side of the vehicle. So you can't be hit center of mass with the vehicle going straight back and somehow end up 10 or 20 feet to the side of where the vehicle is traveling.
So in this circumstance, would you expect the taillight material to be distributed straight back in the same center line as the vehicle is traveling?
Yes, absolutely.
Would you also expect the body to be struck and move in the same center line as the vehicle?
Sustained is twofold.
Sure. What about the body? What directionality would you expect on a center mass hit?
The body's going to move in the direction that the vehicle is moving. That main direction, that main force, moving straight back, the body is going to move primarily straight back.
Did you reach an opinion or conclusion regarding whether the right arm kinematics are consistent with fracturing the taillight cover and sustaining the abrasions that you saw on John O'Keefe's arm?
I did, yes.
What is that opinion?
My opinion that it is not consistent with contacting and fracturing the taillight cover.
Do you hold that opinion to a reasonable degree of scientific certainty?
I do, yes, sir.
Can we move to the next slide, please? And if I could have just a moment, Your Honor.
Sure.
On what do you base your opinion that you just told the jurors?
That looking at the kinematics of the arm, it's inconsistent with the evidence we have, with the actual abrasions to the arm, the evidence on the sweatshirt, and that at these speeds, you would likely expect fractures, certainly to the hand, and likely to the ulna and the radius and the forearm, if your hand or arm was struck by the rear of the SUV.
Can we move to slide 48, please? What are we looking at in this slide?
This was a study where they used an impactor and they contacted the dorsal or top part of cadaver hands. And they looked at the force that was exerted and they looked at how many fractures were produced as a result of that.
Did you review scientific literature regarding hand injuries under this sort of impact loading? Is this representative of that?
It is, yes.
Next slide, please. What is this?
So this shows the position, and this is taken directly from the aperture paint test. You can see the position that Dr. Welcher had his hand against the tailgate right at the time of impact. And you can see that corresponds, the contact areas correspond to the areas of the hand that were actually tested in this case.
Next slide, please. What is this showing?
So this shows the forces produced during the test as well as the forces produced during our testing. And maybe the next slide here actually better. If you look at the knuckles, which are the blue middle region, and then the metacarpal bones, which are the lower one. So for the metacarpal phalangeal joint, the knuckles, on average, it took 397 pounds of force to fracture that joint. Well, the 15-mile-an-hour test produced a minimum of 483 pounds. And more realistically, that's just with the hand weight. There's going to be more weight because it's attached to the wrist. More realistically, it's twice that, so it's around 900 pounds of force. But what these tests show is that the force produced on the hand, as represented by the PowerPoint from Aperture, even at 15 miles an hour and likely below that, you would expect to get fracture of the hand bones, of the knuckles, metacarpal interphalangeal joints, and the metacarpal bones if you contacted the rear of that vehicle at that speed.
Did you see any indication in the x-rays you saw or the medical records that you reviewed that Mr. O'Keefe's hand was damaged in such a way that you would expect?
There were no indications whatsoever of that, no, sir.
Next slide, please. What are we looking at in this slide?
This was a test where they actually looked at the force on the elbow. So this is a direct longitudinal force against the elbow. Now, there's no indication of exactly, the paint test has the arm horizontal, but there's no indication, there's evidence of whether maybe it would be angled or if it's straight horizontal. But even if your arm's angled a little bit at the point of impact, the forces, again, on the right are what we determined from our testing, and those are minimum. Again, that's just with the forearm. If you include the entire arm, it's about twice that. So even at 10 miles an hour, you're going to have 600 to 1,200 pounds of force acting on the arm.
Is that enough to break it?
That's enough. If you strike the elbow, that's more than enough to actually fracture the different bones of the elbow.
If an arm was hit at that speed with those forces, would you expect the x-rays to show no trauma, no broken bones, no fractures, no hairline fractures?
I would not expect that, no, sir.
Next slide, please. What are we looking at in terms of this slide?
So these are just more articles that I referenced, and they look at impact force on the forearm, so the ulna and the radius. It takes, just to have a transverse blow right against the bone, it takes about 1,100 to 1,200 pounds of force to cause a fracture. We're at that level already at a 10-mile-an-hour impact.
What about a 24-mile-an-hour impact?
24, we're at 1,400 to 2,800 pounds of force.
Did you see any trauma on John O'Keefe's arm that was suggestive of an impact of that nature, of that size, of that force?
There was no trauma, there were no fractures, there wasn't even an indication on the arm of where it would have contacted the vehicle. So if there's fracture at the taillight, there's going to be a force at that point on the arm where it actually contacts the taillight and causes that, right? There's going to be a force riser to cause that damage. There was no bruising, there was no lacerations, there was nothing at the alleged point of contact which would indicate an impact that produces thousands of pounds of force on the arm. No evidence of it whatsoever.
You just mentioned this in your answer, but I want to ask a little bit further. We've talked a lot about bone fractures and ligament damage, et cetera. What about bruising? In any of these tests, would you expect to see bruising, at least bruising, all over the arm at the points of contact?
Absolutely. Bruising occurs when the blood vessels just below the skin are ruptured, and it causes blood to flow into the arm.
Was there any indication that John O'Keefe suffered even a minimum amount of bruising on his arm at all?
No indication of any amount of bruising whatsoever on the forearm.
Next slide, please. And let's go to the next slide. I think we want to jump to slide 50. What slide are we on? Is that 53?
This is 55.
Let's go to the next slide. There we go. That's what I'm looking for. What are you looking at here?
So this again is from the paint test, and it shows, even as the arm gets pushed in, the vehicle's not in line with the center of mass with Dr. Welcher here. So it's not a center of mass impact. and this is important because we've just looked at the arm, and we've looked at the kinematics and the force and whether that's consistent with what happened and the injuries. The next step is to look at what happens if the arm gets hit. How does Mr. O'Keefe end up where he does in the yard? So that's post-impact movement or trajectory of the body. You have to evaluate that if you want to link all these events. If you want to link the head injury to contact with the car, you have to know what happened in between. You have to know the details. And so the next part was to evaluate that.
Is there any indication in any of the testing that you did or any of the review of the medical records medical records of John O'Keefe, including the autopsy records, all of the autopsy records, the x-rays, and the hospital records, any indication that John O'Keefe was struck center of mass?
None whatsoever. No indication at all that he was struck center of mass.
Do you have an opinion or conclusion to a reasonable degree of scientific certainty about whether he was struck center of mass?
I do.
And what is that opinion?
I don't believe that he was. The evidence indicates that he was not. If he was struck center of mass, imagine that. You're getting hit at the pelvis. You're getting hit on the thigh. You're getting hit at the knee. And then the body's being propelled forward. Your arm would get pushed into your body, into your ribs, into your torso. You would have very significant and substantial loading to your body, initially the right side of your body, as that impact occurred. And there's no evidence whatsoever that occurred.
Switching to a glancing blow, a blow of just the arm, not the center of mass, but just the arm. Do you hold an opinion and a conclusion as to whether or not a glancing blow or a blow to the arm only would propel Mr. O'Keefe 7, 8, or 10 feet perpendicular to the line of travel of the vehicle?
I do.
What is that opinion?
It would not be possible. Our testing demonstrates that. The peer-reviewed articles demonstrate that. I've seen no evidence anywhere in this case that would suggest or even indicate that if you get a glancing blow or a sideswipe blow, that somehow would produce enough force to push you 8 to 10 feet into the yard. I don't believe it's possible. I've seen no research that would indicate that would occur.
Do you hold that opinion to a reasonable degree of scientific certainty?
I do, yes, sir.
Can we move to the next slide, please? And let's go to the next slide. Let's keep going. Okay. What are we looking at in this slide?
So this slide, it's a paper that describes how to evaluate vehicle pedestrian impacts and how someone moves in the projection of that body.
Did you seek to analyze a fulsome understanding of whether it was possible that Mr. O'Keefe was hit on his lower extremities?
I did, yes.
Why did you do that? Why was that important?
Well, because with automobile pedestrian impacts, the lower extremity, your legs, your ankles, your knees, that's the most injured part of the body during auto-ped impacts. So if he's going to be impacted at that speed, especially center of mass, there's likely going to be injuries to his leg, to his knee. The bumper lines up with the knee. That's one of the most commonly injured parts, as the bumper pushes into the knee, fractures the tibia, the fibula, or damages the knee joint.
Did John O'Keefe suffer any injuries to his lower extremities suggestive of a vehicle impact?
No, I believe the only injury was a 0.5 centimeter abrasion on the outside of the right knee.
Could Mr. O'Keefe have suffered a 0.5 centimeter abrasion on the outside of his right knee by being struck by an SUV at 24 miles an hour?
I don't believe so. I don't see how those kinematics would work.
Sustained.
Do you have an opinion as to whether or not that injury was from being struck by an SUV at 24 miles an hour or somewhere around 24 miles an hour?
I do.
What is that opinion?
I do not believe that injury is consistent with being struck by an SUV at approximately 24 miles an hour.
Do you hold that opinion to a reasonable degree of scientific certainty?
I do, yes.
Did Mr. O'Keefe suffer any other injuries to his legs or his lower extremities other than that small, how big was it? How many centimeters?
0.5 centimeter abrasion.
That small 0.5 centimeter abrasion. Did he suffer any other injuries to his lower extremities indicative of being struck by a vehicle?
I don't believe so, no.
Okay. Let's go to the next slide. taking a look at the photograph on the right, concentrating on that for a second. How did that SUV get in that condition?
That was by striking the dummy at 29 miles an hour, and that was a center of mass hit with the dummy.
Were you able to review photographs of the subject SUV, Ms. Reed's SUV?
I was, yes.
Did her SUV suffer or suggest any kind of damage anywhere close to this?
No, the only real damage was to the outer taillight cover on the fender itself was fractured.
Next slide, please. We've seen this. This is the video that was the center mass impact?
That's correct, yes.
The photograph that we just saw previous, what relationship does that photograph have to this field test?
That was the condition of the SUV after it struck the dummy here at 29 miles an hour.
Can we go to the next slide, please? What are we looking at in this series of diagrams?
So this is some more recent testing that was done, and this test compared impacts between a small sedan and an SUV, and so it's looking at damage or injury to the legs as a result of this type of an impact. And these impacts are actually conducted at a speed of 24.7 miles an hour. They used cadavers, people who donated their bodies to science, set up the cadavers and struck them at just about 24 miles per hour.
Did this support your opinion and conclusion concerning the lower extremities of Mr. O'Keefe and the possibility that he was hit by an SUV at speed?
It does. If I can go to the next slide, it actually.
Sure.
So this shows you for the SUV, it's the last column on the page there. The last three columns are the injuries associated with the SUV strikes. There's fractures to the pelvis, left knee injury to the ACL, the MCL, fracture of the tibia and fibula. There's extensive damage to the legs of all three of the cadaver subjects that were struck at 24 miles an hour with an SUV.
Did Mr. O'Keefe show any signs of any of these injuries?
He did not, no.
Next slide, please. Is this, what are these photographs and diagrams on the right?
So this was taken from the PowerPoint from Aperture. And so it shows that the medical diagram shows the 1.5 centimeter abrasion. And if you look at the picture on the left of the surrogate, you can see, so the bumper would line up from the knee all the way up to the pelvis. So a vehicle at speed of 24 miles an hour, if it impacts that knee or that leg, it's not going to produce only a 0.5 centimeter abrasion. It's going to get the leg, and it's going to cause significant damage to the knee and to the leg itself.
When you say from the knee to the pelvis, are you talking about the width of or the height of the bumper itself being from the knee to the pelvis?
I am, yes.
Would that be the contact area that you would expect if there was even a glancing blow to the knee and the hip?
That's correct. You can see on that picture there where that bumper, the rear corner of that bumper, where the bottom reflector is, it extends from the knee all the way up to the pelvis.
Can we go to the next slide, please? What are these diagrams?
Again, these are just reports, peer-reviewed articles demonstrating that auto-pedestrian impacts result in lower extremity injuries and fractures.
Did you review all of these peer-reviewed articles that you've told the jurors about, the academic articles, in furtherance of coming to your opinions and conclusions?
I did, yes.
Did you see any reference in the Aperture report that you reviewed and the PowerPoint slides that you reviewed that the concomitant peer-reviewed articles were sought in the paint transfer test?
No.
Or cited?
There was only one article that was cited in that report with respect to automobile pedestrian impacts.
Did it have anything to do with the paint transfer test?
It did not, no.
Next slide, please. And let's keep moving until we get to the, yes, there we go. What is that slide depict?
So this is the opinions that were offered in the Aperture report. And if you look at the top, number 4, it says the totality of the evidence is consistent with the right rear corner of the Reed Lexus, again, impacting John O'Keefe and Mr. O'Keefe striking the rear posterior aspect of his head on the frozen ground. And when you look below that, it basically has the references or the support for that one conclusion.
I'll see you both at sidebar for a minute.
We are at sidebar. Dr. Renschler just bringing it to us this morning. Lana put a goal in chat. You guys have been so helpful. We're going to be calling and giving props to ARCA. You know what, Bagadies? The mic is so low that I cannot hear who objected or called for a sidebar. I only hear when Bev says, approach sidebar, please. I don't think she says please. That's just me. If your super chat didn't count towards the goal, because sometimes it's funny like that, we're still going to count it towards the goal. And so we don't have 3, even though it says 3, I have more than that. If we have 5, I'll count, make sure. We're going to do it. We're going to get it.
Dr. Renschler, can we move to slide? I have just a moment, Your Honor.
70, Mr. Jackson?
That's what we're, I was just 7, thank you. I wish my eyes were better. Slide 70.
Oh. Let me restart it here.
Thank you. Okay, what are we looking at in slide? This is slide 70. Yes. What are we looking at in slide 70, Dr. Renschler?
So this was the one article that was referenced in the Aperture report with respect to automobile pedestrian impacts, and there was a chart from there that was referenced in the PowerPoint that indicates the head's the most commonly injured body region in pedestrian impacts.
And what significance did that reference have in your analysis?
Well, that's not accurate. This article was written in 1979. And the first modern SUV, the Jeep Cherokee, wasn't manufactured until 1984. So this is an article that's 46 years old that doesn't actually relate to this type of an impact. And that's the only peer-reviewed reference with respect to automobile pedestrian impacts that was cited in the entire Aperture report.
Can we move to slide 71? Do you recognize what's depicted in this slide?
I do, yes.
What is depicted here?
So this was a hybrid. This is the 50th percentile hybrid 3, the same dummy that we utilize. And Dr. Welcher performed a test where
Can I interrupt you?
Sure.
So this ATD, anthropomorphic test device,
Yes.
was not a 95th percentile test device?
It was not, no.
Is it 50%?
It was a 50th percentile, yes.
Is that the same exact, not the same exact, same exact sized ATD that ARCA utilized in all of its testing?
It was, yes.
Okay.
And to get the forces on the head, Dr. Welcher scaled the acceleration results based on the weight, which is what I was talking about yesterday. You scale the results from the 50th percentile. That's exactly what Dr. Welcher did in this case.
Is that an appropriate way to adjust for the size of an ATD?
It absolutely is, yes.
Okay. Go ahead.
So this test, what he did, he took a 50th percentile dummy, stood it up, and then let it drop backwards and strike its head on a concrete surface.
Next slide, please. By the way, Dr. Renschler, did the last slide include a video?
I believe it did, yes.
Can we go back?
Or I'm not sure it's on this slide, though. That's just a screenshot.
I see.
Yeah.
I see.
Yeah.
Okay, so let's go back to that slide for just a second. I thought this might be the video of it.
Oh.
So in the lower portion of the center of the screen, you see Dr. Welcher holding the ATD. Is that correct?
That's correct.
Did you review a video of what happened next? This is not the video, but did you review the video?
I did, yes.
Describe for the jurors, since we don't have access to the video, what did you see happen from this point forward?
So Dr. Welcher releases the dummy, and the dummy just falls rigidly backwards, almost like a tree, and impacts the concrete.
Can we jump from your PowerPoint to a video that I have and ask you if you recognize it with court's permission?
Is the video in evidence?
It's in Dr. Welcher's PowerPoint.
Is it before the jury? Is it in?
It is.
Okay.
Okay. Do you recognize this?
I do, yes.
Is this just look like the same screen, basically same thing that you just took a screenshot of?
It is, yes, sir.
Okay. If we could play the first couple of seconds of the video and pause it. As that video began to play, did you recognize this as being the same video that you reviewed earlier?
It is, yes, sir.
And did you utilize this in coming to your opinions?
I did, yes.
Opinions and conclusions in this case?
I did, yes.
Thank you. Let's go ahead with the court's permission. Can we play the video?
Yes.
Thank you. What did you see? Describe what you saw in this video.
So this is a passive rearward fall of the ATD dummy. So just releasing and let it fall. Obviously, it's a dummy. There's no musculature. There's no response to that dummy. So this is what would happen if a rigid individual just fell backwards onto a concrete surface.
Can we see it one more time, please? I want to ask you one other question. I'm going to ask you to take note, Doctor, of the impact location. Did you see that?
I did, yes.
What kind of surface is that floor, if you could tell?
That, I believe it indicates it's a concrete surface, concrete floor.
Did you notice if the falling backward like that, the dummy slid across the floor or was propelled across the floor, anything like that?
It did not. It just dropped and angled backwards and hit directly on the floor.
Okay, let's go to the next slide. I'm sorry, if we could revert back to your PowerPoint. And if you could pull up slide, I think it's 72.
Let me, every time we do that, I have to restart the PowerPoint. Okay.
Why did you include this video one more time in your PowerPoint here?
Because, again, this is the pain test, which indicates the position, at least that Dr. Welcher had himself at to get the impact with the taillight cover. And notice, again, so it's not a center of mass hit. It hits his arm and then he slides by. So if that were to occur, he would rotate or move to the left. So if Mr. O'Keefe did that and somehow ends up falling backwards, rigid directly onto his head, he's going to have to rotate at least 270 degrees and then stop and then fall directly backwards onto his head. There's no explanation of the kinematics.
Sustained is to the end of that. I'll strike the end.
Do the kinematics support what you just suggested?
Objection.
Sustained is to form.
What do the kinematics support?
Objection.
I'm going to see you at sidebar for just a minute. Jurors will be taking our break.
I'll see you at sidebar in just a minute. Hold on while I laugh at what Murky just wrote. I didn't know we were going to go to this. She just boom shakalaka us. So let me go back and count. We're basically there, you guys. So we're going to be doing these calls as soon as Ella gets back to her desk. And we're on. Okay. Here's me multitasking. I suck at it so bad. Gourmet. Okay, we did it. We did it, you guys. Dr. Renschler's bringing the relatable heat, like I said, but notice how many times in his testimony he has referenced the word only when referring to Aperture and what they have produced as part of their $400,000 research. We were only supplied with one photo depicting blank. This was the only video we got, and basically this is the only few frames we got where the blue paint on his arm was trajected towards the taillight at 2 miles an hour. Yes, they ended up using yellow. Well, Dr. Welcher used, I don't even want to call him a doctor because it's probably a fake degree. Welcher used yellow and blue paint. We have not seen the yellow transfer anywhere on the SUV, but that doesn't mean it didn't happen, because as you've seen with Aperture, they only do things very minimally and to the lowest standard. Here's what I think Hank's going to do on cross. I think that Hank's going to come up and say, I swear, I think he's going to do this. Dr. Renschler, you are not a medical doctor, are you? You don't hold a medical degree from any university, do you? You are not a neurosurgeon. In fact, you're not a pathologist. Have you ever touched John O'Keefe's body? Have you actually put your fingers in what you call abrasions? So how do you know those are actually abrasions and didn't break more of the dermis and the epidermis? I have no idea why Hank confabulates and tries to confuse this jury. Well, no, I do know why. But shall we talk about that? I don't know. Hank has overplayed his approach. It falls on deaf ears, probably. From what I see from people who are inside of that courtroom, and they talk about what the jury does and what their interpretations are, they do seem annoyed with Hank. That's what we keep hearing. And they like Dr. LaPrasada. They didn't appreciate the way Hank went at her. And, I'm shocked he has taken this long to direct him. Do you mean, who do you mean? Like, you mean Alan? I don't know. I just feel like this is a joke. I literally was laughing through the whole, every time they show Juddy Buddy. If you want to talk about Rescue Randy, we have Juddy Buddy, and Juddy Buddy, Juddy Buddy putting his arm, he propels his arm towards the taillight, even though it's coming at 2 miles an hour. You guys, these are not, I mean, you guys know, you're smart. It's a smart chat. You guys know it's not scientific. We're back for a minute.
May I continue?
Yes.
Thank you. Dr. Welcher, based on your review of everything...
Renschler.
Did I do that again? My goodness. This is Dr. Welcher in the video, correct?
Correct.
All right. I was staring at that. I apologize. Dr. Renschler, based on your review of the video in which Dr. Welcher is positioned, as well as the drop test that you saw, as well as the discussion of being of the body placement, where you discussed the body placement. Do you have an opinion as to whether or not the testing that you reviewed from Aperture is consistent or inconsistent with John O'Keefe being struck by the vehicle, propelled perpendicular, backward, say 7 to 10 feet, and falling straight back onto a hard surface, as depicted in the drop test?
The testing's inconsistent with those types of kinematics or that type of scenario.
On what do you base that opinion, sir?
That's based on the testing that was performed, the evidence available in this case, and the kinematics of how somebody would move post-impact after being struck by an SUV.
Do you hold that opinion to a reasonable degree of scientific certainty?
I do, yes.
Can we go to the next slide, please? May I have just a moment, Your Honor?
Yes.
Finally, Dr. Renschler, do you have an opinion, or did you reach a conclusion, whether the biomechanical evidence in this matter is consistent or inconsistent with Mr. O'Keefe's right arm being impacted by the subject 2021 Lexus 570, resulting in a backward fall leading to the head injuries that he suffered?
I did, yes.
And what is that opinion?
My opinion is that the evidence is inconsistent with Mr. O'Keefe being struck on the right arm by the SUV and then moving laterally into the yard and falling backward onto.
And do you hold that opinion to a reasonable degree of scientific certainty?
I do, yes, sir.
Thank you. That's all I have, Your Honor.
Okay. So now we'll take our break, folks. We'll see you in about 20 minutes.
Please rise for the jury. Jury break this way.
You are muted. 20-minute break. Lana's back in the house. We're going to wait. We're going to wait. What books are in reading club? Love reading club. So we're on a 20-minute break. Let's put a timer up. You guys over there on the East Coast, it's 11:25. West Coast, 8:25 a.m. Yeah, I like William Tardy's thing to call him Dr. R because I've done that too, called him Welcher instead of Renschler.
Hello. Looks like we met our goal. Let me get that bell out.
did.
Make it a little ringy dingy here.
Yes, do it.
Let me get. Let me ring your bell. Okay.
More cowbell.
More cowbell coming right up. Oh.
Do you
So-
want me to send you the links to what you need to do?
The links. You know, I got those numbers on speed dial.
Okay, good. Handle it.
But yeah, we're gonna wait till lunch to do that though. Was that to like reset how I'm doing it? Because for my phone, I can't do both.
Oh,
So
yeah.
so I'll be making the calls at the lunch break. But I also want to make a couple calls on over to the Norfolk County District Attorney's Office and ask them why they wasted our tax money. I'm going to call on behalf of Miss Kelly.
Well, you should try to ask for
I'm going to call on
Mr.
behalf of being a friend of a Massachusetts resident.
You guys, so how
I'm going to ask if they can tell me how much it's costed to date for them to try Karen Reed for the second time.
they'll just click on you. They're so callous in Norfolk. They remember that's who we were dealing with before, and when Traub, who is the contact person for this case, for the first trial, when he was about to leave or get fired or whatever happened to him, he just started putting Morrissey's number out there. When you would call his phone, he'd like be like, I'm out of the office. And it redirects. He's like, call it this number. And then when you call that number, Morrissey picks up. It was a hoot, remember?
Mm-hmm.
So I think maybe we should call Morrissey and ask him.
Well, I just want to give me a figure. Throw up some dollar figures. I mean, I thought AJ took a little bit longer than I thought was needed, but those views of, I mean, I think you made some really good points on we only had this and we only had this. How about no measurements? Like, mind blowing, right? Missed that during Welcher's testimony, like, no measurements. And you have to wait to get your expert up there to talk about, you know, even if Alan, or actually who, I think it was Aleshi that did the cross, but you can ask somebody something, oh, is there any measurements? But until you get your expert up there to talk about how important the measurements are, and, oh, wait, they didn't have any measurements. How did this cost $400,000?
It's a little padded. Just
I think that it's probably not 400. But I think that was just like the retainer, and then whatever, like, you know, you're gonna get back or whatever from like my calculations. And how about Karen Reed got her exemplar Lexus when I would have been like, can I just have my motherfucking Lexus to smash up? She had to use an exemplar Lexus, and they actually smashed it. Okay. And here, which would have cost her, then you have to like replace it. I noticed that it had Lexus dealership plates on it. It was one of their courtesy cars. Courtesy cars. So then we'll replace it, and then can you guys like buy it back from us?
Sometimes we sell it for more, says Welcher.
I mean, thank God Karen's lawyers know people. You know what I'm saying?
I mean, I don't know, dude.
They do. They know people to get them like, hey, can you do us a favor?
Yeah,
But
but
now,
it's not just the lawyers. Remember what she even said? It's like where she used to work, those people are very influential also, and they've come through. So she knows people. Yeah.
I mean, this is cheddar. Like, you're not getting this type of a defense with the public defender's office.
No.
Shit, you're not getting this type of a defense with people that you pay for.
No. AJ is top brass. I was saying that before trial one.
I'm not even just talking about that. I'm talking about all the money that goes into all these other people. These
you mean
experts,
like Arthur?
Yeah, all the experts. But all the time, like, not just them coming to like the trial. You know what a pain in the ass it must have been for, let's see, if I was Wolf, I would have done the same thing. Dude, no way. He's not going to ruin my career. I'll be driving myself in my pickup. You know what I mean? Like, no one's got time for that. Because I said, why did he even bother flying? I'm going to tell you why he didn't bother flying and why he left. And he probably just went to the tip of Pennsylvania. But because that's not like as close. I mean, I don't know what part of PA he lives in, but you don't just get in a car and drive on a Friday, get home, and then, oh, you're home for what? Like, you get home in the middle of the night and you're home on Saturday only to get back in a vehicle and drive. Why wouldn't anybody just stay in a hotel like you normally would? But I personally think that he did not because of all of the crap. Like, I'm not going to have one of these trolls come follow me up out of there and then try to say that I was eating with somebody or, you know what I mean? Like, it's just not worth it. But you would think that fly him back in. I'm going to tell you why, because I looked at those prices, and I don't know what's going on, but last minute, if you want to fly into Boston, they want to charge like $1,300 one way. I'm like, what? That's never been like that out of Ohio to go to Boston. Like, Columbus to Boston's like $300, and that's a high-end round trip ticket. If I book out like 2 weeks, dude, I can get a round trip ticket for $90. when I was looking at him just like the last week, I was like, wait a second, is the president in town? Like,
Okay, so to drive from Canton, Massachusetts to Arca in PA is 9 hours and 18 minutes right
yeah.
now. But that's because there's a lot of road construction. But yeah.
Well, what do you think it's gonna be at 4 or 5 o'clock? Same. I'm just saying, like, nobody's got time for that. And then you think that you're not paying somebody for their time for that? And so
Yeah.
that's just interesting. Like, nobody would ever do that.
18 hours if you go both ways. Yeah.
Yeah. Well, then he had to
18
come
hours.
the first time. like, so did he fly in the first time? And then it was like, I mean,
This doesn't seem right.
kids at home, kids not at home, married, not married. Like, that's why I thought it was interesting when they kind of had him come in and not, like, when you have somebody on a Friday and they have to testify again on a Monday, what are you doing? You're putting them up, you're feeding them. And normally you're able to just do all of that. But Hank's ridiculous. But none of the stuff, like, I think that those type of questions should not even be allowed anymore. Like, to answer the question, well, what'd you talk to them about? Logistics. Oh, imagine that. Logistics. Like, who do you want me to talk to about it?
Yeah.
I can't talk to who do you want me to talk to? Hank? Like, I just don't think that you should be able to ask those questions. I think that there's certain questions you can't ask. Did you talk to the attorneys about anything other than logistics? Or did you talk to the attorneys? I just think that there's certain, like, you want to talk about, like, decorum? I think that
No,
that's
you
a
want to
slap
talk
in the
about
face to even ask me that question. And then
wanna
as soon
talk
as I
about-
just answer, no, I didn't talk to them, it's over. There's no asking another question about it.
Asked and answered. But if you want to talk about and the jury's time, which is a really big deal, because when in a courtroom, the decorum mandates that the jury is very valuable because they're doing a civic duty and basically getting paid peanuts, taking time out of their days. So their time is incredibly valuable. Bev's just wasting everyone's time, though. But yeah, if you want to talk about time, those questions that you're talking about, Lana, yep.
Like, I think that, anyways, this is something I do want to talk about on this break. So let's go back to John arriving at the house. Okay.
Your brain moment?
Yes. Well, because I want to talk about Jen McCabe. All right. She makes the phone call to John O'Keefe at 12:29 and 44 seconds. And that call is labeled as answered. And it was like a 9-second call. And then now she claims that was a butt dial. She claims that she doesn't know that she made 7 calls, which was 12:29 and 44 seconds, 12:41 and 10 seconds, 12:41 and 59 seconds, 12:43 and 19 seconds, 12:46 and 16 seconds, 12:47 and 54 seconds, 12:50 and 37 seconds. Okay. And remember before it was said that she would have been calling, to, like, look for his phone or something like that back in the day.
Mm-hmm.
Well, if he answered the call and said, "Yeah, I'm walking up," or I'm like, "Yeah, I'm here, I'm walking in." Okay. Then what would be the text for at 12:31 to say anything about, pull in behind me? If I answer your call and I talk to you at 12:29, then why are you writing to me at 12:31, pull in behind me? And that's why I've always said that I don't know if that pull in behind me was meant for John, if it wasn't meant for her daughter.
Yeah, you were saying that it could have been sent to the wrong person.
Yeah, because that happens. And so, like, that wasn't for actually him. Because if in fact they did talk at 12:29 and he would have already been out of the vehicle, then I don't know why you'd be writing him at 12:31 to say, pull up behind me. Like, that doesn't make any sense. That's why I think that actually was for, and what would make more sense is that would be for somebody else. So, but going back to all these calls, if John was attacked right when he walked in and he went in the wrong door to the garage, ready for this? If they didn't go and get the dog to come in from the garage to like go back like upstairs, it would be the moment that they would have went into the garage to get the dog and then would have seen John O'Keefe. Which in my
Okay, you're
opinion,
gonna have to break that down. You're gonna have to
Okay.
slow that down.
All right,
So
here's-
if John walks into the garage and nobody is there and it's only him and the dog. That's
yeah,
what
so
you're
when
saying.
like he goes into that, yeah, he's met with just the dog, and the dog, flies
Jumps
at
on
him.
him.
Yeah,
Okay.
takes him down. Boom, he's out. Okay. And let's say that the reason that the dog was in there is because they put the dog in there, right? Because of people being over, and that they're going to go get Chloe, the dog, at some point, right? To come inside to like, come back in and put her up in the bedroom. Okay. And then that's whenever you would have went in the garage and found
That's
him.
when you notice. So it might be an
That's
hour
when you would
later.
notice.
And he's
Okay.
already gone. You check his vitals. He's gone. What you just said right now would give the Alberts such like a green card to just bypass
Well, but
any
hold on though. Hold on though.
if they did the right thing at that time.
Well, I'm saying, let's say that you don't realize this until 1:30 in the morning, 1:25, 1:20.
Like an hour after. Yes.
Well, the only reason I'm going to say this is because Jen McCabe's phone calls to him, one after another, like that.
Okay.
Okay. To me, you're not looking. I don't believe that you're looking for his phone. I believe that you're really like, what the fuck? Where are you? Or
Okay.
if Jen, like I said, left in a car because she was literally sitting like for like a straight 10 minutes. And then when she gets there and then is like, okay, where are, like, calling. And then it stops. And then where she goes, where her like numbers kick up crazy is at that 1:30 mark where she just goes walking off doing 300 and some steps. And that would be as like right before when Higgins would have been when Higgins would have left to go to the Canton Police Department, to then come back. Like that's when all that stuff's happening, when she starts doing all these crazy steps. And then that's when people would be like, hey, we got to get these people out of here. Nobody can be spending the night, because the whole plan was to spend the night. And because I'm just thinking like in terms of this, if the FBI hasn't come in yet, okay, is there a way that in a way it's half truths here? I never saw him come in the house. Well, he went into the garage. I never saw him go in the house. He never was actually in the house. You know what I mean? But I would think that the FBI got a hold of all of their phones.
Well,
and
whose
so
phones?
all of them.
Higgy and Albert.
No, when I say that their phones, you can still use the iCloud. You can still use Google. You can still, if they truly did an investigation, they would have all of their stuff. And then the FBI only decided to release whatever it is that they released to the two parties. And I do not believe in any way, shape, or form that it's all inclusive of everything. And so could this also play into why certain people weren't called to the stand? I don't know. I would be telling them I'm not testifying. I'm just saying, when you look at this from like a whole big thing, if you think that the dog immediately attacked, right? To me, then you have to ask yourself, why is Jen if he got attacked right there, it would be like right in front of the house, right by where the garage is. He would have had to make some type of a movement to like go into the garage, and then boom.
I think it's a good theory, especially looking at the data. And I like the timing of it. Is that the mic? Are we back? Or is that you?
No,
I like the timing of that, because that is when it aligns with Higgins going to Canton Police Department. And
yeah, like I think he went there to get something.
Well, that's
like,
what they're alleging. That's what the defense is alleging.
Like
Absolutely.
He went there to like, I'm even saying went there to get something, even possibly like to help him. But then they tried and like nothing could be done.
No. I don't see any urgency in like helping urgency in him and his body language, but like,
what did you get the bag for? What was the bag that came out of the truck for Higgins? What would have been all in that bag? That looks like it could potentially be like a bag that you would have a bunch of like.
Yes, it's a go bag. Like how
bag.
many everyday carry dudes, people that have, who know what EDCs are, they have go bags. My house was filled with go bags. like that. Yes, there's things in there, and Faraday bags are part of that.
Now, what if as a joke, I'm ready for this crazy shit? Not as a joke, but as like a sick joke. But if Colin knew that Chloe was in there, John walks up and he opens up the garage, that side garage door, and Colin pushes him in there and grabs the door to go close it. And fucking Chloe jumps up and knocks down John. And then they go to open it and they're like, oh my God, what the fuck? You know? I'm just saying, I don't know how like deranged these kids are, but like, would they think that's like a
funny fun? Well, they had beef, remember? Because like John, they always made fun. What's the character that they made fun of him about? Was it a Monster House character? Like the guy, stay off my lawn guy. I forgot his name now. So they like would make fun of John, and
like, yeah, it's like a way to like fuck with him.
Yeah, I don't see it as being off that they would do that. No,
because I'm trying to put it in terms of like why. If it was just such a wow, boom, the dog came, because I kind of think that they're going away from that he was like beat up. Like, unless you're gonna sit here and say nope, it was just one blow. Then I don't even where does the dog come in? Once John would have been down on the ground, what's the dog's coming then? I disagree with that. Why would the dog come then? And
well, dogs are okay. It depends on the breed, but like dogs are reactive to their environment. So if there's like a melee going on, they're going to, especially a reactive dog that they're saying he was.
Yeah, but if everybody's okay, but you have to look at it in the whole totality, that it was not just John coming to that house and using the side door and the front door, okay? It's Julie Nagel. Okay, it's Colin, it's those other girls, Fabiano, all those freaking people that were there earlier. All these people are coming and going, okay? No issues. No dog is going nuts on them, okay? It's when John walks up that the dog would just attack.
Well,
no, I think that it would have been provoked in a way that it would have been a different situation, where what comes to mind is if they're all gathering right outside the door there, what looks like could be a potential like people are smoking out there because they're not going to smoke inside the house, so right there before you go in, like you're just standing around there if people are smokers or something. But if Colin is leaving,
when you have a bunch of people coming in and you've had a dog that has had issues in the neighborhood, you're not going to leave it up to people who may or may not know the rules of your house to leave a door open or not, and your dog might get out. So your dog's not going to just be out in the party. Your dog's going to be put away.
Yeah, so your dog, like I'm saying, the dog was put in the garage.
Sure. Yes.
Okay, because what I think somebody did is somebody got lazy and they took the dog out, okay, to go to the bathroom in the backyard. And then instead of taking the dog back upstairs, if the dog truly sleeps in the bedroom with, the homeowners, instead of taking the dog back all the way upstairs, and I'm going to put Chloe in the garage, okay? And so Chloe goes in the garage, and then and somebody would have known that if we think that it's Colin, and then fucked with John when he came up, twisted the side door and shoved John in there and closed the door. And what was supposed to be just like a joke or just to fuck with him, it turned into like because I'm trying to put everything in totality as to where the lies when they need to come in about if Colin was even there or not, or, who cares if Colin was there? Who cares if the whole damn neighborhood was there? Who cares if you turn over your phone? Here, take my phone. Like, what do you mean? Here's my phone. Here's my.
Well, they're saying they're bringing up the beat up thing. I like see it in what the defense is doing with these last couple with Dr. La Posada especially, but in stating that he has these injuries to his face and and they did it with Renschler, Dr. R, to the side of his nose, to his face.
And it's because of what if you just put La Posada on the stand. As soon as he suffered that head injury, he's out cold. He's done.
15 minutes, he's done. There's really
no.
life.
But I mean, he's done. Like he's not getting up and walking anymore.
Okay, yes, that too.
Okay, so
but I think he had
for me, there wasn't like a fight. For me, that would be a dog attacking you and shoving you with all their force after they come for your arm and you're like trying to get them off. Okay, and then the dog then was able to force you all the way over, but enough that it's at, the dog could have stopped and the dog could have looked back, like lunged at you. And then he's going back and is hitting his head at a severely, it's with force.
Well, think about
that injury.
Think about you getting startled. Okay. Like you're just, whoa, a dog just comes at you and you're getting like you stumble back.
Think about how you wouldn't be able to break your fall with your hands.
Yes.
What would cause you not to break your fall with your hand?
Because you're protecting your face or your arm is being held by the dog or whatever it is. But even if it just
and then something's slippery enough, if that garage had like that slip, like
it doesn't even need to be slippery.
You would lose your balance to lift your feet up above, so that you couldn't break your fall.
No, listen. If something is lunging at me, let's say the back of my heel hits like a stair, hits something, and that causes me to lose my balance even more when I'm like, whoa, like already off balance from a dog lunging at me, and I'm startled. It doesn't have to be slippery. I could just literally like trip over my own feet. I mean, it makes sense. And that's why I think these witnesses were really powerful, because they put it into perspective of like, there's no hypothermia. He didn't die of hypothermia.
The question would be when did you realize? I just think that when you then look at Jen's data for the whole calling and stuff, she keeps on calling his phone. Okay.
Mm-hmm.
Like, I personally believe that is too soon for her to see that, oh my God, John's incapacitated at 12, let's say 12:35. And then she thinks to herself, now let me just call John's phone a bunch of times. And let me act like he's not here. Like, that to me is way too quick for somebody to start telling you to do that. Do you get what I'm trying to say? Like, she makes these calls from at 12:41 straight through to 12:50. That's 6 of them every 30 seconds to a minute and 20 seconds. I truly think that she's like looking for him.
Okay, well, that changed from what you thought before, right? So what made you change?
Well, I never, the people out there were saying that she was calling, that they were calling because they were trying to find his cell phone. What changes is the data. His phone being in a pocket state and being done and over with at 12:31 in 59 seconds to 12:32 in 9 seconds. Like, because it would be like once you would have found his phone, if you believe in the pocket state stuff, once you would have got to his phone, then there would have been, like I've always said, how does his phone never not move again? Like, there's something to be said about that. And it would have to be that and they said they have no data, which is interesting, from 1:30 until like 6, that because they weren't even do like the temperature of the battery. It just pops on at 6 saying it was like, lost all this degrees, whatever. But bottom line is why would the dog attack John, okay, in a mere instance of coming up right to the house when numerous people were coming and going from that house freely? Like, and to me, it would be because John went into a different door than he was supposed to, or somebody, when he walked up, got in his face and opened up the door, and then put him in there.
Well, you know what I think would help with that is the vomit. And I want to know, because there was vomit on his shirt. And if what Dr. Laprasada is saying is that he was knocked out cold after the coup contra coup injury to his head when he knocked himself, out.
Yeah, and she also says that all the injuries that on his front of his face, like his swollen raccoon eyes, that is not somebody that, she's like, that's not from getting punched.
Yeah, no, but what I want to know is, if you want to know where people were when this happened to him, you need to look at the vomit. Okay. So a very typical thing that happens.
But that didn't come into trial.
I don't care. None of this matters anyways, because all that matters was.
Well, don't you think they would have brought in the vomit if it mattered?
No, hold on a minute. All that matters right now is if the CW can prove their case or can't. So all this who did what and what happened doesn't matter.
No, I'm asking, how do we even know he vomited?
Because there was vomit on his shirt.
When? Who testified to that?
I don't know who testified to that.
But nobody testified to that.
Not in this trial, but in the first trial they did.
No, they did not.
Okay.
That's what everybody's always talking about. This. There was vomit on his boxers and all this stuff. Like, where's that?
So anyways, whatever. So anyways, it's a very common thing that happens in coup contra coup is to be nauseous and to vomit. And even if you're passed out and unconscious, you're going to still vomit. The difference is going to be if you you suffocate on it. I can't say this right now. So if you suffocate on your vomit or not. So if somebody's there and they're able to remove the vomit out of his mouth, and I want to know the pattern of vomit and where it was. I want to know more about it. I want to know if it was chunky. It's gross. That'll make me puke, but I do want to know about it.
I agree, but I thought they couldn't do any of that because the clothing was all clumped together, and so it ruined that.
Yeah, I just want to know about it. I don't care if we can or can't. I want to know about it. We're back.
Yes, back live.
All right, Mr. Brennan.
Thank you.
The firefighters probably testified to the vomit.
Dr. Renschler, facts matter, don't they?
They do, yes, sir.
You've said it many, many times. Facts matter. Isn't that correct?
I think it was details, but facts matter too.
Do details matter, doctor?
They do.
They're critical, aren't they?
If you want to prove that something happened a certain way, they're critical, yes, sir.
When you were talking to the jury and giving opinions about where Mr. O'Keefe might have fell or not fell, you were discussing where Mr. O'Keefe was lying on the side of the yard, weren't you?
Where he came to rest?
Came to rest.
Well, approximately. We don't know the exact position, but yes.
You said 10 to 20 feet, didn't you?
I believe so, yes.
You said that 3 times, 10 to 20 feet. Do you think Mr. O'Keefe was 20 feet from the roadway?
Well, I think he's maybe 10 feet, but 20 feet is from, if you're hit by the car, you need some distance to travel. He couldn't travel just horizontally, or perpendicularly. So it would be at least 10 to 20 feet if you look at the total distance.
You have no idea where the point of impact was in this collision, do you?
Nobody does.
I'm asking you, not nobody.
Yeah,
Excuse me.
So go ahead and ask the
You,
question.
Dr. Renschler, before this jury, have no idea where the point of impact was of this collision, do you?
That's correct. There's no evidence.
Play Exhibit 2, please. When you were giving your estimate 10 to 20 feet, Dr. Renschler, did you ever see this photograph before or part of this video?
I'm sure I have.
Well, when you say you're sure you have, are you guessing or have you seen it or not seen it?
I'm sure I've seen this before, yes.
So you've seen this before?
Yes.
And when you looked at this video, did you look at the street and look at the area where Mr. O'Keefe was?
Sure, yes.
Sure?
Yes.
20 feet, Dr. Renschler?
The way I explained it to you, yes, sir, 10 to 20 feet.
Details matter, don't they?
They certainly do, yes,
You
sir.
take that down, please. Did you speak to anybody today before you testified about Dr. Welcher's testimony in court?
I did not today, no, sir.
Before today, did you speak to anybody about Dr. Welcher's testimony?
I did not, no, sir.
At any point, did anybody discuss certain issues with you today that they said would be particularly important?
I don't believe so, no, sir.
When you began your testimony yesterday, before you even finished your credentials, you began talking about your work with the NHL and how important it was to use a 50% hybrid 3 dummy. Do you remember that testimony?
I did, yes, sir.
And you hadn't even finished your credentials yet. Was it brought to your attention that there was an issue in the testing because you or Dr. Wolf or you and Dr. Wolf chose to use a 50% dummy?
Not at all, no, sir.
In your preparation for your testimony, was it discussed at all that at the beginning you should get ahead of the issue and talk about the 50% dummy?
I didn't know it was an issue, no, sir.
Well, you know that the 50% dummy represents somebody who's 5'9", correct?
Approximately, yes, sir.
Approximately 173 pounds.
171, 172, somewhere around there.
And Mr. O'Keefe, how much did he weigh?
216, I believe.
How tall was he?
He was 73 inches, I believe.
So that is not a representative height and weight for Mr. O'Keefe, is it?
That height and weight, no, sir.
And so if you were making projections or analysis based on limb weights, they would be inadequate.
They would certainly, the force on the limb would be less if you use a lighter limb. So if Mr. O'Keefe is heavier than the hybrid 3, and I use a hybrid 3, the forces I calculate would be an underestimate of the actual force acting on his body.
If you didn't make an adjustment, but you relied on the numbers from the test 3, the hybrid 3 dummy, ultimately the conclusions would be off, wouldn't they?
They would be an underestimate. Yes, the actual forces would be higher.
And so did you make any conclusions, or do you know that when Dr. Wolf did his tests using the hybrid 3 dummy, he didn't make any adjustments?
What do you mean? What adjustments would he make? You get the acceleration, but the acceleration's not going to change, and that's what we utilize. Then you can scale the weight of the body, but I'm not sure what he would have made adjustments for.
When you looked at the ratio, force and mass, if you use a lighter weight, the mass changes, doesn't it?
If you use a light, sure, yes.
And that changes the force equation, doesn't it?
That can, yes.
And so when you were discussing yesterday at the beginning of your testimony about the 50% dummy, had that issue been raised with you?
No, sir, it had not.
You had testified before, hadn't you?
In this case?
Yes.
Yes, sir.
And you knew there was a sequestration order?
Prior?
Yes.
Yeah, I didn't discuss the case with anyone, no, sir.
Well, you didn't discuss it with anybody, you said?
I did not, no.
Before you testified last year, you were receiving information from your employer about issues and testimony in the case.
The party that retained us told us things. I didn't break any sequestration. They were the ones in contact with the court. So it was my assumption that whatever they were telling me was allowed by the court. They were the client. I didn't discuss anything with them or tell them anything, but yes, they told us certain things.
Before you testified under oath last year, you were getting updates from your employer about details of this case, weren't you?
Objection, Your Honor. May we approach?
Maybe we can approach briefly.
Okay, this is interesting because this has to do with the FBI. And I think Alan Jackson's going to say, wait a second. Um, this is opening the door for us to say who the fuck the employer is now. I think it opens the door. Because they're now saying that my experts here today were violating, court orders, and that's going at their character. And that, I mean, Bab's gonna say, well, they know that you didn't hire them. You made that clear on, you can just handle that, and you can rehabilitate him there. Well, rehabilitate him how? Who was his employer? Who would ever instruct you to do something like that? They were still our witnesses. And if we told them about a sequestration order back then, like, it wouldn't. I would be saying that rehabilitation isn't going to work unless I could say it's the FBI. I think, yeah, remember, Alan Jackson's just making sure the record's all crump tight here. These sidebars, they might not be known to us, but they definitely on that record over there. Let's take a look one more time at facts matter. You said, how far off that? Yeah, about that. Yeah, Jennifer McCabe, 1:24 to 1:34 a.m., 255 steps. Then 1:36 to 1:44, 302 steps. For a total of 557 steps in a 17-minute period. 18. Of which only 35 of those steps was when she had her phone on her.
Before you testified last year, you were receiving information, not from the defense, from your employer, about other witnesses' testimony during the event, weren't you?
I don't know if they told us about witness testimony. They told us about certain evidence. I had no contact with the court, with the prosecution, with the defense. I had no idea what was going on. We were retained by a certain organization, and they contacted the court. They were in talks with the court about, I guess, what we could or couldn't do. Anything I got was from that organization.
Good answer.
Voir dire 2, 118, line 15. Did you testify under oath that they did inform me, yes, about testimony and situations and events that came forth in the event that I was not aware of?
I don't know. They told us about evidence. I don't know if it was specific to who testified to what, but they told us certain things, certainly, yes.
What I just said to you, are those your words, sir?
I have no idea. I mean, if that's what's in the record, I assume it is.
Would you agree it certainly helped you prepare?
It helped me prepare?
Yes.
It didn't make a difference to my analysis or conclusions.
Made no difference at all?
It did not, no, sir.
Would you agree it helped you understand what was going on during the trial?
I don't think it made a difference at all, no. It doesn't change the facts that I evaluated or the analysis I conducted or the conclusions I came to.
And so as you sit here today, you are denying that that information certainly helped you prepare.
How did it help me prepare? It didn't change the opinions I offered. It didn't change what was in my report or what I'm opining to or testifying to today. It hasn't changed anything I've ever testified to.
I'm going to ask you a very specific question. I want you to give me a very specific answer.
Objection, Your Honor.
So just go ahead and ask the question.
Are you denying that receiving that information certainly helped you prepare?
Honestly, I can't remember. It didn't change my opinion. I don't see how it would help me prepare. I remember there was evidence about trace DNA found that we didn't know before. That didn't change my opinion then. It doesn't change my opinion now. It doesn't have anything to do with my opinion.
Details matter, right, sir?
Details can matter.
Details matter, so let's talk about detail.
Sure.
Are you denying that receiving that information certainly helped you?
Asked and answered.
Denying.
I'm going to
God damn it.
Yeah,
How?
I don't think that it did. It's been a year, but certainly it didn't change any of my opinions or what I opined to. It didn't change anything with my testimony.
I'm going to ask you one more time. I'll ask you a different question. Receiving that information from your employer, are you denying it helped you understand what was going on during the
For a
trial?
fifth time.
I'm going to allow that.
I don't even think that it did. I don't understand it. I understood what was happening. I understood what the theory was. So saying that there's trace DNA doesn't change anything. Doesn't affect what my understanding of the trial was or what was happening or what allegedly occurred.
When you were traveling out to testify last year, you had phone conversations with the defense, didn't you?
I think I had like 2 phone conversations, 2 or 3.
So that sounds like a yes, you did.
Yeah, there was one right before my qualification, my voir dire, where I talked to Mr. Jackson, and that was it. Other than that, I think it was just planning and scheduling.
Mm-hmm. Was there any discussion on how you could portray yourself as independent?
I
What?
don't believe there was.
You say you don't believe.
Yeah, there was no need to.
That's not the question. Details matter.
What?
Was there any attempt?
So the objection sustained. I'm going to make that, folks, okay? Questions, Mr. Brennan?
Was there any attempt in your conversations to portray yourself as independent as far as your arrangements were concerned and coming out here?
No, I don't think so, because there was no need to, because it was independent.
When you had conversations with the defense, did they offer to give you transportation assistance?
See,
They
This is what I'm
provided
talking
a
about.
ride to and from the airport, yes.
Did you tell the defense that you prefer to take an Uber so that it would appear independent to a jury?
No, because I didn't take an Uber. I took the ride. If I wanted to appear independent, then I would have taken an Uber.
Did you have a conversation about that you were thinking about taking an Uber?
It didn't
Oh
even
my
cross my
God.
mind, sir.
This is
And
ridiculous.
after you testified, did you stay independent?
What do you mean independent?
Well, did you have any bias for him in you?
Any bias?
Bias, yes.
What do you mean? Did I have any bias?
Well, after you testified, where did you go?
Well, I was waiting for my ride, and to get back to the airport, they had to take other people, and so they were having a lunch afterwards, and they said, come have a sandwich, and then your ride will take you to the airport. So I went, and I had a ham sandwich.
You had a ham sandwich. Did you testify at some point that after you had something to eat, you just stood in the corner?
I did. I sat at a table, ate, and then went over and literally stood in the corner waiting for my ride.
When you sat at the table and eat, did you just eat your ham sandwich, or did more go on?
I ate. People were talking. I really didn't talk much at all.
Did you listen?
Well, certainly, I'm sure I did, sir.
Did you laugh along?
I assume if something funny was said, I probably laughed.
Did you talk about your testimony?
I don't, at this point, I don't even remember.
Let me alert you to something. When you were there at the lunch, did you see a camera crew
I believe I did, yes, sir.
filming and documenting, right?
There were a lot of cameras, yes.
You know that you might have been on some of that footage?
That's fine, I could care less.
Okay. So do you think maybe you were talking about the case and your answers and laughing it up a little bit?
I have no idea, possibly.
You were involved in conversations with the defense attorneys, were you?
What do you mean conversation, sir? I had just gotten done testifying. I was having lunch. Whatever was spoken about at the table, I'm sure I heard.
You know what a conversation is when someone speaks to you and you answer.
Sure.
Did you have conversations with some of these folks?
Sir, I can't remember conversations I had last week, let alone a year ago. So I probably did, but I have no clue
Do you remember
what we would have talked about.
Do you remember accolades you might have been receiving because you had given certain answers to the then prosecutor on the case and laughing about the answers?
I have no idea.
You don't remember?
I can't remember last week what I had for lunch last Tuesday. How would I remember a conversation from over a year ago?
Do you remember when you were having conversations with some of these folks and you were laughing about when the prosecutor asked you about other evidence like DNA? You had a response, well, the physics doesn't change. Remember?
I don't specifically remember that, no, sir.
How long were you at the table eating your ham sandwich?
Oh
with
my
the
God.
folks there enjoying the event. How long do you think that went on?
Enjoying the event.
I honestly don't know. 10 minutes? How long does it take you to eat a ham sandwich? 10 minutes?
And after you finished your ham sandwich and then you told us you stood in the corner, you got a ride back to the airport?
I did, yes, sir.
Yeah. After you got back to the airport, ultimately your company billed the defense for your time preparing and traveling and testifying?
I believe they did.
You wrote your bills down, didn't you? You wrote your time down?
Well, I don't know who gets billed to it. I think it was actually, I wrote my time down and it was the same time code for the original employer that we had. I'm not involved in billing. I don't know who the bill goes out to. I just put my time in and do my work.
Do you know that the defense paid that bill?
I have no idea if they paid it or not.
And then now you have a new contract with the defense. Or I should say you have a contract with the defense, don't you?
I assume ARCA does. Again, I'm not involved in that. I don't do any part of the financials. I just do my job.
Do you keep your billing?
I enter my billing every week, yes.
Do you know how much you've paid so far in this case?
I haven't been paid anything. I'm a salaried employee for ARCA. I have no idea how much ARCA's been paid.
How much has ARCA been paid because of your work so far?
I have no idea. I'm not involved in the financials, sir.
You have no idea how much time, how much compensation your company's going to get for the work that you've done and continue to do on this case? You have no idea.
It's not my concern. It's not my department, so I don't.
Is that it? That's a no?
That's a no, sir.
Now, when you communicated with the defense, you texted, didn't you?
When?
At any point.
There were some texts, yes.
And at some point, there was a court order for you to bring a copy of your text?
I believe so, yes.
But when you say you believe so, details matter.
Yeah.
Do you know whether there was a court order for you to bring your text?
I believe there was, yes.
Did you comply with that court order?
I complied with, yes, with whatever I had.
Did
Yes.
you have any of the text messages?
Don't believe so.
What happened?
Well, there were like 2 text messages about where I could get my ride and what time. And so after that day, like I do many times, I'd probably erase those texts.
Wouldn't say probably. Did you delete the text that you had with the defense last year during the trial?
Again, I had like 2 texts about scheduling, and I'm sure I deleted them like sometime around that time, like I do with most texts.
Did you ever use Signal?
I did not, no, sir.
Why not?
I have no need to.
Why would you have a need to?
Objection.
I'm gonna allow.
I wouldn't have a need to. That's why I said I don't use it.
What's Signal for?
It's for, I think, for encrypted messages.
Do any of your colleagues use Signal to have conversations with their clients?
Objection.
I'm going to allow that you're aware.
Why?
I have no idea what my fellow employees.
He has no personal
cohorts
knowledge.
do.
Move
One
on.
of your fellow employees is a gentleman by the name of Dr. Wolf. Yes? You worked very closely with him on this case, didn't you?
I've worked with him on this case, yes, sir.
And working with him on this case, were you aware of his habits, of whether or not he used encrypted apps like Signal?
Objection, Your Honor.
I'm going to allow it.
I'm not aware of Dr. Wolf's habits, no, sir.
When you worked on this case, when you began, you worked with a gentleman by the name of Mr. Klein?
But Scott Klein is another engineer at ARCA that worked on the case, correct?
And you worked with Dr. Wolf?
That's correct, yes.
You worked as a group?
Well, I mean, we all worked on the project together. I'm located in the Pittsburgh office, and Mr. Klein and Dr. Wolf are in the Philadelphia office. So we didn't physically work together, but we worked on the same project, obviously.
When you first began your testimony yesterday, you said that you were restrained in what you could do. Do you remember that testimony?
I do, yes.
And when you said you were restrained, were you attempting like a preemptive strike because of certain things you didn't do to try to ward off any questions about that?
Objection.
Sustained.
Let me ask it this way. Were the rules different regarding your initial investigation for you as opposed to Dr. Wolf?
I don't know that they were. I don't believe they were.
Did Dr. Wolf have free reign to do whatever he wanted?
Objection.
Sustained.
Were you given free reign to do whatever testing you wanted?
I don't believe we were, no.
You, though, were you?
Was I?
Yes, were you given free reign to do whatever testing you wanted?
I mean, there was budgets, and we had to stay within certain values. So I wouldn't say I was given free reign because I couldn't do whatever I wanted.
Did anybody tell you what tests you could or couldn't do?
I don't think there was a list of specific tests or not, but you would discuss what would be done or what we could do and what the cost of those tests would be.
Were you free to suggest any tests that you wanted to?
I'm assuming I could suggest whatever I wanted to, sure.
Were any of your suggestions denied?
I can't remember. I don't know that they were. I mean, we had what we were constrained is what the client wanted to know. And so we tailored our tests to do that and tried to keep the budget and the cost of what we did in our analysis down for that very purpose.
Could you have suggested crash tests?
Probably could have suggested whatever I want.
Did you suggest crash tests?
Honestly, I don't know. I mean, it might have been brought up, but pretty sure that would not have been within the budget. So
I want you to be detailed. I don't want you to guess.
Objection, Your Honor.
So without that yeah, go ahead and just ask the question, please.
Did you suggest doing crash tests last year?
I can't remember. We obviously didn't, but I don't know if that was brought up or not.
Do you, since your memory is difficult,
Objection.
Sustained. Okay.
Yep, may we approach. This is called badgering the witness. This is exactly what this is. And this is absolutely 100% not allowed. You are not allowed to do this. And he does it after she says no comments. It's like, Mr. Brennan, if you do it again, we're going to be like, we're shutting down. Like, as soon as you hear him, Bev, say it, you should be interjecting. Alan Jackson shouldn't have to freaking say, Your Honor, object. Like, what? You hear what he's saying? Are you deaf, bitch?
She needs to admonish him right here in front of this jury. She needs to say, do not, when there's an objection and you're doing that, shut the fuck up. I can't even believe she's probably just sitting there with her fucking head back in her fucking chair, sighing up a fucking storm, waiting for anal beads to fucking drop out. I can't even fucking believe that she did what she just did. Allowing this line of fucking questioning. FBI is in all day. They open the door. Commonwealth just kicked that door open.
I think they just kicked the door open.
they're trying to discredit Welcher. I'm sorry, Dr. R. Jesus, I just did it.
Yeah. And if I'm them, I don't care. Like when I go on redirect, I'm going to say, who hired you? The FBI. Objection stricken. I don't care if it's struck, bitch. You want to low blow? We'll low blow all day. Just because I don't need to low blow doesn't mean I can't and don't know how to. I mean, come on. Did an insurance company hire you? No, the FBI did. That's how you're going to get it out. You will forget that. Strike that answer.
We're back. Oh, Jesus. Hi, Boston.
Is Double D's Boston in here?
To remember things, do you write them down?
That's one of the ways you can do it, sure.
Do you do it? Do you write down things so you don't forget?
Depends what it is.
Okay.
Let's talk about some facts. Come on, do you have anything? Do you have any facts?
You provided a CV, which is a resume.
That's correct, yes.
Resume outlines your education,
Yes, sir.
areas of specialty,
Correct.
and then it highlights your accomplishments as far as the focus of your specialty or the focus of your profession, what you like or what you do a lot, right?
Some of it, yes, sir.
So, for example, you have a number of publications that are peer reviewed.
Correct.
And peer review publications mean that you've written something that's been evaluated and considered by other experts in the industry and have been adopted or recognized, correct?
Well, that it's been published, yes, sir.
You have a long list of peer-reviewed articles dating back to 2003, is that correct?
Yeah, as I said yesterday, most of my peer-reviewed articles are all written when I was in graduate school, correct?
Have you had any peer review articles since 2003?
Probably not, no.
And your peer review article 2003 deal with the evaluation of selected electric-powered wheelchairs.
That was one of them, yes, sir.
The next one, intelligent walkers for the elderly.
Correct.
Comparison of fatigue life for 3 types of manual wheelchairs.
Yes, sir.
Evaluation of a pushroom activated power assisted wheelchair.
Correct.
Displacement between the seating surface and hybrid testing dummy during transitions with the variable configuration wheelchair.
The hybrid 3, yes, sir.
Assessment of manual wheelchair ride.
He's laughing too.
Correct. I was looking at forces and accelerations on the body. Yeah.
Fatigue life of 2 manual wheelchair cross brace designs.
Yes, sir.
Memory lane.
Evaluation of selected ultralight manual wheelchairs.
Yes, sir.
Augmentation of 100 key ISO wheelchair test dummy to accommodate higher mass.
Yes, sir.
And so you would agree that all of your peer review articles deal with wheelchairs?
Well, wheelchairs and the kinematics and kinetics forces associated with propelling wheelchairs and injuries associated with that. Yes,
There's
sir.
no one that's
Any
old
of them deal
on the
with
trial, on the jury. If there
pedestrian
was an old
collisions?
person, you would not do this.
No, they don't.
You've written a book chapter,
Yes, sir.
Smart Technology for Aging,
Yes, sir.
and again, nothing on pedestrian accidents.
That's correct.
Expanded abstracts, you've written a few.
I have, yes, sir.
Suffice to say, dealing with wheelchairs.
And assistive technology, that's correct, yes, sir.
Any have to do with pedestrian collisions?
I don't believe so, no.
Looking at your CV, you can note any area of specialty you'd like. Correct?
You can put down whatever you like, I suppose, sure.
Sure.
What does that even mean?
Have you listed any specialty as pedestrian collisions?
Well, not specifically. That actually falls under impact biomechanics, biomechanical injury causation. So I didn't list it specifically, but it certainly falls under the actual expertise that I perform.
Now, doctor, when you worked with Dr. Wolf, did you have a chance to look at his report?
I did, yes.
If you saw anything in the report that was off or mistaken, would you have an opportunity to discuss that with him?
I'm sure I would, yes, sir.
Did you find anything about his report that was wrong as far as data?
I don't recall. If I did, I probably would have talked to him, but I don't recall.
You and Dr. Wolf were collaborating together, weren't you?
Yes, sir.
And when you collaborate, you relied on each other's data at times, didn't you?
To some extent, yes.
Some things Dr. Wolf did, you relied on ultimately for your interpretation and your conclusions.
I did, yes.
Did you write a report and talked about the acceleration of the ATD, the test dummies, regarding its hands and arms?
I did, yes.
When you wrote your report talking about this very specific data, do you remember what you determined was the acceleration for the ADT right hand at 29 miles per hour? How many G's that was?
G unit,
Let's see.
50 cent.
Accelerations for the right hand.
Page 6.
Yeah, it looks like 863 Gs.
And when you were comparing data with Dr. Wolf, if something was different or off, would you correct it?
Oh, I talked to him about it, sure.
Okay. Did you ever talk to him about his collection of data regarding peak acceleration that the arm and hand experienced at a 29 mile per hour collision?
Well, when I think that 863 is from 1,000, the CFC 1,000 hertz low pass filter. And in his report, he used a lower number from a 180 hertz. So they're both accurate numbers. It's just how you actually filter the data.
So you know what I'm talking about, right?
I do, yeah.
Yeah.
And I ended up using a lower number than when I did my calculations.
Could we have Exhibit 1, please?
I love Dr. R. China.
You've talked a lot about this photograph. Do you see it?
I do, sir, yes.
And you described, well, you didn't describe, you read that these were superficial abrasions, correct?
That's the diagnosis, yes, sir.
Any of those wounds a puncture in your mind?
I don't make medical diagnoses, so I'm not going to comment on that, sir.
Well, you talked about x-rays and injury. I know you don't make medical diagnosis, but you were very careful to be detailed about what this was. Not a laceration, right? It is a superficial abrasion.
That was what was diagnosed by the medical records, yes, sir.
And you were very careful to make that distinction when you were critiquing Dr. Welch, weren't you?
Objection.
Sustained in that.
And so you also looked at x-rays, didn't you?
Yes, sir.
And when you looked at them, did you try to give the impression that you've read them, even though you're not a doctor and you can interpret them?
Objection.
Sustained.
Were you trying to interpret them for us?
No, it was actually interpreted by the medical examiner that there were no acute injuries.
So when you were giving all that information to the jury about the x-rays, was that your personal opinion, or were you just regurgitating something you had read?
That was the medical examiner's opinion, but certainly you can look at the x-rays and see that there are no actual fracture lines or space displacement between the joints. But it's the medical examiner and his diagnoses that I rely upon.
So when you were going through an explanation of all these different photographs and x-rays, you weren't trying to portray that you were giving your own personal opinion about it?
I don't give diagnoses, but if there's no fractures on an x-ray as diagnosed by an MD or physician, you can look at the x-ray and then you can see why there are no fractures. You can look at the x-ray and see where the fractures are if there's a diagnosis. So the diagnosis was no fracture, no acute injury, and that's certainly consistent with looking at the x-ray itself.
So when you were looking up the x-ray and holding it up, was that just a prop? I mean, were you simply just regurgitating what you read in the report, or were you doing a certain kind of...
Sustained.
Were you doing any kind of analysis yourself when you were sharing with us what those x-rays showed or didn't show?
The analysis is that there's no fracture or acute injury, and that's what the medical diagnosis is, and that's what the x-rays showed.
Are you giving us your opinion, or are you regurgitating what you read in a report?
That is what the medical diagnosis is, that there's no fractures and no acute injuries. That's what the medical opinion is.
So you're regurgitating what's in the report.
Objection, Your Honor.
Sustained in that form.
Did you see any MRIs?
I don't believe any MRIs were taken or performed.
In
no.
x-rays, does it depict deep soft tissue damage?
Normally, it does not depict soft tissue damage, no.
How about muscle tears?
No, it does not.
How about tendon tears?
Not normally, except you can see laxity in the joints if there is tendon or ligament tears. Normally, you can see laxity in the joints, but it doesn't show the ligament or the tendon itself.
Nerve injuries?
No, sir.
Avulsion fractures?
Yes, sir.
People sometimes get MRIs to see if there's a fracture that doesn't appear in an x-ray. Yes?
Sometimes x-rays are the best for looking at bony fractures. MRIs looking at soft tissue injuries.
Speaking of,
Bev knows all about that bone.
you've cited a number of references, a number of materials in your reports, haven't you?
I have, yes, sir.
And one of them that you've cited is forensic pathology.
Yes, sir.
This is a legitimate source to you, correct?
Yes, sir.
And you've relied on it for at least part of the basis of your study or opinions.
Well, I relied on it because it speaks and looks at the difference between, for instance, a laceration and an abrasion.
A person could be struck by a motor vehicle and not indicate any bruising to that area, wouldn't you say?
At what speed, what part of the vehicle were they contacted, what part of the body were they contacted? It depends on the amount of force associated with that. There's a number of variables involved.
Okay. Does the absence of a bruise indicate that there was no blunt force trauma to the area?
Objection, Your Honor.
I'm going to allow it. Can you answer that?
Well, the absence of a bruise, can you repeat that again?
Yeah.
You're talking
repeat
about
that.
bruising.
Yes.
Does the absence of a bruise necessarily indicate there was no blunt force trauma to an area?
No, you have to look at all the evidence and you have to look at the force. If there's 4,000 pounds of force applied to the body or to the arm, then certainly you would expect a bruise. And if there's no bruise, then you would have to question if that impact or contact actually occurred. You don't just look at that by itself in isolation. You look at all the variables and facts involved with the case to determine if an injury occurred.
Have you ever seen collisions where more than one person was hit or struck by the vehicle?
Multiple pedestrians, you mean?
Yes.
Yes, sir.
And have you ever seen in a collision where the vehicle's going the same speed when it hits multiple different people, there can be multiple different injuries?
That is so vague, and you'd have to go back and look at a specific case, look at the
That is
injuries,
so
look
vague.
at the vehicle, look at the people. You can't just say, is it possible this could occur? You have to look at a specific case and demonstrate that that could actually happen.
Well, I'm not asking if it's possible. I'm asking in your experience. Have you
I'm going to allow that.
The comments?
ever been involved in evaluating multiple pedestrian crash where there are multiple pedestrians hit by one vehicle and they sustain different or in some cases no injuries? Is that going to happen in your study?
Sure, because it depends where they're hit, what part of the body they're hit on, what the force is for that hit. The people aren't going to be hit the same multiply by one vehicle. You can certainly have multiple people and different types of injuries.
Have you seen people hit by a vehicle at a particular speed and have certain injuries, and then you've seen other cases where people are hit by a vehicle similar speed but have no injuries? Have you ever seen that?
I'm going to allow it.
So what do you mean by injuries?
Have you ever seen, in any of your cases, a pedestrian hit at a certain speed and have injuries? In another case where you look at where there was a similar type of collision.
You're so vain. You probably
So
think
again,
it's
do you mean
all
abrasions,
about
cut, laceration, fracture? Do you mean same cars? It's not something that you look for and compare
You're
between
so
cases. You have to go
vain.
back and actually study the cases and look at
All
the
about
details.
you,
Having
don't you?
experience in pedestrian collisions, you can't think of a similarity between cases as far as vehicles and speeds and totally different injuries occurring.
I'm going to allow that. Can you?
I'll allow
Do you mean
it.
hit the same way with the same type
can
of
butt
car
fuck
at
it.
the same
I'll allow
speed,
it.
with the same force?
I'm going to allow it. Can you answer it?
I don't believe
Bend
I've
over.
ever seen a case where two people were hit with the same car at the same speed, with the same force, with different injuries. I don't even know if you can correlate that.
Looking at Exhibit 1, have you done any study about the directionality of glass or broken plastic?
What do you mean by directionality?
About when something shatters, how it shatters. Does it shatter the same every time, or when plastic shatters, does it shatter differently?
It certainly depends on the impact.
Do you have any studies where plastic shatters exactly the same way on different impacts?
I doubt that it shatters exactly the same way.
It has a lot of different variables, doesn't it?
It could.
Depends on a number of different equations, doesn't it?
Well, it depends on the testing you do. If you want to see how it shatters, and if you're claiming that it shattered in a certain way to cause a certain injury, if you don't have any peer-reviewed evidence, if you don't have any research, then you have to do the testing, because you can't just say, well, it's possible it could shatter this way and cause that injury. That's not conclusive. You can't use that to come to an opinion about what happened.
Oh, that wasn't what I was asking you. I was asking you if you have seen in cases that when plastic breaks,
Stop with the
it breaks
comments.
differently.
Well, sure. The testing we've done here, the taillights covers fractured differently, and we didn't get any contact. So I have personal experience just with this case alone.
We'll
sir.
get to the contact. When you looked at all the tests you did, the plastic broke differently in each and every case, every experiment, didn't it?
Sure, it's broken like that, and I've never seen a case where you get these types of abrasions.
Oh, I didn't ask you that.
I've never seen a
Is
case.
that funny?
No, it's not funny.
Okay.
So I'm going to strike the comment. Next question. Next question, Mr. Brennan. No more comments.
When you did
this
your
funny?
experiments, the
You
sizes
guys is gonna get out of control.
of plastic that broke were different in each experiment, weren't they?
They were, yes.
The number of breaks in each experiment were different, weren't they?
They were, yes.
The angles of the break changed from piece to piece, experiment to experiment, didn't they?
I'm sure they did.
Hank's losing his
Did you watch
case.
the videos
He's
and watch the damage?
going
and
down
look
swinging.
and count how many pieces broke in each experiment?
I didn't specifically count, no. We looked at contact to the sleeve and to the dummy itself.
You never counted the broken pieces in each experiment?
I did not. There was no need to.
Not a matter if there's a need, did you?
I did not, no, sir.
You had talked quite a bit about Dr. Welcher's test with the paint, so I want to
gotta
ask you
sit down
some
and count
questions
every
about that.
fucking piece.
Were you ever under the impression that Mr. Welcher, you can take that down, please? Were you ever under the impression that Dr. Welcher was trying to reenact the actual collision when he did that blue test?
I'm going to allow it.
What? I'm gonna allow
Well,
it.
that was the only test he performed, and he referenced that test for his opinion that the position and orientation of the lacerations are consistent with the taillight cover. So if that test was not intended to signify or demonstrate the position of the arm, he has no evidence to say the position and orientation of the arm in the lacerations, which are abrasions, are consistent with the taillight cover. That's the only test he did. So if it doesn't represent that, it's really meaningless in his analysis and conclusions.
Now that you've shared your opinions, can I get back to my question?
Sustained. So.
Are you fucking serious?
Mr. Brent, I'm going to see counsel.
He wants him admonished. You just heard that? I want him admonished right now. Hell yeah. It'll fire you fuckers up. Let's go. I want to fucking fight. You know what? We've seen everything. I want to see Hank Brennan and Alan Jackson like fighting stance, like neck to neck like this, like giving like that, like they're like hard look to each other. You know, I want that. I want a shirt that says,
Admonish him.
No, I just want to. I'll allow it. I'll allow it. I want to say I'll allow it, and I want Hank and AJ, you know, fist to fist like this. I want to fight. Okay. This has
Oh, so
everything
they're
other than a
removing the
fight.
jurors.
I want to fight.
I can't believe they're removing the fucking jurors right now.
What if
This is
that was just like, you know what? I'm calling a mistrial.
She needs to.
No.
She's wasting time.
No, I'm calling a mistrial, and we're gonna redo this in about 6 months.
Oh, with prejudice?
Yeah, because
I mean, without prejudice, you mean?
This is welcome to Karen Reed Day 31. This is a non-lawyer coverage with F-bombs. If you don't like it, get the fuck out. This is a non-lawyer with F-bombs. Are those birds chirping?
Yeah, we're back.
Yeah, I'm just not feeling it right now.
And
We're back. We're back doing what?
We're together once again, my love. I don't know. Ted Daniels looks like he packed it up and is heading out. So I have no clue if he's going to TB or what's happening here.
TB?
Turtle Boy's hearing. I have no clue what's happening.
I'll tell you what's going on in Turtle Boy's hearing. Oh, they just showed a picture of his cock.
They're of Hank's cock. I don't think
No, Turtle Boy's.
Oh, in the trial?
Yeah, they're saying that Turtle Boy was intimidating people with his cock. So.
Oh, that's why he calls it the Intimidator. So they removed the back row. Is the back row the Commonwealth helpers?
God, what the fuck? Who is this?
So it will be the lunch and recess and will take an hour.
All rise to the court, please.
Okay. So they went to Sidebar and they went and removed the jury. And now she's like, okay, we're just going to go to lunch and it'll be an hour.
Well, I think she's just letting that know now. She's going to like come back on the record because does AJ want to like say stuff on the record? I think AJ's saying he's going to ask questions or what can happen? Like what's some case law on this? Hold on. I want to look this up. There's got to be case law on this.
Thank you, Dr. Latina.
Dr. Latina, let's look this up. There's got to be case law on a lawyer who keeps badgering
over objections.
Badgering the witness refers to a situation in a courtroom where a lawyer aggressively questions a witness in a way that is unfair or intimidating. This behavior can undermine the integrity of a trial by intimidating or confusing witnesses, potentially affecting their testimony. Examining case studies where badgering the witness was a focal point offers valuable insight into its legal implications. We know that, but we want to know how we get stopped. Like, I believe that you can, here we go. Wilson versus State.
What's the state? Did you look it up in Mass?
Fucking Texas. I'm getting out of there. I'm not looking anything up in Texas.
In Texas. Okay. I'll tie.
This is totally unethical, but what can happen? I mean, he can get. I think that they're going to be reporting. Okay, this is what I think is happening. I believe that Alessi, AJ, their whole team is going to be. They're going to be 100% reporting Hank to the bar.
They need to.
And they're going to cite all of this shit, and they're going to make a. I think they're going to make a a spectacle out of him, as they should.
Well, and they also need to report back.
He's committed so much misconduct. It's not even, I mean, go for his license, motherfucker.
Hell yeah. Sanctions and dismissal from the bar.
Yeah. Okay.
And Bev.
Personal attacks, ready? So
Which is-
badgering the witness refers to aggressive and harassing question tactics employed by an attorney during cross-examination. This behavior is not only unprofessional, but can also be damaging to the credibility of the attorney and the case they are representing, but not if she's not admonishing. Then it doesn't look like anything's wrong. Let's take a closer look at some examples of badgering the witness. Personal attacks. When an attorney resorts to personal attacks or insults towards the witness rather than focusing on the facts of the case. Oh, man, isn't that what you just said? It can be considered badgering. For example, belittling the witness's intelligence or character instead of questioning their testimony. Repetitive questioning, continuously asking the same question in different ways in an attempt to confuse or frustrate the witness is another form of badgering. Yep. This tactic does not only waste time, but can also reflect poorly on the attorney's professionalism. But he's not getting admonished. Intimidation. Using aggressive body language, tone of voice, or making threatening gestures towards the witness can create an intimidating atmosphere in the courtroom. This behavior is unacceptable and can lead to objections from opposing counsel. Yeah, but nothing's happening. Badgering through sarcasm. Employing sarcasm or mockery towards the witness can undermine their credibility and make them feel uncomfortable on the stand. Attorneys should focus on obtaining relevant information through respectful questioning. Yeah, he has nothing. He can't do anything. He has nothing to refute anything that he has. And so therefore this is a perfect example of that kid whose parent, right? Like, there's nothing worse than a disrespectful little snotty little shit. Your mom didn't teach you any manners, and then she didn't even fucking wipe your nose. She's shit. And now you've turned out to be a shitbag too. Shit's creating little shits. So what can happen though, right? I want to know how we do this. Legal implications. When objectable behavior such as badgering the witness occurs during a trial, it is crucial for the opposing counsel to raise timely objections. Common objections in response to badgering include badgering the witness, argumentative, repetitive questioning. These objections alert the judge to inappropriate behavior and give them an opportunity to intervene and ensure a fair trial. Strategies to avoid badgering. To prevent badgering the witness, attorneys should prepare thorough and relevant questions in advance, Hank. 2, listen actively to witness responses and avoid repetitive questioning, Hank. Maintain professionalism, Hank, and respectful demeanor during cross-examination, which he is not. He hasn't. Alessi and them, even though they have the tools that they've had up there, they've been beyond respectful.
Well, and that's the thing, that he keeps making those side comments, and Bev just sighs around and says, okay, just don't make those comments. No, dude, like, he needs to be admonished.
No, and what ends up happening is we're going to shut down the cross-examination. So you're done. And I think that's what Alan Jackson is saying. Ask relevant questions or shut this down.
Yeah, and stop commenting. Knock off your little comments. Oh, did you really eat your ham sandwich? Who cares?
Remember, Hank, if you would have just prepared thoroughly, and if you would just remain calm and respectful, and if you would just listen, and if you could just focus on the relevant information, you could do it. So
you could do it. The problem here is he didn't ask Renschler, his own star witness, any of these questions that he's.
It is essential. It is essential for Bev to prioritize fairness and justice in every step of her legal processes. What a fucking cunt.
Yes, Murky, it is. It is Bev's responsibility to control her courtroom. And that's why she needs to be brought up on sanctions and disbarred. And she needs to resign. But like out of the country.
Disgusting.
It's
disgusting. I mean, we could go back and count them. I mean, like literally everything. let's see. You're I want to call Hank's cell phone right now and say you badgering beaver bastard. I want to know what can happen during the proceeding though. Can anything like really, really like boom? Like give me something good.
I literally need
Like I
them
want
to
to
come
hear
back.
that. Like
We're done here. Nothing to see. Commonwealth didn't prove their case. Moving on. You didn't ask Welcher. Do you think this is lost on the jury? That Hank didn't even do this with his own star witness, put his star witness up there with yellow and blue paint all over an arm while he's hugging some fucking dummy mannequin? Juddy buddy? The hell is wrong with these people? You're so diligent right now, Hank, in trying to ask and answer. Poor Dr. R had ham in his mouth when he had a conversation, if he smiled, if he had his back up against a wall or had a foot up or whatever he fucking did. Why didn't you ask your fucking witness how many actual real scientific experiments he did that you hired him to do? Aperture? I don't get it. Then you have these people.
I have a question. Can Renschler say, Your Honor, I refuse to answer any more questions as I feel harassed and intimidated? Can you ask one of the other lawyers to ask questions?
They think you're giving him ideas. Can
No,
he do that?
I think there's a way. Hold on, I'm researching.
Okay, but it's always going to come down to discretion of the judge if she
I
allows.
don't care, but it's on the record. Say that, and then he's gonna be like, "Did anybody tell you to say that when you were just out there having some ham sandwiches?"
Oh, you mean Dr. R, not
I think that
not Welcher. Okay.
a Dr. R needs to state to the judge that I feel Your Honor, I'm sorry, but I refuse to answer any more questions due to the fact that this man is harassing me, and I would like to put him for a civil protection order. Can we stay the proceedings?
A CPO. I need a CPO.
I would like a CPO on this man. Can you get one of your other shim-shams over there to ask me these questions?
I want Lally.
Yeah. Can we get Lally to ask these questions? I just think that they should make a big deal about it.
I want
This is
Tori.
ridiculous. I think a big deal should be made. I want there to be some controversy.
I will
start speaking out there. Renschler needs to call a lawyer. Get some legal advice.
Arca should be right now like calling in their lawyers right now, because he is trying to undermine his credibility as a witness by talking about ham sandwiches. It's totally inappropriate. And there's Bev sighing and letting it happen. You don't get to do that. You don't get to suggest to the jury that he broke a sequester order because he was ordered to talk to the FBI, but you're not allowed to say it. So you open that door, Hank. And do you want AJ to rehabilitate him on redirect? Okay. So he gets to say, when Mr. Brennan asked you if you broke the secret.
Okay, I have some information.
Hold on a second. When that was asked of you, who was the employer? It was the FBI. Aren't you required when the FBI asks you to comply to do so? Yes, I had to comply. End of. Go ahead.
Oh, can I?
Yes.
Thank you. A witness can refuse to testify if they feel badgered, but they cannot decline to testify altogether. If a witness refuses to answer questions after being ordered to do so, they may be held in contempt of court. So I think that all they have to say is, I will answer questions, but not of this man. Like he has 3 other lawyers right there. Pick somebody else. I think that he might have some. Yeah. I think he could say, I think he could probably get away with it. These people suck all. Suck all. Jeez. So basically all today is going to be is right here. Is today's Wednesday. And then Hank is going to be able to use what? Thursday and Friday for his rebuttals. And you don't get sir rebuttals in Boston. So
You don't get to serve rebuttals, like as in dinner rolls? What'd you say?
it's called a sir rebuttal.
Oh, a sir rebuttal.
Yeah.
I
Yeah.
thought you said serve rebuttals. I
No,
think I'm hungry.
Yeah, go eat. All right, guys, remember, we are on a lunch break here, over here at good Dedham, Massachusetts. All right, let me pull this back up. Let me look at your guys's. I got to use 2 devices here. Okay, what do we have in chat? Thank you so much. I can't even highlight it over here. This is nuts. This better be the fastest not guilty. Because if you would ever say guilty when you're like, you're watching this, like Hank, like, I mean, I just feel like Hank, there's like, he has nothing to lose. He can do whatever he wants. Like, he doesn't work for any, like, what can happen to him? Absolutely nothing. But can there actually have something happen to him? And you'd have to go after his bar license. And I just hope that AJ and them do it. I hope that they do. I hope that they serve all of this to the bar. And I think that this is all grounds. Like, he's walking. Yeah, maybe nothing's going to happen to you with Norfolk County District Attorney's Office, okay, and blah, 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 but who's hiring him after this? I think he thinks that he's running for DA. So I would just end his career. Let's end it. Yeah. I agree, Gina. This is very embarrassing. Let me write this on the screen. Just so we're clear, not one question has been asked about, like, meaningful questions. They all have been about, let's see. How long did he eat his ham sandwich at a table? Were you aware the defense paid the bill? Do you enter your billables? But I'm a salary employee. I had a ham sandwich. I sat at a table. Did you take an Uber? Did you want to portray to be independent here? Is that part of it? How did you travel to the trial? Did you talk about planning, scheduling? Was somebody telling you about what was going on last trial? Your employer was feeding you information during the trial to tell you what was going on? What kind of communication were you having with the defense? Were you using text? Did you use Signal? Did you have any text messages? Wasn't there an order that you were supposed to preserve those and you didn't, right? You deleted them? Do you have any personal knowledge of what Signal is used for and why Dr. Wolf would communicate and what his communication habits are? Did you know that there was reporters with cameras watching you eat your ham sandwich? and you went and stood in a corner and you were standing there waiting and you were laughing and chuckling with other people about a year ago, and you were making fun of the prosecutor for the questions he was asking you, and you were getting a good laugh at his expense. Did you guys have different rules, you and Dr. Wolf? Did you get, were you just free reign to do whatever you wanted? What kind of tests could you do? Who decided those tests? How about the cost analysis? Were any of your suggestions ever denied? Did you use crash test dummies? Did you do a crash test last year? If you write things down, since you have memory problems, would it help you remember things if you wrote things down? Now let's talk about your CV. Let's see, 2003, you had written work about wheelchairs? Mm-hmm. Nothing on car crashes though, right? Like that's what the fuck we've heard so far. So in case you wanted to know what the hell's been going on, there you go. That's our cross-examination and about 10 objections to badgering the witness. And Bev's allowed it. Yes, Jax James.
It's like I'm on East Coast time because I'm eating lunch and it's 10 a.m. It's like I'm on East Coast. Oh, Jesus, I hate that. It's a pet peeve. That is a big pet peeve. I was just listening to you. While I was getting lunch. So you guys heard Lana go through the questions for the recap of what Dr. R was asked while he was up on the stand by Hank. Sheesh, you guys. I don't know. If we want to apply real case law, we got to stay with mass. And I just think this is setting precedents left and right here, this trial, and it will come up in its own little footnotes in case law moving forward in other people's cases. And hopefully, you guys just think about, some of you have probably already thought about this, but think about the misconduct of the officers involved in this. And the notable one, obviously, is Proctor, okay? That means every case that Proctor has been involved in, they are going to be able to go in and have a great argument that those cases need to be thrown out. And some of those people might actually be guilty. Maybe he didn't cheat to get certain people in prison or jail, whatever. But can you trust someone like Proctor? Hi, Valentina. Are the charges against KR identical to the last trial? The charges this time around? Yes, they are. The CW wasn't smart enough to hear what the juror who came out and spoke about it said and how the form was confusing, as AJ Amianetti spoke on before. And she had like some kind of like snarky remark about, and so they didn't amend the charges because they are so steadfast in the corruption, and they've done this for so long. They really believe it's going to work out for them. And it's not going to work out. This is egregious. It's being done in front of our faces. And let's just go, the worst case scenario happens and she is found guilty. This is going to have it's going to have such a big movement. You think the movement to free Karen Read is big right now? In 1 year, I have seen law enforcement, local Massachusetts law enforcement, their minds change. Law enforcement that I speak to in Massachusetts, in 1 year, I've seen them change from, she's guilty, to, oh my God, she's being railroaded. Draw Latina, this is part of their problem. This is part of the CW's problem. They're not doing anything that's legal, logical, makes any sense, which tells me they're used to running things this way. Norfolk County. It's scary. I don't understand what they think they're gonna, by saving face, and it is just so disgusting what do you guys understand? You guys all do, because you've been here and you guys are smart. It just blows my mind that they planted taillight evidence in order to get somebody they had a hard on for thrown in. to prison. And I don't want to hear about there was no probable cause to go into Albert's residence that night. There's a dead Boston police officer on your front lawn. Don't you, as Alan Jackson said, don't you want to go in and make sure they're okay? But do you know what happens in life? You don't ask questions when you know the answers to them, unless you're a lawyer. You don't ask those questions. So they knew that the Alberts were okay in that house. You look for things that are not asked, and those glow and shine at night. Like, nobody went in to the residence to do a welfare check. There is a dead police officer, a Boston police officer. The owner of this house is a Boston police officer. What if there's somebody killing Boston police officers around here? Do we not want to go in and check on another Thin Blue Line member? No, we don't, because we already know the answer to that. We know he's okay. We've already talked to him and established it. It's been established. That's how you get to where we are today, is because they know what happened and they didn't do it because they know he's all right. Everything's all right. He didn't sleep through this. And that whole area, there is so many law enforcement officers that live in that area. And we know the person across the street where there's missing, ring cam footage was a police officer where they got their little solo cups, right? And we are told to just disregard the evidence collecting in this case. We're told to look over there. Right now, with what we're seeing today, we have a witness who takes the stand and says, these injuries do not line up with the injuries that John O'Keefe had on his body. And now we have Hank, who is supposed to be for justice and truth, saying, hey, but look over here.
Guess
But
what?
you do wheelchairs.
Guess
Who
what came?
cares what came?
My brand new
Your
modem.
microphone.
No, I have all that. My brand new modem. That's what I needed.
Yay.
So, haha.
A day early.
What's today? Wednesday? It's supposed to be a Friday.
Oh, I thought it was supposed to be there Thursday. 2 days early.
Yes.
It's the unboxing.
Yeah, Daddy, come fight me.
Lana's got a new baby. I'm gonna. If you're gonna talk, I'm gonna eat.
Oh, I'm not talking.
Oh shit. Okay.
I'm just excited because all my shit will be better.
Mm-hmm.
It'll be done. Yeah.
Better and clever.
No excuses. Oh, there she is. That's beautiful. Oh, she's so pretty.
What color is she?
One's white and one's black.
What? You only got one modem.
I got everything. I wanted everything new. I got everything.
You got 2 modems?
I want a new router modem, and I got all my, because I have like that, all the home stuff, so like I could be anywhere, and I could be like down the street. Well, not like down the street, but like, my shit connects like when I'm pulling onto my street.
Thank God, because on your porch it doesn't.
What?
Because of your modem, we didn't know that was what it was.
Okay. Number talks. Okay.
I don't know
Oh,
why
Hail
was
Murphy.
left off before LO. But so we're told it's all obfuscation. Like, look over there. Why don't we concentrate on the papers that you wrote about wheelchairs instead of asking the real questions and get to the truth of the matter? It's like you want to avoid it, Hank, and it's glaring. And that's what we're seeing. Full display. She said we're only taking an hour lunch today, and we will be back. In front of them, she acts all hard, a bit soft to the jurors. Like, I'm just looking out for your best interest, jury. I'm just here for you all day, every day. No, Bev, you are a big part of the misjustice that's happening in your courtroom, and you need to be held accountable for that. You need to answer to that. And I wish there was like the equivalent of a court-martial in the military, and Bev had to stand up and answer to a panel of judges, and I hope that is legitimately what happens. This is an embarrassment to our legal system. So I'm going to look up what everybody is saying. If I can see, like, if anyone read the jury today and what they think about the jury. I want to know who was in. So we saw Ted, right? Let me see. Let's see if Ted talks about TED Talks. Let's see if Ted talks about the jury at all today, because I really want a temperature read on them rectally. Okay. Ted said 40 minutes ago. Hank Brennan says, does the absence of a bruise necessarily indicate there was no blunt force trauma to an area? Dr. R says, no. You have to look at all the evidence, and you have to look at the force. You don't just look at it by itself in isolation. Brennan asking Dr. R about his contact with the defense and coming to testify in the first trial. Hank, when you had conversations with the defense, did they offer to give you transportation assistance getting here? Dr. R, they provided a ride to and from the airport. Yes. Hank, and did you tell the defense that you prefer to take an Uber so that it would appear independent for a very Dr. R, no, because I didn't take an Uber. I took their ride. I forgot about that. I forgot about the Uber line of questioning. Hank, who cares? Literally. His work is solid. It's scientific. You can't refute it. What are you going to do? Now bring up Welcher. Bring up Juddy Buddy, the crash test dummy at 2 miles an hour. An embarrassment. What an embarrassment. Oh, that's right. Okay, this one. I'm glad Ted got this verbatim. Hank Brennan is crossing Dr. R. Hank Brennan, you have no idea where the point of impact was in this collision, do you? Dr. R, nobody does. Hank, I'm asking you. You don't know. Yeah, and neither did your little tofu dick boy over there, Welcher. In fact, he propelled his arm towards the SUV, not the other way around. So if you want to talk about details matter, facts matter. The fact is that your star expert witness, who you want to cuck for all day long, propelled his arm toward the SUV. He didn't stand there. And as Dr. R testified to, when you look at a still from the video from Aperture and Juddy, the SUV's taillight would have never even impacted his elbow at all. He moves his arm to the location where Juddy thinks it's going to be best served for what he's presenting and charging for, which is a big padded pad between his legs. Okay. Ted doesn't talk about the jurors. And I know that Aiden wasn't in because he has his own thing going. So, but, you know, when I just feel that this jury is not taking kindly to Hank and his line of questioning with these witnesses that have resonated with them so well. Yes, Gen History, Fuzz Admin. Yeah, you change a little bit of any variable, it changes things. And you know, that should be the line of questioning that Hank, if he wants to be smart, he should say those kinds of things. Like, you guys did it at 29 miles an hour, which already got asked already. But like, you know, I don't, when he asked Dr. Laversada about the data yesterday, and she's like, what data? What data? What are you talking about, Hank? Like, he doesn't even know the answers to his own questions when he asks them. I don't know what your common sense is, FGF, but you just made me laugh. You got none if that's what you think. Common sense. I'm sorry, science trumps anything you just said right there. I think Karen is going to own so many people, and I'm here for it because what they did to her is disgusting. I love it. You cannot refute this evidence. There's no way. You have to check your confirmation bias at the door. You have to check yourself and ask yourself if you're mentally sound, if you can sit there and listen to this and still think she's guilty. Don't do whataboutism with me. You're about to get blocked, honey. If you can't stick with the argument, you're lost. See ya. At least have an intelligent argument, please. I don't ask for a lot. Don't come in here with stupid stuff. It's not going to stand. You just have to be so dim-witted. And I feel sorry. I feel sorry for you that you can't check your confirmation bias at the door and have any self-insight. I love arguments. Give me a good one, honey. Give me a good one. I'll buy it all day. You don't have to ever agree with anything we say here. It's not about that. It's just about being smart, evoking thought, adding to the conversation. If you're not doing that, why even breathe? You know what I'm talking about, girl. You're struggling. I mean, every day in and day out, when Hank gets ready to to get in there, I don't think he breathes like a good sigh like Bev does. So Bev should give Hank her formula for it, as he needs to like have a solid shit. I don't think he's had a meaningful one in a minute. So Ted Daniels does not tell us anything about that, but let me see who else was in the courtroom today. I don't know. I think that Aiden having a trial kind of impacts this. Let's see, like maybe he got word or something. Let's see if we can get some dish. All right. Oh. Okay, Aiden. I'm not going to say that like loud, but okay. Weird. Okay, so he's dealing with his own stuff, so he's not commenting on Cammy today. I don't blame him. Who can when they're dealing with their own stuff? That basically sparked off because of this trial. I just want to eat some lunch at 10:30 a.m. and so what do you guys think? She's taking a short lunch. Let's see when she'll be back. Marky says, for real, your debate at least needs to hold some kind of possibility. Not just words keeping up with the fray. Oh, girl, you know how it is. It's a struggle out there for so many people. Their brains can't keep up. You got to feel bad. Jen, it's about having thought-provoking ideas that are based on the facts. And Gilchrist can't produce that because they don't exist in this case. I mean, look, okay, for the first trial, I could see for the first trial people being like, I don't know, blah, blah, blah. After everything we have seen, what sick society do you live in to be so committed to your stance? I mean, just say you changed your mind. There's grace in that. It is bizarre to just keep going down the same road and not be willing to look at your failures. No way can you look at this case and say, by the degree that she needs to be found legally guilty beyond a reasonable doubt, that they've met their burden. They haven't. The Commonwealth has a theory. They haven't proved it. Move on. We're done here. And I think it's incredibly disgusting that this farce is going on, and we are being gaslit, or the defense is being gaslit by saying the jury's time. No, Bev, the jury's time is being taken up because of you and how you run your courtroom. I have no respect for that. And I can tell the defense is at the end of their wits with their respect, and they have lots of respect, lots of decorum, lots of class. Lana got her new modem. She's putting it up, you guys. You guys are going to get some. Oh my God, I almost called him Hank. Wait. Hector. I have Hank on the brain. Oh my God, you guys are going to get some Hector probably today, but possibly tomorrow. It's coming. It's 2 days early. So exciting. Meanwhile, Los Angeles is on curfew at night at 8 p.m. because of what they call rioting. Gotta love it. It's getting hotter. Everyone's tits are out. We just got to do the right thing. Yes, Amy Jade. That's the thing. It is our civil rights. And but beyond, like, she is up for freaking murder. She's up for murder in a frame job. Would you guys want her? You guys want her to like roll over and just take it? This is like a third year class now, like a 300 level class on sticking to your principles. It is just absurd. Oh my God, Murky. It affects all of it though. The 110, like, oh my God, talk about an artery through the city. I don't care though. I don't care. I mean, like, whatever. But yeah, it's just funny because they sent it out. They sent out the notices to LA County residents at 8:07 p.m. Okay, last night, talking about it and saying that the curfew started at 8 p.m. Like, like, okay, wait a minute. So you're 7 minutes lagging. Like, you didn't think this through very well. Yeah, but you can, if you're going to and from work, you can still do that, supposedly. And it's only certain areas that have been impacted. But like, we're a hose hair away from martial law, probably. I'm just not following it right now because we do this and then it's time to mellow out for the day, for the night. I just cannot believe that Bev is not going to get on her gavel and pound it and say, thank you for your service, jurors. You can be excused. I'd like to declare a mistrial here because this is completely a farce. And I don't want to be responsible and have my head roll along with Morrissey's. Morrissey has her strapped and loaded, licking his boots all day, bent over as much as her body can flex. Licking those toes, not boot. I appreciate what Dr. LaPrasada did yesterday and how calm she stayed and how she schooled Hank and how he mispronounced literally every word. I think even coup contra coup, he pronounced something. I don't even know. I have no idea how he did it, but he just was like mispronouncing left and right. And she, at one point, just started giving up, like correcting him. She would just kind of like smile, like, very, very slightly, and not to be disrespectful because she has class, apparently, from what it seems. She has a lot of class. She's very dignified. And I think that she resonated with the jury. She did, JC, for me. She did. She was holding back So many giggles. That's important, you guys, because you get in there and you have these 12 strangers who all think differently, but these are professional witnesses who are there just to tell the truth. They're not there because they're paid to say a certain thing. They know what they're talking about. They have confidence in the work that they have done. And it makes a difference when it comes to how the jury responds. Hi, Lady Leo. I don't know. I don't know if you were. Sometimes I don't know what you're necessarily talking about, but sometimes YouTube has a mind of its own and doesn't let things in. 1 second. Let me see if I can see chat on this end. But we can see you right now, so that's good. Because it's different on StreamYard. Like, it's so different on StreamYard than it is on YouTube. So I have both open now. Yeah, so she had grace and very, very likable personality, very relatable. Yes, Jalatina. Yes, that was one of the words, the Glasgow scale. Yes. And he almost mispronounced basil, like, you know, like in like the brain, but like a basal fracture, but he got, I think that was the only word he got right, medical word he got right. And I can't. Oh, really? No, I don't know why it would disappear. It might have been an accident. I didn't see it. I'm sorry, but we'll put it up. And he knew it was a dog attack. Your 11-year-old. No, you didn't say anything wrong. You're still here, Lady Leo. We're good. Yeah, sometimes YouTube's been like really bizarre. Sometimes like chat. Yesterday I was like, wait a minute. my chat froze. It's so typical of YouTube to do weird things. Did you, Draw Latina, as a medical professional, did you appreciate how Dr. La Prasada explained things? Because it was like, explain to me like I'm 5, right? I need that. It's a very intelligent way to explain things to people when you are an expert at something. Because you can talk in your words that you use and nobody's going to get it. And it can come across condescending. But if you just break that down a little bit for people, it goes a long way. Oh, he did. He really did. I thought I heard it, but I thought he got it right. Basilar, and he kept saying it that way. And she corrected him gently and said, basilar, skull fracture. So I'm saying it wrong too then. That's probably why I thought he said it right. He needs to do it right because he's an attorney up there speaking Mike. I don't know. Yeah, I think she did keep the jury's attention. And I think that that's kind of what has been happening with the last significant witnesses that we've had. You know, Dr. Wolf, definitely. I read that with people that were in the courtroom, that he, you know, the jurors were smiling at things he said and were very engaged. And basically, when Hank was kind of going at him in a very rude way, jury members were wincing at that. They didn't like it. And that speaks volumes. And that's why Hank needs to read the room. I mean, I'm glad he's not reading the room. Please continue. Don't read the room. It's only going to help Karen. But I mean, like, how out of touch, or maybe it's like, how committed are you to not exposing what the fuck you guys did? How committed are you to this travesty, this lie? And that's what makes it disgusting. Because right now, your oath as an officer of the court dictates that you stand up for what's true, and your line of questioning, Hank, is anything but that. Ham sandwiches, Uber rides, nobody cares. Basil. Oh, so it's like basil, as in bad. Basil. He literally got every medical term wrong, and and that was a good term for it. Draw Latina. It was gentle. She was really gentle in every way. Even the tofu comment. And the brain, like, have you ever held when he was like, have you held a brain in your hand? And she's like, I'm not a neurosurgeon. Oh, you're not a neurosurgeon? No. And the people I work on, they're usually deceased. Like, I can't. But she was really gentle with him, and that's a good term. It's the brain, like soft tofu. And she goes, ew, gross. And so the jury liked that. Tofu peen. Stacey Ryan, what you say, honey? You talking jurors? I needs to know. 9 jurors wrote down that Dr. R stated the aperture blue paint test proves nothing. I don't know if you're joking or not, but that's what I see happening. I just like it's an eye roll in there. Murky, I don't know what they're doing. They're probably just loud because they're crazy in the spring. I know. Okay, hold on. Let me see if I'll try to shut this window. That probably will do it. It's going to be like, OMG. Okay. So, Draw Latina, if you weren't here yesterday, or maybe it was the day before when I said this. So I had read people saying that live in the area that Dr. Laprasada was really instrumental in finding the cause of death of their loved ones that went unnoticed with other people, like whoever else looked at it. But she found the real cause of death, which ended up being something that ended up saving members of their family because it was a genetic thing that was happening. And I think that's powerful because it's not like, oh, she's just some like Hank, like you wanted to be independent. Like she's not just some like hired gun that you bring in and she just works for you if you're wealthy. It's like, no, this is her job. And she knows what she's doing and she's really good at it. I think it speaks to how stacked her CV is. And she's a wonderful, wonderful woman to listen to. I just liked her demeanor. And she's witty, you can tell. You can tell she's incredibly witty. That's right, Michelle. That's right. I do wish that came up. She was hired by Hank for 3 cases he did after the Rhode Island station fire. And you know what? The state uses, and I don't know if that was hired by Hank in the state capacity as a criminal defense attorney, but the state has used her. And that's the thing. When the defense uses an expert witness who is used a lot by the state, you cannot then come and say and question their expertise when you have been good using them. It is redunculous. And that's kind of like a save when you're a defense attorney, is doing that, because then on, rehabilitating, so on redirect examination, that's something that you would bring up. It wasn't brought up, or I missed it. It wasn't brought up this time around. I don't think it was necessary. I think Dr. Laprasada had so much grace that it wasn't really necessary to rehabilitate her in that way. And I just don't know, but no matter what the outcome or what anyone's theories are about anything here, the Commonwealth did not prove what happened. Their theory, which is Karen Reed struck John O'Keefe with her vehicle in reverse at 26 miles an hour, clipped him so perfect, like this perfect freaking shot, perfect shot, which by some accounts, she would have hit Higgins' Jeep with the snowplow in front of it. But regardless, let's even say Higgins' Jeep wasn't there. She did this beautifully perfect backwards reverse motion and clipped him just so. And then just peace out, I'm going home. No reason, no rhyme, no nothing. And then you have witnesses who, according to their testimony, it would have been before, right? Before she reversed her vehicle. If you're new to this case, before she reversed her vehicle, she's sitting in her vehicle, hands at 10 and 2, Ryan Nagel said, hands at 10 and 2, and there's only one occupant in the car, and that is a female with long hair, Karen. There is nobody sitting in the passenger seat at the time. There's nobody standing outside of her vehicle, nobody walking up to the door of the Alberts house, and nobody on the lawn. I mean, it wouldn't have even happened on the timeline yet, but nobody on the lawn. So where was John then? Where was John? In the gas tank? On the floorboard hiding? Where was John? We heard from John and Karen's friend. We had heard from her in trial 1 as well. Colathesis, I'm totally butchering her beautiful Greek name, saying that it was a great night. They were getting along. That Karen didn't seem inebriated to her. She seemed aware, full of her faculties. And this is somebody who is a pharmacist by profession. It's important. All of these facts matter, as Hank likes to say, but avoids in his own things. In his own questioning. Why aren't you prepping your witnesses like this? Okay, I cannot wait for the rebuttal of Welcher. And while he's going to be limited because a rebuttal witness, you're bringing them up to rebut something the defense put. So it's very limited in scope as to what you can ask them. But I don't care. The guy is a joke. He's actually a comedy routine. I hope SNL picks up on it, but they probably won't. Maybe we can all just create our own SNL highlight reel from this case. But I mean, come on, man. Like, the guy is like a walking comedic joke. with no timing. I mean, he ran himself into an SUV. The SUV didn't run into him. He ran himself into the SUV, you guys, at 2 miles an hour. I mean, we don't even know if it's 2 miles an hour because he was running at it basically, walking, whatever the word is, the action, the verb is. He was going towards this SUV. And you're not supposed to do that. Why aren't you using Rescue Randy or a crash test dummy? Is she late, you guys? We're on bedtime. We're only going to be an hour. So when we left, we'd taken a sidebar because Hank was being gross and improper, incredibly improper. You guys, and you know what? If Hank wants to go down this bizarre line of questioning, why didn't he ask Welcher where the yellow paint was? Did you only take one photo, Welcher? Why? God, I wonder if his dick has yellow all over it from his hand being painted yellow. You know how, like, if you're like, I don't want to say that word for it. I need to find a word for it.
You are unmuted.
Oh, we're back. If you're a scaredy cat, they call you a yellow belly, yellow dick.
Court is now open. You may be seated.
All right, while the jury is on their way in, I need to see counsel at sidebar.
Oh, we're going to go to sidebar right away. Here we go. Like to see you at sidebar. Wait, but wouldn't Cheetos be, you guys? Cheetos would be orange. He did this in yellow. He did it in yellow, and his penis is probably yellow because he probably can't stop, like, from wanking off, or when he, like, goes pee or whatever, because he just looks so messy. He probably didn't wipe his hands. Oh, that's a pretty color blouse. Is that a new person sitting in the front row? Same, Bella. Yes, V. Yes. I don't want to think about his penis, though, but I don't mind thinking of a yellow handprint on a stick that could resemble his penis. We're back, you guys. Lally.
Please rise for the proof.
Okay, so I guess they're bringing the jurors in, and that's why we're back on the fan. I'm guessing. We'll know in a second when they say, all rise for the jury. And he was LARPing. He was live action role playing as a crash test dummy.
All right, Mr. Brennan. Jurors, hopefully it'll be comfortable enough in here this afternoon. The court officers has done a great job keeping the AC going while we were out of the courtroom. So.
Dr. Renschler, you wrote a report back in February 2024,
Yeah, that's correct, yes, sir.
and in that report you provided a number of opinions, didn't you?
I did, yes.
Do you remember if you opined or had the opinion that the injuries on Mr. O'Keefe's arm would not result from impact with a non-damaged tail lamp cover?
I believe that's correct, yes.
And the amount of force required to fracture the tail lamp cover would result in extensive soft tissue and likely bony injury to Mr. O'Keefe's right arm?
Correct.
And so your opinion back in 2004 was that if a person's arm were to cause the damage to that taillight on that Lexus, you would expect to see extensive soft tissue and likely bony injury.
Yes, soft tissue referring to ligaments and tendons of the elbow and shoulder, correct, and the wrist.
And so you're saying not superficial abrasions, but in the arm?
Yes, when you look at, and you can see from the testing we did for this case, for this round, that the arm extends and you have contact with the arm, you would expect at those speeds damage to the tendons and the ligaments, the elbow, the shoulder, likely the wrist.
In the x-rays that we looked at, or that we saw, and you offered the words of the medical expert, there is no MRI studying any ligament damage, is there?
There are no MRIs that I'm aware of, no, sir.
And x-rays wouldn't fairly depict some of those internal injuries that you're referring to, would they?
As I described before, it can show laxity of the joint, but it normally doesn't show the actual soft tissue damage itself, no, sir.
And a crash test dummy is different than a person, isn't it?
Certainly it is, yes,
No
sir.
muscle,
That's correct.
no ligaments.
That's correct.
The crash test dummy does not react or respond like a human being.
Well, it does to a certain extent, yes.
There are differences.
Certainly there are, yes.
And so when you're looking at a crash test dummy, you can agree that there are significant differences between what you might see on the dummy's arm and what would maybe happen to a human being's arm on the inside.
There can be. That's why you have to look at the acceleration and the force, and that's primarily what the ATD is utilized for.
But focusing on the actual observation of the arm, you would agree, doctor, that looking at a crash test dummy arm is not comparable to actually looking into a human being's arm with an MRI and seeing if there's any damage on the inside.
No, of course, that they're not the same, no, sir.
You were speaking about references earlier. You did have a chance to see Dr. Welcher's report, didn't you?
I did, yes.
And in his report, there were a number of references, weren't there?
There were different references, but I think maybe 26 within his report.
In addition to his references, you were sent a number of gigabytes of information, weren't you?
I was, yes.
And in those gigabytes, there was different references to different materials, wasn't there?
Well, first of all, there were only 26 references in his report that he cited to for his opinions. There was material contained within the batch of documents that they sent over. There was a bibliography or CV of different papers that he had submitted, I think 20 pages of papers that weren't referenced in the original report. And the most recent paper in that AutoPed packet was from 2004. Most of them were from the 60s and 70s, but there was an additional packet of information.
When you read his report and saw his references, did you look up the references?
I did, yes, sir.
Okay. And when you were saying earlier that there was only one reference, you were referring to the paint test, correct?
Well, I was referring to, there's only one reference specifically with respect to automobile pedestrian impacts.
When you looked at his references, sir, did you have an opportunity to read any of the articles?
I did, yes, sir.
And many of them are peer-reviewed?
Yes, sir.
In addition, when you looked at the 20 pages of materials he sent over that were not in his report, how many references out of those 20 pages of references that he offered?
Well, I didn't read any because they weren't referred to in his report for his actual opinions in this case.
Do you know whether or not he considered those references or whether he read those references?
We're going to allow that.
He didn't cite to any of those references in either the PowerPoint presentation or in his report. That's the knowledge I have of whether he reviewed those.
So you don't know what he considered or thought, do you?
I know what he cited to and he referenced to in his report in PowerPoint. That's the extent.
The
yes.
question is, you don't know what he was referring or reading or relying on other than what was in his report cited, correct?
Well, right. If he referred to the other articles, yes, certainly other articles in the 60s, 70s, and 80s he may have, but they don't really pertain to what happened in this case.
How many references were in your May 7th report?
Well, I think there were, 26, I think.
Those 26 references, are they offered in your report to suggest some type of support for the proposition that you're promoting in the report?
Well, they support the opinions or the methodology or both with respect to what I've offered in this
The
matter.
reason why you put a cite in is suggesting that it supports whatever proposition you're footnoting on that.
To some extent, or the methodology or some information pertinent to that opinion, yes, sir.
Regarding crash test dummies and prediction in soft tissue injury, you provided 3 sites, didn't you?
And soft tissue injuries?
Yes.
Can you show me where that it says that, sir?
Footnote 11 of your report, Mr. O'Keefe's right arm kinematics during impact with the Lexus are inconsistent with producing the documented cuts damage to his right sleeve as well as the abrasions to his right arm. Did you write that?
Yes, and which one was that again? I just want to make sure. What was the number?
You cited footnotes 24, 25, and 26.
Yes.
And when you cited 24, 25, 26, did any of those 3 sites, in fact, those are the only sites that you cited for that proposition, correct?
Yes, sir.
So your entire basis of sites is limited to those 3 articles or 3 papers, yes?
For reference, it's not, the testing obviously proves differently, but yes, for that one comment there, those were the 3 that were provided, yes.
Starting with number 24. When you looked at 24, did it ever suggest, in this paper, did it ever suggest that it was appropriate to use a crash test dummy in the material of a crash test dummy to make an analysis or determine whether or not there would be documented damage to someone's skin?
No, it didn't, and that's not what I did in this matter.
In this article you cite supporting the claim that you made, there is nothing in here that would suggest that a crash test dummy is appropriate to use in making that determination, is there?
There is not, no, sir.
In fact, in this article, it gives you details on what actually should be used to make that analysis, doesn't it?
No, sir. It looks at, it tells you certain ways to look at sharpness and how lacerations are caused.
This is titled Skin Tissue Cutability and its Relation to Lacerations Severity Indices. You know that, you cited that.
That's correct, and it looks at specifically, I think, laminated glass and its ability to cut the skin.
Number 24 in your site, correct?
Yes.
And it tells you 3 types of skin were examined and used for this type of study. Post-mortem human skin from 2 different body sites, Cameos leather, and Napa goat skin. Is that correct?
Right, to look specifically at laminated glass and it's the cutability of that type of glass.
And the reason why the study is giving those suggestions is because a crash test dummy's arm and fabric, the way it's made, is different than how real skin would respond. Yes?
Well, it is different, sure.
Yeah.
And I didn't do that type of comparison.
You did not do any comparisons with any of the suggestions in the site that you cited in support for your proposition, did you?
Oh, I did not evaluate that, no. Not in that manner. No, sir.
And then you cited number 24 or 25. You cited a book, Forensic Pathology, correct?
Correct.
And in this forensic pathology book, in the entire book, it never suggests that crash test dummies are appropriate to use when making this type of analysis, does it?
Correct, and that's why I would not do that type of analysis with respect to lacerations. That's not what my analysis involves, sir.
My question was, nowhere in that book does it say that crash test dummies are appropriate for analyzing skin lacerations on a collision, does it?
Sure, I mean, for that sake, it doesn't say it's inappropriate either.
And then you also cited an article, your third article, Understanding the Acute Skin Injury Mechanisms Caused by Player Surface Contact During Soccer. Did you cite that?
I did, yes.
And again, there's nothing in there that talks about the use, the appropriate use of a crash test dummy when you are trying to support the proposition that someone's arm is consistent or inconsistent with producing cuts and damage in a collision.
That's correct.
Are you aware of literature relative specifically to the use of the hybrid 3 crash test dummy, which was used in this case?
There's a lot of literature with respect to the hybrid dummy, yes.
Have you ever heard of the person by the name of Stanley Bakatis?
I don't recall that I have.
Okay. How about Harold Mertz? Isn't he a leader in the field with crash test dummies?
He is, yes.
Right. Would you agree that we also do not believe the current instrumented arm configuration is suitable either for prediction of soft tissue injuries? Would you agree with that?
Well, for laceration, sure, it shouldn't be used for that. It shouldn't be used in that manner. That's why I don't use it in that manner.
Do you have any source that says it's suitable for determining superficial abrasions?
I do not, no, sir.
You have no other sites whatsoever supporting that proposition, which led inevitably to one of the opinions you gave to this jury, true?
No, not true. That's a misrepresentation of what I performed, the testing that I performed, and the results that I analyzed in this case.
Now, you've talked a lot about Dr. Welcher's pain test. You don't have any information that Dr. Welcher ever claimed that his test was intended to represent exactly how Mr. O'Keefe's arm was when he was hit, do you?
Well, the evidence I have for that is that in his report, he says that the orientation and position of the lacerations are consistent with the orientation position of the taillight cover. And then right under that, he has reference to that test that he performed. So again, if he didn't intend to do that, then there's no evidence that he can provide with respect to the arm impact at all. That's the only test that was performed to look at the arm and the taillight cover. If it doesn't represent the actual position, then apparently he has no idea how the arm was positioned or how it was impacted.
Let's get back to my question.
Yes.
Is there anything where Dr. Welcher has informed you or written that he is intending to represent the actual arm angle of John O'Keefe when he was hit by Alexis?
Again, I just described what he has in his actual report. So he didn't write specifically that that's what it's intended to do. It seems he's inferred that, and again, that's the only test that he's performed or referred to in this case.
You inferred that.
Inferred that that's how he believes that,
It's not
that
doing
the
what?
arm was positioned.
I think we understand your perspective is that the only test he performed, but what I really want to get at is your conclusion, your assumption that Dr. Welcher was suggesting that there was a specific arm angle that occurred in this case.
Well, the email that I put it in under was the mind
You don't see that
challenge.
anywhere in his
thought.
report.
Well, it would be pretty odd if the one test he ran didn't actually represent what he thought happened. I don't understand what the value of that would actually be.
Did Dr. Welcher ever represent that he was trying to describe the actual body position of John O'Keefe when he was hit?
Actually, he doesn't state that. He states very little in his report or in his PowerPoint. He demonstrates through the video of his arm like that and contacting it, and then he holds his arm up to a picture of Mr. O'Keefe's right arm to compare and apparently demonstrate that it's in the same area. But again, he doesn't actually state that opinion. He doesn't state any opinions that the contact actually occurred, except in one point, and has no evidence or foundation for that.
Would the answer to my question be no?
You would have to ask Dr. Welcher, I suppose, but if it's not, again, then I'm not sure what that test actually accomplished
Well,
or
I'm
represented.
asking you. You've made assumptions and then have given opinions to this jury based on your assumptions, haven't you?
I've evaluated the evidence in the one test he ran. If that's incorrect, well, then I would have to correct my opinion and my assumption and say that not only is the test not actually show what occurred, but he hasn't performed anything to actually contact to the taillight cover. If it doesn't represent that, you're right, I'd change my opinion that there's no evidence, no analysis, no conclusion whatsoever.
I'm going to try to make my question a little clearer. Is there anything in the report where Dr. Welcher has stated that the arm angle in the demonstration was in any way attempt to replicate exactly how John O'Keefe's arm was when he was struck by Alexis?
I don't believe anything's written in the report with respect to that, no.
Is there anything in the report, Dr. Renschler, anything, that states Dr. Welcher was stating or claiming that he knew the body position of John O'Keefe when he was struck?
Objection.
I'm going to allow that.
So no, I guess there is no opinion or conclusion that he knows how Mr. O'Keefe was actually positioned at the time of this alleged incident.
You
You're correct.
know whether Dr. Welcher has been clear that he does not know? Let me say this a different way. You would agree, Dr. Welcher has never stated in his report that he can identify the speed at which Mr. O'Keefe was struck in a collision.
He does not state what he thinks the speed is. That's correct.
He never states how far, if at all, Mr. O'Keefe was thrown after being in a collision.
That's right. He does not.
When you don't know the speed, you don't know the body position, and you don't know the angle of the body at the time of collision, you cannot replicate a collision with crash test dummies to a reasonable degree of scientific certainty.
Well, you're right. You can't prove that that actually occurred. That's the basis. Yeah.
So,
If you don't have the
You can-
information, you can't replicate what happened. You can't determine, you can't state to any conclusion of accuracy what actually occurred if you don't have the evidence.
so if you were to do a crash reenactment, but couldn't state to a reasonable degree of scientific certainty this replicated the actual collision, that wouldn't be scientifically reliable to a reasonable degree of scientific certainty, would it?
Well, if you perform a test and you state this is what I tested and this is the angle, then you can certainly say these are my conclusions. But if you don't know the throw distance, if you don't know the position, then you're correct. You can't actually come to a conclusion that it didn't occur. If you don't know how something occurred, how can you conclude that it actually occurred? It scientifically makes no sense.
So, if an expert does a crash test and they can't determine to a reasonable degree of scientific certainty that it replicates the actual collision, you would agree that would not be a reliable test to present to a jury, don't you?
Objection, Your Honor.
I'm going to,
Let me approach that again.
very briefly.
We're briefly on a sidebar. Um, I think Hank's MO here is to force their hand at a mistrial so he can start all over again and come up with another tactic. Does he know he's lost and he's trying to scramble at the last minute? I don't know. I am fully disgusted again at Bev. I've never cussed this much on YouTube that I have in the last 3 years. I'm sorry, 3 days. 3 days, but it feels like 3 years. I can't believe this. She's been asked to admonish Hank before we went to break. She was asked to admonish Hank at Sidebar because of the way that he's making little flippant comments while he's on cross. He's not allowed to do that. She didn't admonish him. She like barely said anything. He needed a full reprimanding in front of the jury. And he's at it again. I don't get it. Be this thorough with your own witness, Hank. Do this with Welcher. This isn't your witness. You dropped the ball. They picked it up. They dunked on you. You got dunked on. You got dunked on. Yeah, seashells. I don't want a mistrial. If it's a mistrial by Hank in the Commonwealth design, we don't want that. And you know what? Massachusetts, if that ever happened, needs to be up in arms protesting every day because it's your money. Give it to Karen, though, all day, every day. We back.
In reading the reports and evaluating the PowerPoint, would you agree there is no statement by Dr. Welcher ever in anything that you reviewed that he is claiming or stating that his pain test was supposed to be a reenactment, identifying the details of how Mr. O'Keefe was standing, moving, or holding his arm at the time of a collision?
He did not state that. That's correct.
So when you've made your criticisms, that you've done testing regarding Dr. Welcher, you don't have any evidence, any statement by him that he was trying to reenact the actual collision?
When I did that, there was one test with the arm like this. That's the only evidence that was presented in his opinion or in his case. I evaluated that. I have not seen any other explanation of what happened or how it occurred. Specifically, Dr. Welcher said in his report on page 9, he said, I have conducted an accident reconstruction and biomechanical engineering analysis of this matter. If he did not recreate how he was positioned, if he did not determine the speed of impact, if he did not determine how Mr. O'Keefe's body moved, if he did not determine where he ended up, then he did not conduct either an accident reconstruction analysis or a biomechanical causation analysis. He did nothing of the sort.
Other than your opinion, let's get back to my question if I could.
I believe I answered at the beginning of that, sir.
I'm going to ask you again. My detailed question is, there is nothing in Dr. Welcher's report or any of his presentation that states he is trying to represent the exact posture, movement, and stance of Mr. O'Keefe when there was a collision. It's not anywhere in there where he stated that, is it?
It's not stated. I'd be curious to find out what that, if that wasn't the intent of the test, I'd be curious to see what the actual intent was.
Is the answer no, it's not in there?
I think I just said that at the beginning of my answer, sir.
I'm going to ask you again, is the answer no?
The answer is no.
When you do crash tests, you have a controlled environment in some respects, don't you?
You do, yes, sir.
You get to control some or sometimes many of the variables, don't you?
You can, yes.
Real life sometimes is described in your world as chaos, right?
I suppose it could be under certain circumstances.
Testing is limited to the variables that you produce, but real life sometimes has variables you can't predict. Isn't that fair to say?
It's possible, yes.
Is it more than possible, doctor?
I don't know, is it?
What? I'm asking you.
It depends on the situation and the certain variables. It depends on the case. It could be possible, yes.
Have you seen cases where the variables are impossible to predict?
Where the what?
Variables. Have you had cases? You've had many cases, you said. Have you had cases where variables are impossible to predict?
It depends. I mean, it depends on what you're looking at. And if you want to conclude that something happened and this is how it occurred, you have to look at those variables. If you can't control for those variables, then it's possible you can't prove that it actually happened. So yes, if you're doing a certain test to prove something, you have to look at how those variables may affect it. But there's basic information you have to know to perform that type of an analysis.
So my question again is, are there scenarios where variables are impossible to predict?
There could be, yes.
Have you had cases yourself where there are variables that were impossible to predict?
I suppose I probably have. I mean, it depends. If you don't know what happened, sure, then you don't know those variables necessarily.
How many cases have you done on pedestrian accidents?
Done hundreds of cases.
So you have a good background and basis to know whether or not there are variables that sometimes you can't predict, don't you?
Sure, as I said, it depends on the case.
When you did the crash tests in this case, did you actually do them?
I did not, no.
Were you even there when they happened?
I was not, no, sir.
So you're relying in part on Dr. Wolf's work.
I am, yes.
If Dr. Wolf made mistakes, would that affect your conclusions?
It depends what mistakes they are.
When you had, or when Dr. Wolf had the crash test dummy in test E and F on a forklift, you remember those?
I do, yes.
When it's on the forklift, it does not allow the crash test dummy after being struck to move, to be thrown, does it?
Actually, if it's a force acting on it, it will move. It will like a pendulum. So if there's a force acting on it, you'll see which direction it moves. If there's a forward force, it will move. It'll swing forward or sideways or backwards. It can move.
Well, my question isn't direction. It's can it show the throw? Can it throw or move the crash test dummy in its natural course after the collision to a resting spot?
No. In those tests, though, there wouldn't be any throw.
If a crash test dummy is restrained by a forklift, if a crash test dummy is restrained by a forklift, it does not allow the crash test dummy to be thrown, does it?
Assuming there is throw, that's correct. It doesn't.
It doesn't allow an observation of the crash test dummy to turn or fall, does it?
No, it does not. Well, no, actually, it turns, sure. I mean, it can spin.
How about fall?
No. And a crash test dummy would just fall down anyway.
Have you seen crash test dummies where it is held in place electromagnetically, and when the collision happens, then the dummy can move? Have you seen that?
I have, yes.
Have you seen, excuse me, have you seen crash test with crash test dummy where there is a light? I'm sorry. Have you seen crash tests with crash test dummies where there is a light string and somebody cuts the string moments before the impact or a second before the impact?
I have, yes.
That wasn't done in this case, was it?
What? It wasn't necessary.
Was that done in this case?
It wasn't. I'll speak slower and a little clearer.
If you answer my question.
I just did answer it. I said it wasn't.
When the crash test dummy is held by a forklift and the car hits it, it doesn't replicate the drag that the car will have on the crash test dummy as it would a real person, does it?
You can see if there's any drag because it's on like a pendulum. So if there's any drag pushing it forward, it's going to sway that way. It's going to move the dummy. It's not going to move at the distance that it actually would. If there was any distance, it would move it. But you can actually see the motion, and you can see in the testing, the 24-mile-an-hour testing, there was no motion, which is not unexpected for that type of a test.
There is a difference between a crash on center of mass and a fender vault, isn't there?
There is, yes.
A fender vault is a different type of collision than a center of mass collision. Isn't that true?
That's correct.
It is impossible to replicate all of the different scenarios with a crash test dummy on a fender vault collision, isn't it?
I mean, it depends on what you're trying to replicate, and it depends looking at the injuries or how someone was positioned. So if you know how they were positioned, you can try and replicate that, yes.
Could I have 59 of Dr. Renschler's PowerPoint, please? In your PowerPoint, you cited an article, Vehicle Pedestrian Collisions, Validated Models for Pedestrian Impact and Projection, correct?
Yes.
And you put snippets up on the board?
Yes.
Okay. And these snippets talk about an engagement with the pedestrian in the vehicle?
Correct.
Okay. Is there a reason why you took out a piece of that article that falls between those two paragraphs?
No, I don't think so, no. Those were the most relevant parts.
Did you cut out the part that says some frontal collisions are with the corner of the vehicle where the pedestrian is deflected to one side without secondary impact of the upper body with the vehicle front? Alternatively, the transverse velocity of the pedestrian at impact may be sufficient to prevent head contact as the body rotates sideways off the bonnet, and these situations are known as fender vault. The models presented here do not apply to fender vault. Did you leave that part out purposely?
Oh, yeah, I did, sir, because this isn't a frontal impact with a sedan over the fender of the hood of a sedan. This is with the back of an SUV, so it's completely different.
You've cited many, many sources where it talks about front-end collisions, because that is the majority of pedestrian collisions, the front end, isn't it?
The majority,
Yes.
it is, yes, sir.
And so there is a difference between fender vault and a center of mass collision, isn't there?
That's correct, and that's why you see a center of mass, you look at the testing we did, that's a center of mass impact. On a frontal impact, usually, if you're hit by the front of a car, it doesn't usually get your center of mass, you're too tall. That's why you do a fender vault, or you flip onto the hood, or you flip over the top of the car. So yeah, it's completely different, and doesn't pertain to allegedly what occurred in this case.
So let me get back to my question. When the tests were done, E and F was a center of mass collision at 29 miles per hour, wasn't it?
That's correct, yes.
Right. E, are you considering E a center of mass collision?
Which was he, the 24?
miles per hour.
No,
Good test.
it didn't hit the center of mass of the
Right.
dummy, it just hit the arm.
Exactly. So there is a difference. In this case, you don't know the position of Mr. O'Keefe's arm at impact, do you?
Nobody knows. I don't think his arm was even impacted by the car, so no. I don't know the position of the arm at impact because it wasn't hit by the car.
You don't know the angle of his body at impact, do you?
The alleged angle,
So ask the question again.
Okay. You have no information about the angle of Mr. O'Keefe's body at the time the defendant's Lexus was traveling backwards on January 29, 2022, do you?
we have no information that he was even hit by the Lexus. So there wouldn't be any information on the angle if his body wasn't hit.
When you talked about force equations with this jury, you cited a number of pieces of literature, didn't you?
I did, yes.
When you cited the literature, you cited all literature regarding concentrated forces, didn't you?
No, that's not true.
There's a difference between concentrated and distributed force, isn't there?
Yeah, I talked about that on my direct, yes, sir.
When you showed your slides, for example, the hand,
Yes.
could we see slide 8, please? Okay. Let's try slide 56. You would agree with me, Doctor, there's a difference between a concentrated and a distributed load, wouldn't you?
I would, yes.
When you gave your opinions in this case, it was based on concentrated load, wasn't it?
No, sir.
When you gave your force equations, was that distributed load or concentrated load?
That was the load at the center of mass. And so you can evaluate that on a distributed load. You look at acceleration and you look at bending moment. So you can do both.
When you gave your charts and numbers, was that based on concentrated or distributed load?
No, that was based on the distributed load with respect to the center of mass of that arm and where the accelerometer was.
But this was not a center of mass impact.
We're assuming center of mass is the most dispersed impact. So if we want concentrated, then we look at a focal point, and you can do that with the hand. But center of mass, acceleration, and distributed across the entire arm, that's where it's the least amount of pressure, if we're talking about force over area. And that's what I evaluated in this case.
When you gave your demonstration about the hand with the different hexagons on it, do you remember that?
I do, yes, sir.
Okay. There's a difference between taking a small object and putting pressure on the body as opposed to a larger, wider object, isn't there?
Well, it depends on what it's contacting. And certainly not a difference when you look at the size of that impactor and the size of the knuckles and the metacarpal bones.
So for example, if somebody took a book and hit somebody off the forehead, it may or may not leave a mark. But if they used the same force and they took a high heel, the heel of a high heel, and hit somebody, there would likely be more damage with the high heel than there would with the book. Isn't that fair to say?
Well, soft tissue, but if the force is the same, you would expect the fracture to occur. You have to look at the distribution, you have to look at the strength of the bone, and you have to look at the overall force that's being applied.
Now, you said in your differential diagnosis you considered all evidence. Did you say that on direct examination?
I don't believe I did. I believe I considered evidence for a biomechanical and accident reconstruction analysis in this case.
So you didn't consider phone data?
Has nothing to do with biomechanics or accident reconstruction.
Did you consider text stream data?
I'm going to allow that.
I'll strike it. Did you consider Apple Healthcare data?
No, sir.
I'm going to allow it.
Did you consider phone temperature, battery temperature data?
I'm going to allow it.
Has nothing to do with biomechanics, sir.
I'll ask again, did you consider it?
I did not, no.
You said it would be improper to ignore evidence. Are those your words?
For a biomechanical analysis, yes, sir.
Have you been to the scene of an accident before or a collision?
I have, yes.
Do you know what a debris field is?
Yes, sir.
And you've seen in your videos, E and F, there's debris fields after the collision and the taillight brakes, isn't there?
So first of all, there's debris in the yard. What that's from, is there a collision? Was there a collision? Where did that come from? Where it was positioned? That's all conjecture and supposition. Those aren't actual facts, sir.
Can you hear my question about debris field? I'm asking.
Yeah, and I think it's in a...
Excuse me, sir. In a collision, have you seen debris fields?
I have, yes.
Have you seen debris fields where a taillight is shattered?
I have, yes.
In fact, in your video, yes or no, after the collisions, in video E and F, there are debris fields, aren't there?
There are at a certain point, yes, sir, absolutely.
And so when you're looking at your studies, do you consider debris fields?
It depends on the evidence. It depends on how it was collected. It depends if it is accurate or reliable. But from a biomechanical standpoint, no, you don't need to look at the debris field or alleged debris field of a taillight cover. That has nothing to do with the injuries or the position or the movement of
Could I
an
have Exhibit
individual.
73, please? Do you see that, sir?
I do.
Do you know what that is?
Looks like possibly part of the taillight cover.
Right. Is that an alleged part of a taillight cover, or do you think that's part of a taillight cover, sir?
I don't know specifically. It might be part of the actual taillight cover.
Well, when you studied this case and you looked at all the evidence and all these different things, did you look at these photos and see that alleged piece of taillight shard recovered from the front yard area of 34 Fairview Road? Did you consider that?
Well, I don't, was that part of the one that was recovered by a leaf blower or not?
When you were doing your ample study, sir,
Yes.
what I'm asking you is, when you were looking at all the available evidence, did you look at this photo of this alleged taillight shard on the front lawn of 34 Fairview Road? Were you aware of this?
No. Oh, I was aware that there was debris in the yard, but again, that has nothing to do with the biomechanical analysis. If you can't prove that the impact happened, then everything after that doesn't actually matter, does it? Because all of that would be from something else. So unless you prove the core issue at this case, the contact, the post-impact movement, the head injury, without proving that, everything else is ancillary to what you're attempting to conclude.
Boom.
Do you have any evidence in your biomechanical studies how this alleged piece of taillight shard ended up on the front lawn of 34 Fairview?
I don't know, sir. I didn't evaluate or investigate that.
Could I have Exhibit 76A, please? Did you see this photograph, sir?
I do, yes.
Is that part of a red taillight shard or an alleged piece of a taillight shard?
It looks like it, yes.
Did you consider this in your biomechanical studies that this taillight shard was found in front of 34 Fairview Road?
Was found. Can you give me a precise distance from where the body was found and where that was found with respect to Mr. O'Keefe, with respect to a reference point?
Did you consider this, sir?
There is none, so no, I did not consider that.
God, I love this
Do you
guy.
know how this taillight shard got there?
How it got there?
Yes.
That wasn't part of my analysis. There are certainly different possibilities of how that actually occurred.
Exhibit 99D.
Moving on. Ignore that. Hank, you're a mess.
Do you know what that is, sir?
It looks like part of the light assembly.
Mr. O'Keefe's hat?
Oh,
Did you
that's
look at
his
this
hat.
photograph?
I see now, yes.
Did you know he was wearing a hat that night?
I did, yes.
And did you consider how that hat ended up on the ground in front of 34 Fairview?
No, sir, that was not part of my biomechanical analysis. There's a number of ways a hat can end up in a yard.
Right. Is one of those ways being in a collision with a Lexus?
I suppose that's a possibility, or someone could put it there. I mean, there's a number of different possibilities as to when or how a hat may appear in a yard.
Who do you think put it there?
Well, I have no idea. I haven't seen any evidence of how it got there, and frankly, it's immaterial to a biomechanical analysis.
Do you have a theory you want to share with us about planting evidence? Is that where we're getting at, sir?
Shut the fuck.
By the way, the x-rays you looked at earlier, when's the first time you saw those?
I saw those when I was on the case initially for the first trial.
No mention in your report about reviewing those.
It says I reviewed medical records and reports. That's how I actually word in every report I have. I just put generally that it refers to medical records and reports, which includes x-rays, MRIs.
Exhibit 74, please.
What about your witness, Hank? He denied x-rays. Fuck you, Hank.
Have you seen this photograph?
I have, yes.
Okay. In your studies or your testing, did you determine how Mr. O'Keefe's shoe ended up near the curb?
No, sir.
Exhibit 201A, please. Have you seen this photograph before?
I don't know that I have.
Have you ever seen any container that had tail light shards that matched the defendant's Lexus that were removed from his sweatshirt and his shirt? Have you ever seen any container holding those?
I haven't. Well, I believe there was evidence collected like that, but yes.
Okay, could we have 201E, please? Have you seen this photo?
I believe I have seen that, yes.
Do you understand those are taillight shards matching the defendant's Lexus, the broken taillight,
Yes.
that were recovered from Mr. O'Keefe's sweater or shirt?
Objection.
I'm going to allow that to.
Bullshit, Bev.
I'll try. I'd rather try to reformat it than come sidebar.
Shut up, Hank. Trying to look good in front of the jury. Shut
Did
up.
you know that taillight shards were collected after Mr. O'Keefe's sweatshirt and T-shirt was scraped?
Objection.
I'm going to allow that.
I need to see the voice.
Jurors, this will be brief.
It's going to be brief. Shut the fuck up blaming this and making it fucking gaslighting as fuck that the defense is doing this. Hank is pushing this because he's being dirty. This is his only out, is to try to make the defense come out of character right now and try to taint the fucking jury. Bev is just such a disappointment. I just can't. She needs to leave the country because she can't. I don't even think she needs to be given any retirement money. Sorry. There needs to be like heavy sanctions for this. This is egregious. This is disgusting what we're seeing here. Let's
What's
see if
that?
Lana got her modem on. I think you sound good. Let me hear it.
Well, I'm trying to set up a whole bunch of things, but I am at my desk.
I mean, but you sound, I think that you, what you mean by you're on your, at your desk, you mean you're on your laptop?
Yeah, but I don't even have my new mic even set up yet. Just wait for
Oh, it's
that.
just broken. Okay.
But I'm
Want to hear your voice about
I think otherwise I'm just buying a whole new Apple system and saying fuck it.
Oh, really? You're going to go with a Mac?
I want a Mac computer.
Oh my God, you're going to go with a Mac. Just know that in 7 years you won't be able to use it, but that's
I don't
good.
care, then I'll get another one.
Okay, yeah, do it.
I'm
Gonna
just
love
I'm just done dealing with the stupid shit.
it. You know, I'm into that.
Okay.
Admonish him, Bev. God damn it.
In your extensive study of the detail of this case, did you know that these pieces of plastic were removed or scraped from Mr. O'Keefe's clothes, specifically his sweatshirt and his t-shirt? Did you know that?
I was aware that samples were recovered, yes.
Were you aware that these samples were consistent with the broken taillight of Miss Reed's Lexus? Did you know that?
Yes.
Did you do any analysis how these broken taillight shards got into Mr. O'Keefe's clothes?
No, I did not. The first step involved with that would be to actually perform a biomechanical analysis to look at the movement of the body, how the body was positioned, where it ended up. So without that knowledge, you can't determine exactly how or if those types of shards were deposited there as the result of an actual impact.
Your Honor, based on the last question, I wonder if the property finishes question. I'm objecting to move to strike based on the question that was asked. For the same reason I just indicated at sidebar. You just be reformatted and strike. I'll try again.
Okay.
That's not enough. Oh my God.
When you looked at these taillight shards that were
Objection.
They discussed this at Sidebar, Bev.
when we looked at these taillight shards that were consistent with the break in Miss Reed's Lexus, did you consider how they got into Mr. O'Keefe's clothes?
Objection. Same objection.
I understand the objection.
Stop.
Word it differently. Start with the different.
Yes, Your Honor. You see these pieces of broken plastic, don't you?
I do.
And you understand that these were found in the scrapings of Mr. O'Keefe's clothes.
I do.
And you understand that these broken pieces of plastic are consistent with the taillight of Miss Reed's Lexus.
I do, yes.
In your studies and reenactments, did you make any determination how these pieces of broken plastic got into Mr. O'Keefe's clothing?
No, when you look at those studies, first you have to know how the incident occurred. Then you can look at that and determine, if you want to, how that may have occurred. Because otherwise, there's, again, different ways, different manners in which that may have been deposited on the sweatshirt. Without knowing how this happened, you can't just then look at other evidence and try and predict how it happened. You need the actual evidence to look at the event. This all goes to the event. You need contact with the arm, I guess apparently, to actually cause this incident to occur. And without that evidence of any of that happening, knowing how the body moved, knowing how it was hit, knowing where it ended up, any conclusions drawn off of information like this is just supposition, because you don't know the movement of the body or the vehicle.
Nice.
It's putting the cart before the horse.
Beautiful. Shove it, Hank.
Could I have Exhibit 201D, please? Do you understand this is broken pieces of plastic consistent with the broken taillight of the defendant's car? Do you understand that?
I believe so, yes.
And do you understand this is a photograph of these broken pieces of plastic under a microscope?
Okay.
Well, I'm asking you, do you understand
Well, if
that?
that's what you're telling me, then
I don't want you to rely on me. If you didn't see them, it's okay.
I don't recall if I saw those or not.
Have you seen this picture?
I don't recall seeing it, no.
Now looking at this photograph and seeing these broken pieces of plastic under a microscope with fibers near the plastic, is that something you would want to consider in your analysis, forming your opinion
He
whether or not
answered this last question.
between Ms. Reed's car?
Last slide.
Again,
Thank you.
if you
Again.
can't do a proper biomechanical analysis, then that evidence is not consistent. You can't determine how it occurred. You can't say that that's consistent with it. You can't just look at certain evidence and not do a proper analysis. If you can't even tell that an impact occurred, you can't look at tertiary evidence and say, well, this proves that it occurred. In order to say from a biomechanical and accident reconstruction standpoint that an impact occurred and here's how it occurred, you have to understand the mechanics and dynamics before it. This could certainly support that finding and those conclusions, but by itself, I don't know of any methodology in any study or peer-reviewed article that says you can just look at alleged evidence and then form an opinion as to whether an impact occurred.
Can you see with your eye that parts of those broken pieces of plastic are sharp?
They look sharp.
Do you disagree? Do you think they're not sharp?
Well, I don't have an opinion as to that, sir.
We'll take a look.
Objection.
Sustained.
If you look at that for me kindly, can you tell me whether you think those pieces of broken plastic are sharp?
Objection.
I would allow that.
I guess they look sharp. I have no idea if they are or not. It's under a microscope. When you actually put things under a microscope, it looks much different, and it is much different than
Okay, let's go back to
looking at the normal
20E.
eye.
Perhaps that can help. Not under a microscope. If you pay particular attention to the larger one in the middle, that looks like a shark's tooth. Do you see
Yes.
that one?
Yes.
Do you think, doctor,
A shark's
that
tooth.
some of those appear sharp?
Show us.
Some of those appear sharp, could possibly cause a laceration, sure, as opposed to an abrasion.
Do you think that any of those could cause an abrasion?
I don't think that you could get a consistent level of superficial abrasions along the entire arm of minimal depth of less than 0.5 millimeter through impact with the glass. To have that minimal force on every part of the arm to only cause superficial abrasions would be highly unlikely.
Do you think some of those sharp pieces, if they were lodged in Mr. O'Keefe's sweater, could cause an abrasion?
It's possible if you had enough punctures and holes in the sweater to correspond with the abrasions on the arm, that would be, I suppose, that could be a possibility.
Oh my. You're not paid enough, honey.
In your testing, not to belabor it, I'm just going to show you one. I want to show you video E. Could we go to video E, please?
Please tell me it's Welcher. I need a laugh. I need a laugh at the yellow dick man. Oh, man.
Stop. In video E, the arm that is sticking straight out, who determined that angle, Dr. Wolf?
Yes, well, we positioned it just so it would impact in the general area of what was shown in Dr. Welcher's paint test study, which apparently is irrelevant and doesn't show the alleged position of how the arm was at impact. But yes, we positioned it in that manner.
When you say we, did you have input on the positioning of that, or did Dr. Wolf do it?
Well, I had input into how we were going to position it. It would probably be both of us, I would say.
So you chose to position the arm straight out, correct?
In that test, we did, yes.
Is there a glass in Randy's hand?
There is not, no.
A drinking glass, no?
No.
Oh, shut up.
in any of your studies did you have a drinking glass in Randy's hand?
We did not have a drinking glass in the dummy's hand, no.
Throw my fucking life.
And you see when the taillight is shattering, those red things falling down. What are those?
Those are part of the taillight.
Continue a little bit, please. Stop. Did you count how many taillight pieces broke?
We didn't count the taillight pieces. We counted how many punctures or holes there were in the sweatshirt, which was 0.
If you had done this test and changed the arm angle, do you expect the damage would look different as far as the brakes in that taillight?
Well, we conducted a number of tests. It may look somewhat different, sure.
If you conducted this test and moved the arm angle, not another test, this test, but you moved the arm angle, do you expect that the brake would look different?
That the brake would look different?
Yes.
It could look a little different. I mean, certainly the brakes looked a little different in the test, but they were comparable to each other.
You do not know how John O'Keefe was standing that night, do you?
Well,
Objection. Seems fast.
No, I'm going to allow that.
Shut the
You do
fuck
not
up.
know how John O'Keefe was standing that night, do you?
if he was standing, if the impact occurred, then no, nobody knows how he would have been standing.
You would not know what his arm angle was, would you?
Nobody does.
No.
You would not know the exact speed of any vehicle that hit him that night, would you?
Objection.
Sustained.
Like,
The debris, the broken taillight, is that traveling in a consistent or a
Debris.
different direction?
Get it right.
What do you mean consistent or
Is
different?
it all going in the same direction, or is it going in different directions?
No, there's some spread to the debris.
So the pieces don't all fall right in a pile with each other, do they?
They do not, no.
Continue, please. Stop. Do the majority of the pieces land on Randy?
No, they do not.
And so as they fall, if Randy were to fall, many of those pieces would not be among the immediate area of his body, would they?
oh, God. Hank.
If the dummy fell right there, no, they would not be.
Now, the dummy can't fall because the dummy is on a forklift, correct?
It's suspended like a pendulum, correct?
And you see in your test that the taillight, at what you say is 24 miles per hour, can be broken without the dummy's knees touching the vehicle. Isn't that fair to say?
That's correct, yes.
You can't tell the full movement and fall of this dummy the way you've set up this test, can you?
What?
Well, knowing the physics, you can certainly determine or estimate where it would be, but no, you could release it and it would fall primarily straight down. It would twist and it would fall down.
Is there something that could affect the dummy if you let it fall? Is there something that could affect its movement after being hit?
Like what?
Like, could its feet be twisted and then hit another object like a curb?
You like what, bro?
Well, there's going to be very little lateral movement of its feet, but even if it did, then it's still going to fall over right where it is.
Can you continue, please?
Jesus.
Can you see the feet, doctor?
Yes,
Are they twisting?
they are, yes.
Is that because of the rotation of Randy after he struck?
Yeah, that's the rotation of Randy. And again, yeah, as you said, that's not a normal person because there's no normal force acting on the dummy. We just have it barely touching. So a normal individual, you aren't going to twist to that extent because this is a dummy which is suspended with just a little contact on the
And
ground.
after being contacted by a vehicle enough to break the light, could it cause a person to stagger backwards?
I mean, you're making some suppositions here. There's no evidence that would occur in this case, and not if you're spinning like that. You're not going to stagger backwards. First, you're going to spin if you get hit with your arm, as I described in my direct. But is it possible? I can't say it's impossible, but there's no evidence of that.
Could a person stumble backwards after being hit?
Objection.
I'm going to allow that.
I'm gonna allow.
What do you mean by backwards? Because you'd be spinning. So what direction is backwards?
Could a person get their foot caught on a curb sneaker come off and then stagger backwards and fall on their head?
Objection, Your Honor.
He said, he's.
Doctor?
Can you answer that?
I mean, I guess you
love
could
this.
somehow predict or have a possibility of almost anything happening. You could say someone could get hit by a car and do a couple of somersaults into the yard. I mean, there's no evidence of that. So it's just supposition, but I won't say it's impossible.
You think John O'Keefe did somersaults into the front yard of 34th Fairview?
No, it sounds like you think that.
No, I don't think he even got hit by the car, sir.
Beautiful. Fuck yeah.
Yeah. No, there's no evidence of what he did.
He didn't get hit by it. Oh my God, he just said it. Fuck your sidebar. Oh, now you want a sidebar? Because he said that?
You shouldn't have asked that question.
Mm-hmm.
No, sir. I don't even think he got hit by the car. No, sir. I
Yeah,
don't think he did
stop
somersaults. Or, but most importantly, I don't think he got hit by the car. He wants a jury instruction to disregard that.
Now all of a sudden he doesn't care about like the sidebar. I'd rather reap.
He's gonna ask at sidebar. I want you to instruct the jury to disregard him saying that I don't even think he got hit by the car.
I hope he does. It's gonna make him look so fucking foolish because you cannot get that out of their heads now. I love it. I don't care what the rules are. The Commonwealth is breaking rules left and right, and the jury knows it. And I don't give a fuck. I think they're over it, like I'm over it.
We don't give
like
a
you're
fuck. We don't give a fuck. You know who I think's really over it is Randy. Randy has just gotten tossed the fuck around, and he doesn't even have a dick. Okay.
Well, it's better than having a yellow dick, like because you know that Juddy Buddy, who was the crash test dummy for Welcher, he painted his hand yellow, right, and his arm blue, but he's messy. I don't know if you caught it. So when he went to go urinate that day, he probably didn't wipe his hands, so his pee-pee has yellow all over it.
Gross.
Mm-hmm.
Randy is just pissed.
Randy just pissed his pants.
Well, first of all, we've been calling him Rescue Randy. Now we have to rescue him from Jaws. There's a Jaws attack. Don't those look like shark teeth? Don't those look like shark teeth? What?
Shark teeth. And did you?
I think. Let me just say something. If this could ever be made into a movie, I want JLR to play Hank Brennan because I could see JLR asking questions like that.
Yeah, that's true.
I think that JLR should play Hank Brennan for the movie. Okay.
Yeah, if you give him glasses.
Don't those look like shark teeth to you?
And did you see like when he started saying sharp and sharp, they were like,
rescue. Somebody threw one of those things called "Give a Life Preserver,"
a lifesaver.
Oh my God! You guys, this case, like someone's dead, someone's on trial for murder, and this is the type of stuff that's being put out. Like, how do you not? Either you're gonna cry about it or you can make jokes about it. I choose to watch Sharknado tonight and remind myself. Shark attacks.
Shark attacks can happen.
What is he talking about over there? Hey, Bev, I'm going to need you to give a jury instruction to disregard that this witness is not the.
I want a mistrial. I think he's saying I want a mistrial. He just said this out loud that he doesn't think that. No, duh, dude. What do you think?
Well, isn't that his expert opinion?
Sure is. But I don't trust fucking Bev. Bev needs to give up her size and just start like admonishing him, spank him. Spank him.
I would agree with this comment. It must be so hard for the defense to not bust out. Well, I think Natty has, But
I love that name because she did her green laser pointer. Laposa's. Dr. Laposa's green laser pointer, because her green laser pointer was like barely even there, but it was there, and that's a really witty name.
I just think, what expert witness has Hank won yet? I mean, he is forever on expert witnesses. Let's just
forever.
Oh, forever. Oh,
You owe
forever
forever.
against expert witnesses in this trial. I was reading his jury instructions, to how he wants the jury to be told about expert witnesses.
Mm-hmm.
Get a hoot out of this. Expert witnesses, according to Hank. There is one more point about witnesses to address. Expert witnesses. This term refers to witnesses who have specialized training. Okay. He says they're not more credible than anybody else.
Could I have Exhibit 166, please? Did you see this photograph, sir?
I did, yes.
And do you see the cut on Mr. O'Keefe's nose, the left side of his nostril?
I do.
In your analysis of whether there was a collision with the defendant's Lexus, did you consider or know that there was evidence that a piece of glass or a piece of broken plastic was pulled from Mr. O'Keefe's nose?
Objection.
I'm going to allow
Mhm.
that.
Well, there's a formal question.
I'm going to allow that.
You are.
So, hold on.
Sure.
Let's get an answer, Dr. Mitchell. Your objection's noted, Mr. Jackson.
Shut up.
I was aware there was some piece of material allegedly pulled from the nose, yes.
Allegedly pulled from the nose?
Yes.
Okay. And that alleged piece of material, were you aware that it was perhaps a piece of glass or broken plastic?
Objection.
That's a
Are you
mischaracterization.
aware of that?
Did she allow it?
That's not what.
So,
That's not the statement.
Glass.
Hold on.
hold on, Mr. Jackson. Mr. Brennan.
I can
do you have a
reword
quick-
it.
Okay.
You will.
You're welcome. Are you aware of that object that was pulled from Mr. O'Keefe's nose? What material that was?
I believe it was glass.
Did you want to know in your assessment about collision where that came from?
Well, I did evaluate that, and it's actually entirely inconsistent with coming from an impact with the vehicle.
Hmm.
I think Karen doesn't know what she's talking about.
Can we have Exhibit 52A, please? Do you know what that is, Doctor?
It's hard for me to see from here. I believe that's the drinking glass.
A drinking glass. Do you
Yeah.
know where that is in relation to where Mr. O'Keefe was found?
I believe it was found in the vicinity of where he was found.
And could I have Exhibit 195, please? You recognize that?
That is another photograph of the drinking glass, yes, sir.
197A, please. B.
That glass doesn't
See?
match.
D.
Opening doors.
I mean,
And in your assessment, did you know that a piece of glass that fit the broken drinking glass was found in the street area in front of 34 Fairview Road?
Oh boy.
Yes, sir.
days later. No.
98, please.
Oh, that was found that day.
Relevance to
That's what
any
he
of this.
applied to.
I don't care. There was no collision. We're done. This is
A
all
little
the
more, please.
confused.
I don't care what
You
your
know what that is, sir?
is.
It's hard for me to tell from
Does it
back.
look like a drinking straw?
Okay, the black, that does appear to be a drinking straw, yes.
Have you seen that before?
I've seen that photograph before.
And do you appreciate that is in front of 34 Fairview Road?
Yes, I believe that's correct.
And sir, in your analysis, in your reconstruction analysis, did you consider the broken glass found near Mr. O'Keefe's body, the suggestion glass is found in his nose, and that glass that fit the broken glass was found on the street? Did you consider all those things in your reconstruction analysis?
Well, My biomechanical analysis, I did consider especially the glass in the nose, yes, and whether that could have been as a result of the impact.
A result of what?
A result of the impact with the vehicle.
When did you find out about the glass from Mr. O'Keefe's nose? When did you learn that?
I don't recall specifically.
Well, was it
Good
before you
answer.
came and testified last time, or was it before this time?
I honestly, I couldn't tell you. I know it was before this time. I don't know when I found out about it.
Weeks ago, months ago? Could you turn the lights on, please?
I have no idea, sir.
You don't know if it was weeks or month ago?
I don't remember with that specific piece of evidence when I found out about it.
What do you mean you don't remember it? Have you seen it before?
Well, I evaluated certainly for my report for this case. I don't know if I had known about it prior to that.
Is it mentioned anywhere in the report about the piece of glass in Mr. O'Keefe's nose?
No, it's not.
When you received that information, did someone tell you about it? Did you listen? Did you watch? How did you evaluate this evidence?
It might have been in an interview or something that it was pulled from his nose, I believe.
Okay. So you saw and listened to something?
I believe so, or was made aware of it.
Okay. Just a couple more questions, sir. I had asked you at the beginning of your examination whether you denied that receiving information certainly helped prepare to understand what was going on during the trial. Do you remember those questions?
With respect to the trace
Last
DNA,
one.
correct?
Yeah.
Okay.
Yeah, you're not going to loop that all in, buddy. Good answer.
Yeah, approach.
Yes.
Great answer. I hope AJ just comes out and just asks him flat out, who hired you for the last trial?
Yes. 124 minus 16.
I hope AJ says, so in your opinion, there was no collision?
Yes.
Just say it again and
He already
again.
said it.
Testified a few times
Say it again.
in this case, haven't you?
I have, yes, sir.
And you testified recently for a short bit in April, didn't you?
I did, yes.
Oh, he was asked.
On April 28, 2025, did you testify in this very courtroom
I believe I did.
under oath,
Yes, sir.
like the oath you took today?
Yes, or yesterday.
Now, when I read this, I'm not attributing this in any way to the defendant's attorneys. I'm going to read you this just for clarity. You were asked, did they inform you about witness testimony? And what did you say, sir?
They did inform me, yes, about testimony in situations and events that came forth in the trial that I was not aware of.
Those are your words?
Yes, sir.
Page 125, line 7.
Don't get too smug there, Hanky.
Yeah, I don't know what he's getting pumped about.
I'm going to ask you if this is your sworn testimony, sir.
Sworn.
Page 125, line 7, I'll read the question. And if this is your answer, you should read the answer. Were you asked, and by calling and raising issues and telling you information, even if you weren't requesting it, it helped prepare you for your trial testimony, didn't it? What did you swear?
I said it certainly helped prepare me to understand what was going on during the trial, yes.
Nothing burger. Sorry.
Seriously?
In the court. There's someone at the door at the court.
That's prime. I'll put all my money on
I
it.
have no further questions.
All right, Mr. Jackson.
Okay.
Okay.
Here we go. Oh, sidebar. And here comes Lally. Lally doesn't have another ounce to give.
Did he get a haircut?
I think he got a body cut. He has been pounding those cigs down. He just doesn't know when he's going to get another reach around, if he's going to end up in prison. I don't know.
Oh my gosh, Octavia, it's like Ricky Lake. Yeah, remember when they would ring the doorbell? Isn't that what they would do?
You guys know about that? You guys watch Ricky Lake?
Everybody watched Ricky Lake at least once.
Just saw in Hairspray.
Didn't you know that Ricky Lake? I think wasn't at one point she banging Dennis Rodman. Is that true?
What?
Dennis Rodman. I have to look it up. I think she was. I'll look it up.
The height difference on that must be insane. It's like my mom and my dad. Sheesh. Ted Daniels is back in the courtroom. None of this matters, and I love that Dr. Renschler is so adamantly sticking to that. That these are all, like, this is all conjecture. These are, like, you can talk about this all you want. It doesn't matter, because it's all allegedly. We are back.
Yes.
Thank you.
Whipping her hair.
Dr. Renschler, you were just asked a couple of questions about they provided information about the prior trial, correct?
Correct.
They is no one associated with the defense team, correct?
That's correct. No one associated with you, and they provided information, and again, it let me know what was going on, but it didn't affect my preparation or my opinions. It in no way changed any of my opinions or what I testified to.
Thank you for that.
To get through this, I'm going to let you just answer the question.
Sorry,
And-
Ron.
Oh my
with
God.
regard to, and I appreciate that. Mr. Brennan asked you a couple of questions about they being your employer. Do you remember those questions at the beginning of his cross-examination?
I do, yes.
Who is your employer, actually? The actual employer that you work for?
ARCA.
Okay. Wasn't them.
No,
It's a client, correct?
it was a client.
A
That's
completely
correct.
separate entity that hired you
Please.
for that work, correct?
That's correct, yes.
Thank you. Thank
You
you.
can't say FBI.
Say
You
it.
were asked about a fender vault
Yeah.
collision, and you said, well, this wasn't a fender vault, right?
Correct.
What is a fender vault?
Frontal.
A fender vault is when you're hit by the front of a car and you're moving across the car. So you're moving across the center towards the driver's side of the car, and the car hits you. You go up over the car and you fly over the fender to the driver's side of the car. So you vault over top of the fender.
Fender
Dr.
vault.
Renschler, where is as I stand here, where is my center of mass?
Love it.
Right about your belly button.
Right there. right?
Yes.
So what would happen if I was hit by a vehicle, front collision, and the vehicle struck me below my center of mass?
It's going to flip you. Your center of mass will go, you'd go right up. If it was coming right at you and it hits you at your legs, you'd flip right into the hood or over top of the top of the car.
Is that what's described in the industry as a fender vault?
That is part of a fender vault, yes, but it's at an angle. So instead of going direct back, it's because if the person's walking across and you get hit, you fly kind of back and over the top of the fender.
Did that set of circumstances, physics, have anything to do with your analysis in this case?
No, none whatsoever. The profile of the car is completely different. The back of the SUV.
Thank you.
You were asked several questions about the debris field in the test F as in Foxtrot. Actually, you were asked about both test E and test F. Test E being the 24-mile-an-hour impact to the right arm of Randy, correct?
Correct.
And test F, the full rear impact, center of mass impact, correct?
Correct.
You were shown several photographs, exhibits of very tiny, tiny shards. Do you remember that?
I do, yes.
I'll get to that in a second. You were also shown some photographs of pieces of plastic that were claimed to have been found at 34 Fairview. Clear plastic, piece of red plastic, correct?
That's correct, yes.
In your review of all the data in this case, Do you know when those pieces of plastic got to 34 Fairview?
I do not. No.
Do you know how those pieces of plastic got to 34 Fairview?
I do not know.
Do you know who put those pieces of plastic at 34 Fairview?
I do not.
Were you aware in your review of the police reports that none of the plastic
Sure did.
that you were shown was found at the time John O'Keefe's body was discovered and the area was initially searched?
That is correct, yes. I was aware of that.
You indicated that the cut on Mr. O'Keefe's nose, the right side of his nose, was inconsistent with coming from a vehicle, correct?
Correct.
Can you describe why you came to that conclusion?
Well, if you're standing at the back corner of the vehicle and it strikes the arm, and let's be clear, if nobody wants to say where the arm was or how it was positioned, if they're claiming the abrasions are a result of the fractured taillight, it has to strike the arm. You have to be standing like this. The debris goes forward with the vehicle. So it's with your arm like this, it already passes by the person. And if there would be any contact whatsoever, it would be with the right side of the face. The shard can't come out and then make a right turn and then somehow embed itself on the left side of the nose. That's entirely inconsistent with the fracture and how the glass and the cover would actually move.
Dr. Renschler, you were asked a series of questions about a hat. Do you remember that?
I do.
About some shards of plastic material, correct?
Yes.
About a drinking glass?
Yes.
About a drinking straw?
Yes.
Doctor, if there was no collision, does any of that matter in terms of your biomechanical analysis and your reconstruction in this incident?
It does not.
Why?
Because if there wasn't a collision, it wasn't that debris or those items weren't a result of that impact. You can explain how that got there, I believe, easier than if you can't explain how the impact occurred. If the injuries don't match up, if you can't even prove what happened, then you can't use information or evidence if you have no idea how it got there to try and prove what you don't even know what happened. Scientifically, it makes no sense.
Scientifically, is the first question that has to be answered is, was there a collision?
Was there a collision?
Sustained. You have to watch the formal question.
Of course.
You have to watch my
In your expert opinion, based on all of your review of all of the data in this case, all of the testing that you've undertaken, do you have an opinion as to whether or not there was a collision with John O'Keefe?
I do.
Yeah, I'm sustaining that.
Wait, what?
In your view,
how? Of the evidence.
Was there evidence of a collision with John O'Keefe?
Sustained.
In your opinion, were any of the injuries that you saw suffered by John O'Keefe consistent with having been struck by the subject Lexus?
No, they are not.
Do you hold that opinion to a reasonable degree of scientific certainty?
I do.
Thank you.
You're not muted. You're good now.
I'm gonna.
I can't believe.
Doctor, you just said that you do not believe that there was a fender vault collision.
Shut up.
Could it have been a clip?
Clip of the nuts?
Could it have clipped Mr. O'Keefe?
Yeah. Not hit him, but clipped it.
Well, I don't believe that's consistent with the evidence and what occurred. I mean, someone can get clipped by a car, sure, but in this case, no, I don't believe the evidence indicates that's what occurred.
The glass. When you learned of the information of the glass in Mr. O'Keefe's nose, when do you think it was that glass was pulled from his nose? What date?
What?
I think it was the morning when his body was discovered.
January 29, 2022?
Yes, sir.
somewhere
Allegedly.
around 6:15 a.m.?
Allegedly.
What?
Sometime when his body was discovered. That's correct.
He's
Do
already
you
said.
know or understand that,
Why is he
do you
answering?
see any evidence that Mr. O'Keefe had a drinking glass outside of 34 Fairview Road that morning after he got out of the defendant's Lexus? Do you understand that?
What do you mean evidence?
Drinking glass. Did you hear anything about that in your review about?
What evidence would there be? Is there a video or a photograph, you mean, of him holding a drinking glass? Because otherwise there's a drinking glass there, but there's no evidence that he had it.
We have a clip, right?
Oh my.
Okay. Judge, can I come sidebar?
Okay.
May I come sidebar? There's no evidence of him with a drinking glass. And this is what he's going to say, Your Honor, he's watched the waterfall videos. Hello, he knows that John had a drinking glass. That's what he's going to say. And then,
But do you understand what they did at Sidebar?
hold on, please. And then he's going to say, he's over here saying, he said that he watched this waterfall bar video and that he had a drinking glass. And I think all that's going to be said here is, just because he had it with him there doesn't mean he had it with him there. I mean, you'd have to show me that the drinking glass isn't in the Lexus anymore or isn't in, I don't know. I mean, I'm curious to see what he's saying over there at Sidebar for this.
I just think it's ridiculous because it doesn't even need to come up because he's already answered that he doesn't know one way or another if it was. He called it allegedly the first round when he did cross. On recross, he just answered a little differently and he should have just stuck with his guns and used the term allegedly again. But I want to talk about when they went to Sidebar and Hanky was all upset about him saying there was no collision. Apparently, Bev allowed that. Bev allowed that to stand because they had to dance around how it was asked when Hank opened that fucking door. And this is just so, first of all, as soon as Alan Jackson starts asking questions on redirect, she interrupts his flow. I can't even stand it anymore. The bias is just she's not even trying to hide it. I mean, over a week now, but it just pisses me off. This is first of all, Karen's life on the line for murder. This is also people's careers. And they're doing underhanded things to fuck with them on the stand. He doesn't have to opine about some comment Karen made in some entertainment show, which she shouldn't have fucking done, but she did. This is science. We're dealing with science. He's giving you facts. Hank, you're not asking about the facts. You want to fucking confabulate and you want to fucking cloud everyone's vision. And I'm starting to think you're a fucking narcissist. What the fuck is wrong with you?
I mean, I think everybody knows that this is getting overturned if, God forbid, she was to be found guilty on anything. But it's just, whew. Those shouldn't even be in. Those shouldn't even be in.
It shouldn't be in.
What she said, it shouldn't even be in. Those are out of court statements.
Exactly. But the whole thing we were talking about yesterday, where they're allowing these clips to be played without a witness having to bring it in and introduce it, is egregious. I don't know of any other place where there's like this demonstration put on. Like,
I don't think Alan Jackson, I don't know how he objected, but like, I don't know if they're going to play the interviews in their entirety to the jury because there's no way that you can just play a clip. Like Alan Jackson would have free reign at the clips as well. You can't say just you get to play the clips and he doesn't. You know what I mean? So whatever clips could be to help Karen, I'm sure they could play.
Okay. What clips are those? Because I don't know.
On her saying that she saw him going to the house.
You were asked about whether or not any plastic taillight shards were found near Mr. O'Keefe's body. Do you know the limits of the search that the Canton Police Department did around Mr. O'Keefe's body? How small of an area they searched when they first went there?
I do not know, sir.
Did you ever see a video of somebody with a leaf blower blowing snow off the ground?
I did see that, yes.
And did you see the confined area in which that happened?
Well, I mean, I saw the area where he was blowing with the leaf blower.
Have you seen any information or evidence whatsoever that the pieces of taillight that were found after that search, have you seen any evidence that they were found in that exact area, or were they found in different areas on the lot?
I'd have to go back and look. I don't recall specifically.
And so when there was a snow blower or a leaf blower search in that area, there would not be a piece of plastic taillight to find if it was never there, would there be?
What?
If it wasn't there, you wouldn't find it? Is that what you're saying?
That's what I'm saying.
Sure.
Okay. Did you notice in the injuries to Mr. O'Keefe, most of them are on the right side of his body?
That Duper's delight, though.
Well, we have the abrasions and then a 1/2 centimeter abrasion. And then we have the laceration and scuff on the left side. And then the skull fracture, it's a little bit to the right, but it's mainly on the back of the head.
And the bruise on his knee?
That's the 1/2 centimeter. It's not a bruise. It's a 1/2 centimeter abrasions, about an 1/8 of an inch.
When you're conducting an investigation or you're doing your analysis and you keep saying the physics and the physics, do you add a little bit of common sense in the equation when you're considering the evidence?
Well, you can sit back or step back and look at whether what someone's claiming makes sense in the bigger picture.
So when you have common sense and you look at the big picture, it's not just physics. It's considering all of the evidence, right?
Well, it depends what you're looking at. To certain parts of it, the biomechanical analysis, you look at the physics. It tells you what it is. I mean, if you don't like it and you don't think it fits, well, sorry, it is what it is. That's the science. So you have to step back. I mean, you can look at it the bigger picture if things make sense.
Beautiful.
You know, if somebody was standing on the side of the road with their arm like this while an SUV backed up at them and they didn't flinch or they didn't put their arm up, that's kind of the smell test bigger picture. That doesn't make sense. But the physics, you can't deny it. You have to accept what science tells you.
You can't deny it. That's the line you were laughing about in the documentary is one of your answers that you were all selling.
What? Excuse me? Thank you.
Isn't it?
The objection sustained.
How'd that taillight break, sir? How did it break that night?
How did, oh, I don't know. There's no evidence of how it broke.
Thank you. No further questions.
All right.
You're
You're all
all
set, Dr. Renschler.
Thank you, Your Honor.
Oh my God, what's going to happen now?
What?
Is there an objection? So, subject to us discussing it. Mr. Jackson? Mr. Jackson? Subject to me taking a look at it and us discussing it. It's not coming in right now. Okay. They've been marked for identity. Jurors, I'm going to see counsel for a couple of minutes over here.
What's happening? They're not
What
resting.
was just asked for? Something was just asked for.
Okay. That's not over yet. They didn't say, that's all we have, Your Honor, as far as witnesses. There's more so, let's talk about that steak dinner. God, this is going to be good. What do we got?
Well, I told you to wait. I said I was being fair and letting it wait.
Well, let's just see what's up.
I think we should rewind a little because I really want to hear what he said.
I'll say it again.
I want to know what they're doing right now because then Hank objected to it. And then she said, is there an objection? I'm not allowing that in. What are you not allowing in? What motions
No, it wasn't that. She wasn't allowing that in. She's like, subject to what we talked about, there was something of it.
Right. If I knew what that was.
If it's about Ellington's new stuff.
What motions did motions drop?
So he has to get the exhibits admitted. So let's see what happens here.
This callback?
Let's see if it has to do with the clips. Let's see if it has to do with maybe they want to introduce Randy's dick. I mean, don't you think that maybe John O'Keefe's balls would have been, I don't know, clipped?
I mean, great. Let's talk about
Randy's balls. Can we get those admitted?
Let's talk about things that aren't there, like the Commonwealth is doing, and that would be Randy's dick.
Yeah, we want to talk about why it wasn't Randy's dick scuffed.
Let's talk about things that don't exist, like the Commonwealth did.
Like Randy's dick.
Yeah.
How do you not have a dick on a dummy?
Let's talk about the dick measuring contest that Randy and Juddy got into. Juddy won the first dick measuring contest ever. Yeah. Okay, so.
Oh wait, where's my phone at?
So.
I'm gonna call the Norfolk County District Attorney's Office. I want to know how much money this costed to.
Yeah, you better start making your phone calls
to try Karen Reed because I want to refund my taxes.
for someone that you know that lives in MA. Okay,
Hi, my name is Miss Kelly here, and I was just wondering how I can get a refund on my taxes for this Karen Reed 2.0 trial shit I'm watching. I heard y'all busted through about 4-5 mil. I'm gonna need my money back.
You ain't from Mass with that accent.
Yeah, I live in Section. Don't you worry about. Don't you worry about where I live. I just moved to town.
You're not a local. Whitechapel.
Right. I'm actually surprised. Well, I guess he started after lunch, so 2. Yeah, he said he would go about an hour and a half. So he was right on schedule. I thought it was great. Right there at the end, he was like, "Oh, that's the stuff that you guys were laughing about last time, right?" That he got that in, and AJ stood up. I cannot believe that he asked him about his ham sandwich, waiting for a ride to the airport, and then you went and stood in the corner, huh? You guys, that's going to be in transcripts. This, like, you want to talk about reading something on your channel? Fucking read this shit. This is.
Read these transcripts.
Yeah.
All right. I'll ask.
I mean,
look.
This is like.
Oh wait, why are they taking press passes? Whoa, that's weird. The bailiff.
This is like a comedy. Yeah, it's because it's the end. This is like a comedy show, and also like a true crime, like murder mystery drama with comedy in it.
Well, that's what I do is read transcripts on my channel. Do you want to read them with me? Who are you gonna play? Because I'm not gonna let you have AJ.
Randy because he doesn't talk. That's the part. I need a vacation. Shit. Okay, let me talk about this expert witness crap. This is hilarious. So, okay. This is what Hank wants the jury to hear about expert witnesses that he just went forever on.
I love that term.
He said, there is one more point about witnesses to address, expert witnesses. This term refers to witnesses who have specialized training or experience in a particular field. Generally, in cases that are tried in our courts, both civil and criminal, witnesses may testify only to facts that are within their own personal knowledge. Well, then why are you asking him about Dr. Wolf? So, like, right there, just totally blows him up. That is, things that they have personally seen or heard or felt. However, in a variety of cases, issues arise that are beyond the experience of lay persons, and in those types of cases, we allow a person with specialized training or experience, called an expert witness, to testify, and to testify not to only facts, but also to opinions and the reasons for his or her opinions, which he kept objecting to hearing this man's opinion, and to testify, and on issues that are within the
issue for the day. We will see you tomorrow morning. Those same cautions, please do not discuss this case with anyone. Don't do any independent research or investigation into this case. If you happen to see, hear, or read anything about this case, please disregard it and let us know. We'll see you tomorrow morning.
All right, so jury.
There's going to be talks about it.
And the camera will pan down. There we go.
May be seated.
All right, so Mr. Brennan, I'm going to take a recess. You go ahead and look at that PowerPoint. I'll come back out in 10 minutes regarding the PowerPoint.
PowerPoint. Here it is. It's Ellington. Let's see whose PowerPoint it is. Or wait, no, wait. Is this going to be, wait a second. Is this, hold on.
Arca?
No, this might be his PowerPoint.
Who is his? There's a lot of his.
The Dr. Renschler who just testified.
That's what I said. The Arca guy. You go, no, it's going to be his.
Oh, I didn't hear you. I didn't hear you say Arca. Oh, hell's bells. Oh, hell's bells. Well, let's see what else we got. Let's go to Twitterland just so we can see a couple tweets.
Okay,
we'll read off some crazy people tweets. Now,
crazy people.
This is, oh man.
Signed up for craziness.
Who is she talking to and why? Corn Pope says, who is she talking to and why? And it's a picture of Bev. She says, just when you think things couldn't get more shady. This is the.
I like what Jessie Cat says, and she says, Hank is using a lot of words to say no one knows anything.
Oh, here we go. Olivia Lambo says 28 minutes ago, breaking. Hank Brennan admits the Commonwealth has not and cannot satisfy their burden of proof beyond a reasonable doubt. Unclear if this was deliberate.
Has been clear that he does not know. Let me say this differently. You would agree, Dr. Welcher has never stated in his report that he can identify the speed at which Mr. O'Keefe was struck in a collision.
He does not state what he thinks the speed is. That's correct.
He never states how far, if at all, Mr. O'Keefe was thrown after being in a collision.
That's right.
So then what's up? That's right. That's right.
The speed. You don't know the body position.
Oh my God, you guys have to show you something. Oh my God, please.
You cannot replicate.
Oh my God, how am I going to
Collision
do
with
it?
crash test dummies.
I'm going to send it to you.
Scientific survey.
Well, you're right. You can't prove that that actually occurred. That's the basis. Yeah.
So,
if you don't have the information, you can't replicate what happened. You can't determine, you can't state to any conclusion of accuracy what actually occurred if you don't have the evidence.
It is very clear that the jury is getting fed up with my bullshit, and a not guilty verdict is imminent. I've tried to hide my bias, but with the recent ruling after Hank made shit up about the holes on the back of John's hoodie, I can't hide it anymore. They have noticed that if Hank objects, sustained. If anyone on the defense objects, I'll allow it. Can you please turn the fucking fan off so the people on TikTok can hear me? Why am I always sighing? It's because I have to watch all these corrupt cops and McAlberts fuck up the frame job we have been working on for years. It's finally time for me to pull this gavel out of my ass and say it once and for all. Free Karen Reed.
Good old TikTok. Good old TikTok. Good old Twitter. They just turned Bev into a. Here we go.
No, check your messages. Show what I just sent you. It's funny.
Okay, please hold on. John DePietro show. Karen Reed defense decided not to call Trooper Proctor. Interesting. This is all I want to read about him because he's just, oh, hell no. This is Lally and Rescue Randy together. And it says, did I rescue you or did you rescue me?
You're going to have to put your hand behind because it's focusing on you. So you're going to have to do what makeup artists do.
No. I have it like that for a reason, but I'm just saying, like, you clearly see what it is.
No, you clearly don't because it's blurry.
No, that's what I mean. You clearly see what it is. It's all. Girl? It's for Gay Pride Month, by the way. Aiden, Dr. Turtleboy says. Oh, let's go with something more recent. That's not. Let's get some of the people that are pro Karen or pro prosecution. Kay Marie says, controlling much, Janet Reed 3 hours ago, and the blonde next to her needs to be thrown from the courtroom for her behavior. Sassafras. Again, the defense-owned witness looks like he's a Commonwealth witness. He worked as a team with Dr. Wolf, and he showed us how an arm can shatter a taillight. You guys think that you're going to go into this deliberating room with, I mean, this is what people are, 28,000 people read that. 28,000 people. Here we go. In the corner, weighing in at 175 pounds, Dr. Welcher and his ham sandwich. There you go. Coffindaffer. People are asking to see Coffindaffer. You know, I have to like Google her. She's not like someone I don't even really get on Twitter, but let's see. Jennifer Coffindaffer said. Okay. Mainstream media picking up on the what? Callousness that we've seen that we've watched all trial. John O'Keefe is dead. The evidence shows Karen Reed was drunk and angry and hit him with her SUV. 1 hour ago. 1 hour ago. I'm sorry, 3 hours ago. The problem with the defense expert is he can't explain the taillight debris field, DNA on taillight pieces. The what? There's no DNA on the taillight pieces. What DNA is on the taillight pieces? Hair on vehicle. Why Karen Reed reversed at 24 miles an hour. Why John's phone didn't move after he was hit. Why Reed screamed she hit him. Why Reed knew exactly where he was when no one else could see him. Why she told Carrie Roberts that John was dead at 5 a.m. Why his glass was by him. He has no idea about where John was standing or John's posture when he was hit, nor does anybody. His opinions are based on guesses. Thus, the very basis for his calculations rely on imagination, not facts. And y'all want to think that you don't need to call Ellington to the stand. Dude, how can people like somebody that was in the FBI, like her, literally make a post like this? And basically what you've just told me, I'm going to say, yeah, and neither can the Commonwealth. So isn't that considered a neither can the Commonwealth. Isn't it obvious this case is reasonable doubt? I mean, I'm being serious. Being serious. Innocent or not. How can you convict?
Per Ted Daniels, I won. Ted Daniels says 15 minutes ago the defense rests.
Innocent or not, how can you convict? Well, duh, because he's going off of that. He was the last witness.
No, he was in the courtroom.
Ted Daniel packed it up. He left at lunch. He ate a dick and left.
I swear he just got his thing taken away from him.
Innocent or not, isn't it reasonable doubt?
Yes, don't be a sore loser, Lana.
I already said I'd buy you the steak. I don't think you listened this morning.
What? Excuse me?
I don't think you listened.
I was giving you grace.
Grace.
And letting you go until they rested.
I already said pick the place.
I won.
You know what? I think it's a bad thing that you won, because if I'm Karen Reed, I'm not putting Dr. Elling, or not doctor, but Mr. Ellington on. I don't know who spends 15 grand on at least an expert and then just doesn't use them, especially with people like this writing shit. We'll see what happens. Anyways, going back to Twitterland, all the fucks. Jennifer Coffindeffer one day ago. I worked today, so missed part of the Karen Reed trial. What are you doing working? I thought this was your job. Like, this shit. I just got caught up. Alessi, counsel for Reed, donning black gloves, dramatically asked for a mistrial with prejudice. Why? Brennan, counsel for the Commonwealth, showed Wolf, defense crash reconstruction expert, victim John O'Keefe's hoodie. He asked Wolf about holes in the back of John's hoodie, indicating they could be from the MVA, motor vehicle accident. In fact, the holes were made by a criminalist. My mom told me when I was very young that the only perfect man died on a cross. This fucking bitch is going to bring up Jesus Christ. Dude, you know what my mom told me? People that fucking put Jesus Christ in arguments are fucking sadists. Take that. Who brings up Jesus? Who? Brennan is not perfect, although the trial had been going perfectly for the Commonwealth. Brennan admitted he made an error. I wish he would have ran his question by Lally. That's what I said, Lally. Lally knew. Who knows this case better than anyone? Lally would have known about the origin of the holes. He should have known the moment that he started the line of questioning. And if you're reviewing, what wasn't Lally reviewing with you, like your case, like your cross-examination? I'm so glad that she said that, because that should just show you, Jennifer, you're biased. Like, she says, I've been covering this case from the beginning and did not recall if there were holes on the back of John's hoodie. We all knew that there were not. There are a lot of holes in that hoodie after all. Oh my God. It was a mistake. It certainly did not warrant a mistrial and was cured with the judge's instructions that the holes were caused by the criminalist. Wow. Dude, this is what I'm talking about. You want to go into a deliberating room? You don't think there's going to be Jennifer Coffindeffers on that jury? Fuck out of here. People like that, and then bring in Jesus Christ. You leave my God the fuck out of it, Jennifer. Okay, you hear me? Talking about the only man perfect died on the cross. Well, I think Rescue Randy's pretty perfect. Ridiculous reading her shit. I love the debater though, and you know what? If I want to hear it again, I want to hear who tagged me with. Okay, you guys ready? This is Andrea yesterday, and it's the best thing since sliced bread. Oh, thank you.
Welcome.
Mm-hmm. Thank you. Look at your kind, sweet heart. There you go. Okay, let's see. Let's see if I can play this puppy. Here it is.
About thrust. I'm asking if you have an opinion. Your words.
We know you don't know about thrust,
About
Hank.
thrust.
We wish your fucking mom didn't know about thrust.
Usually a judge is
What? Burkhart? Like, no way you go with.
about thrust. I'm asking if you have an opinion. Your words.
We know you don't know about thrust,
About
Hank. We
thrust.
wish your fucking mom didn't know about thrust.
No, sister, did you look at any information that would...
You guys, I rub off on the best of them. I think that, I'm always like, I think that might be the comment of the trial. Okay. Like, maybe I'll give out some awards for the Karen Reed best whatever, best blah blah blah. But that literally, I think that should win.
About thrust. I'm asking if you have an opinion. Your words.
We know you don't know about thrust,
About
Hank. We
thrust.
wish your fucking mom didn't know about thrust.
What happens when I spread my load out? When I lay in my bed like this?
Oh, gross.
I mean, there's some really good ones.
We could totally have a show.
About thrust. I'm asking if you have an opinion. Your words.
We know you don't know about thrust,
About
Hank.
thrust.
We wish your fucking mom didn't know about thrust.
Afternoon, Dr. Lapasada.
6 minutes till the afternoon. Good afternoon. Okay.
It's okay. Does MRIs show contusions on the brain?
Well, they might.
Subdermal hemorrhages?
Subdural hemorrhages.
All right. Suffering brain injuries, but there's an attempt to save them.
Sure.
Have you ever heard of a Guzma coma score?
Glasgow, you mean?
No, but there's Glasgow. But you've heard of Guzma?
It's called Glasgow comas.
Can't be saved. Did you know that about 1/3 of them do get saved?
I don't know what you're talking about. 1/3. Everybody has different sorts of injuries. 1/3 of what? So it can happen within minutes.
Do you have any studies or literature to support that?
That's my training experience. I can't cite you a particular article at this time. I could certainly go look it up and bring it to you.
Okay. Orbital bones were broken, and you had opined that it was caused by the brain. Do you agree that a brain is very soft, consistent with, for example, tofu?
Oh, gross. What do you mean?
Okay, let's see what else we got going on here. After jury's excused for lunch, Brennan asked judge to challenge the credibility of Dr. Lapasada based on published reports, including an audit when she was chief medical examiner of Rhode Island. Hank Brennan, there was an extraordinary number of individuals that were improperly handled. Fuck shit. Okay. Mark Betterow. Many people believe the case against Karen Reed is flawed and rigged. Many who believe she cannot get a fair trial and have little confidence in the Norfolk County District Attorney's Office and the criminal justice system as a whole. Days like today further these beliefs. What a horrible display. What a horrible display in front of a national and international audience. Go America. Fucks. Let's see. Okay. Aiden Carney. Yesterday. Let's see. Bella, pick your place in around Huntington Beach, Cali. See if there's any steak places around there. I think before we start every court, we should have to play the national motherfucking anthem. Remind everybody where we're at. May we all rise to the singing of the national anthem. Turtle Boy said, I just agreed to have a bench trial instead of a jury trial. The trial will take place in the main courtroom of Dedham District Court in front of Judge Pomeroy. It will take place over 2 days from 11 to 1 today and 11 to 1 on Wednesday. I am now seated inside the Karen Reed trial as I got one of those standby passes and will remain here until my trial at 11. We've donated to his fund more than we've donated to Karen Reed's, only because for personal reasons. I know what it's like to go through what he's been going through. And, you know, Karen obviously has a lot of supporters, and I'm sorry, but if it wasn't for that man, Karen Reed's case would not be where it's at. As well as a lot of the locals that went out there every fucking day. So you know who you are, and we love the shit out of you over here. And we try to give you as much praise as possible. Let's give, you know who else needs praise, guys? If it wasn't for Bella the past 2 days, we wouldn't be here. Wait, is today Wednesday? Monday, Tuesday, Wednesday. Has it been 3 days in a row? Chop House in Newport Beach. Is there anything in Huntington? We don't really want to go to Newport. I want to be able to stumble home, because if I say I'm buying steak dinners, I'm going to have to get some like fancy drinks for her too. Like she likes those Valcarrays or whatever they're called. I'd just rather not see the bill and just hand my credit card over when you take Bella out. You know that's right.
I want to know who's doing Karen Reed's civil. Who's taking on Karen Reed? Yes. So please, where's Bella? Yep. Thank you. We wouldn't be here. We wouldn't be here. Chop House, amazing. Get the filet. Oh, there you go. Thank you, guys. Where is she? She's somewhere. She's around here. We wouldn't be hearing the birds chirp either. So I like to argue with Bella if you can't already tell. It's all in love, though. Okay. 5 hours ago. Mama Llama. I can't believe a defense attorney and his witness clearly planned to wish the witness's child a happy birthday while testifying in a murder trial. What? The judge tried to shut it down, but of course, they were determined to force it in. The victim's mother is sitting just feet away. What? The victim's mother is sitting just feet away. She wakes up every day wishing she could say happy birthday to her son. What? I don't care what side you're on. What they did was completely inappropriate and beyond fucked up. What the hell happened? Somebody's birthday's today? And somebody... I can't believe a defense attorney and his witness clearly planned to wish the witness's child a happy birthday while testifying in a murder trial. That was seen by 8,000 people 5 hours ago. Jennifer Coffindoffer's live right now. I'm going to write it on her fucking channel.
I'm willing to let you move on despite what you've done to affect this trial. Because she also was conspiring to get the first juror that got thrown off through what seemed to be her lies. We know that from the judge, what she revealed about the sidebar early on in the trial.
I like Daniel.
I mean, so this, you know.
Can you imagine me being on a panel with Jennifer Coffindoffer? Like, give me all these fucks. But see, I'm not going to be motherfucking people because Dr. Wolf is getting hootin' and hollered as he's going to the courthouse. Oh my God. Oh my God. Have you guys seen this? This poor woman, she tried to confess her love and she like biffs it on the lawn. I mean, on the sidewalk. Is that for real? Who's this woman, Carrie? Oh my God, you poor lady. Do you guys seen this shit? Humiliating. Well, it's gone viral. See, okay, K. Marie, 13,000 people, 238 likes. See what I mean? She says, Renschler is a scumbag. This is all about him, right? Wishing his child happy birthday while on the stand and a murder victim's family looks on just wanting justice. Oh my God, that's what this is about?
Details matter. There is, yeah. I would like to explain an example of what's important with that. So I was going to say, I have 3 kids. A 9-year-old who's actually turning 10 today. Happy birthday, Kai. And I have
They're pearl clutching. And they're pearl clutching. What are they doing?
Oh my God.
I'm sorry.
Oh my God. The waves have gone crazy because this man wished his son a happy birthday on the mic.
Everyone needs to calm down, stop clutching your pearls and being precious.
I would have done the same thing if it was Jax's birthday and I was testifying. I would have been like,
what would you have done?
I would have said happy birthday to my boy as well.
But I don't think that Dr. Renschler asked for that. They just said happy birthday, right?
No, he said it.
What did he say?
He said he was talking about his family. He's like, yeah, I have 3 kids, one of which is he's 10. It's actually his birthday today. Happy birthday, Kai.
Aw, yeah.
Yeah. Okay,
that's cute.
You're gonna
Everyone does that.
You know, you're gonna have at least one of these people that are like thinking like them.
You mean on the jury? Finish your thought. Yes.
Yeah. And I think that there's going to be more than one. I think there's going to be a couple. I think there's going to be,
Sure, maybe.
I think it's going to be like when they walk in there, it's going to be 10, maybe 9-3. I mean, I'm hoping that's 10-2, 11-1.
But listen, like these are just people that have no content, and this is what they're grasping at. Because literally everyone who has a mic in front of them when it's their children's birthday or someone they love's birthday always says, that's just what you do. It's kind of almost like a known thing. It's almost like the American way. I don't get why they're being precious about it, but because they have nothing else.
I think if you can make if you can like make arguments and keep like either side out, but like why can't people just go across the board? And if you go across the board, this is the case that it's like reasonable doubt if on the mere fact alone, the investigation. Jennifer Coffin, you're an ex-Fed. Like you know who Michael Easter is, motherfucker. Like,
yeah, and she didn't allow Michael Easter to testify.
So it was Renschler's child's birthday today, and people going crazy about that. He said happy birthday to his kid.
Like, now, how evil do you have to be? And I really hope the O'Keefes get upset with this, because you guys are assigning like evilness onto the O'Keefes when they're not even asking for it. You're saying that they're upset over it. They're not. Anyone that has a good heart doesn't give a fuck someone gets up there and wishes their kid a happy birthday in the middle of shit.
I'm going to ask JLR if I can have him on my show and ask him, like, real, why does he think Karen Reed's guilty? What do you guys think?
Do it.
Nothing like a good suck. Nothing like a good lick.
What are you eating?
Jax gave me a popsicle. He split his half with me.
What flavor? Is that lime?
Green. My
green.
Put us back in session and be seated.
Okay, here she does their attitude.
All right, so I had a minute to look at the PowerPoint. Are you in agreement on the PowerPoint?
We're not. I do not want to admit it. I don't think it's substantive evidence.
Wait, what?
Okay. Mr. Jackson?
Exactly the substance of
Which was not objected to, right?
No, the court keeps saying that, yes, there were things that were less like evidence, so yes, there were things that.
But did he object to the PowerPoint coming in?
We're all under pressure. I don't know what Mr. Lesson's going to do regarding the PowerPoint. That's the question. The question is whether this PowerPoint is admissible, and it is. There's nothing in it. We've taken out all hearsay, discussion of the opinions or thoughts, thought processes. These are all tests that were completed and done exactly as Dr. Lewis' PowerPoint was done. Dr. Lewis' PowerPoint was in evidence. This PowerPoint should be in evidence.
Is there anything in this PowerPoint by way of videos that is not already in through Dr. Wolf?
I believe the video of the drop test is in Dr. Welch's PowerPoint. There are most of the videos are included. Oh no, I'm wrong. Things have been slowed down. So there are videos of the same, but the videos that Dr. Renschler used because of the side of the case that he was handling, the biomechanics side of the case that he was handling, slowed down significantly to show the deformation of the arm, the force impact on the elbow, the hand, forearm, which he testified. So what he did, and I remember asking him this before I ever saw the PowerPoint, is there going to be anything different? He said, I use the slow motion cameras more than Dr. Wolf does because I need it.
Okay, so I need you to tell me tomorrow which slides specifically answered that question for me. Okay, whether they're in evidence or not, and which ones are not, regarding the videos. Maybe. I'm going to take a look at it. There's an objection before me now, so I have to rule on the objection. So I will take a look at this, okay? So if you let me know, and if you want to let me know tonight, I can let you know first thing tomorrow. All right.
Have you heard briefly?
Yes.
Very briefly?
Yes.
I am objecting, it's not admissible, it's hearsay, it's a strategic decision. The past introductions have been strategic. The defense did not object to Dr. Welchers. I did not object to Dr. Waltz, but that was a strategic decision. I'm objecting.
Okay.
The defense objected to Shannon Burgess. Only a select amount of documents were allowed. I wanted the whole thing in. I was precluded properly from introducing it because it was hearsay and they objected. I'm objecting.
Okay.
There's no hearsay. They objected to certain slides. We took out the slides. If they had an objection to the PowerPoint, they should have posed that objection before it was displayed for the jury.
Well,
The jury's now seen the entire PowerPoint. I think it's tactical. It's not strategic. It's tactical. They just don't like it because it hurts their case. If they didn't want to put certain things before the jury,
Yeah.
which is exactly what admitting it into evidence does, brings it before the jury. So if
Yes.
they didn't see it, they should have objected in a timely manner. When they objected, they chose certain slides, certain data on certain slides, and we took all of that out at their request and at the court's instruction. We did that with the court's instruction, with the Commonwealth's instruction, and there was no objection to playing before the jury. Given the fact that it's been displayed not in part, in whole, as it now assists for the jury, assists for the court for quadruple K for identification, it should be admitted.
Okay.
Just like Shannon Burgess. It's no different.
All right.
It is different.
PowerPoint is in evidence.
So, Mr. Jackson, when you let us know which slides answer my question about slides that are not in evidence and you want to put in evidence, the videos, just the videos, let me know that. And if need be, I'll hear you all on this tomorrow morning as well. Okay. All right. Is that it for today? Will we see everybody just tomorrow morning? What else do?
Mr. Leslie needs to, I didn't mean to interrupt.
After the defendant rests, we will not be calling any witnesses, putting on any further evidence.
Okay. All right.
Oh.
Your Honor, it's late in the day. We would like to review our motion to require finding of not guilty after the close of all evidence. It won't be a lengthy argument, but I'm happy to be heard on that in the morning if the court prefers what we got tomorrow morning.
Okay. Is that all we have left now? I have no idea what Mr. Alessi wants to talk about, but would it?
I'd like to respond to that, Your Honor, and the answer is, given Mr. Brennan's answer with no more witnesses, my issue is moved.
Okay, great. So,
The technical thing is we need to move in the 3 items of evidence, the documents associated with the sweatshirt. I think they've been marked for identification.
no, they were marked as evidence,
Yeah,
right?
They're correct, Mark, you did.
Yeah, they're exhibits.
Jim did it.
They're come into evidence, Your Honor, I mean, ruling this.
Are they?
I thought they were marked as identification, not evidence. If they're in evidence, they're in. If it's identification.
So I need to find that. It would be my intention that they get put into evidence. I'm not going to display them and bring a jury in just to see those at this point.
I'm not asking for that.
Okay.
As long as they're in evidence and I can use them in closing argument, then so be it.
If I can, for clarity, Your Honor, there are exhibits. I have Y.
So that's not an exhibit, Mr. Alessi, if that's how it marked. That's identification.
I have a different parlance. I'll use this court's parlance. Yes, it's YYY, ZZZ, AAA, BBB.
So that means that, all right, so that's for identification. Letters are identification, numbers are exhibits.
Your Honor, I understand that. We all know what we're talking about, and Your Honor agreed that they're going to be in evidence.
Right. So, and I've ruled that they're in evidence. I just need to know for this record whether they're in evidence or not. What you tell me, you just told me they're in evidence. They're not. They're exhibits. They're identification. Now they will become exhibits. Can we do that now? Do we have them? Where are they? Oh, Jim, they're in there? Okay.
Yeah, and Your Honor, my whole point in wanting to be heard is that they're not in evidence, and I want to make sure they get it. That's my point.
Her exasperation is just annoying with them.
What number are we at, Madam Court Reporter?
To the 230.
Okay, and we'll do A, B, C, D.
I think Dr. Walter said absolutely not.
I, Z, A, and B.
Why are they laughing? Why is Nolly laughing? little kitty huddle they had right there. Pork sandwich.
Counsel, I'm not sure I have those.
All right, so we will make, so as of now, they're in evidence. Tomorrow we need to physically put the sticker on those.
Can I stick another while we're waiting?
Yes.
230A,
I'm sorry, say that one more time.
230A through C, 230C.
All right.
Council, there are four,
Four of them,
A through D.
just so the record, this is limited to 10 different things. They were marked for identification as triple Y, triple Z, quadruple A, and quadruple B.
Okay.
And all I need to do for my records is figure out which one is which in terms of the whole court's marking. So as you do that, I'm good and I'll get out of here.
I'm good out of your hair.
We will do that first thing tomorrow morning.
Why?
Right?
Why?
We
That's what
will,
we
so everyone is in agreement then. I will let you have tomorrow without the jury. We'll have our charge conference here in person. Then I'll give you the rest of the day to get your closing arguments ready. I'm imagining that you don't want to argue tomorrow morning at 9 o'clock. Is that fair?
That's fair.
Mr. Brennan, are you in agreement?
I'm in agreement. I'm not interested in arguing tomorrow.
Okay. All right. So we'll give you tomorrow. We'll have a charge conference tomorrow. I'm going to ask the court officers to call the jurors tonight as soon as possible. This is great that you did it. I was going to give you until 7 o'clock tonight, but if you're certain, then the court officers will call the jurors now and let them know they don't have to come in tomorrow. And then when they come in Friday morning at 9 o'clock, we'll do arguments and charge. Tomorrow morning will be the charge conference. Since we don't have jurors, do you all want to come in at 10 o'clock instead of 9 o'clock?
That would be great.
Does that work for the Commonwealth as well?
Yes.
Okay. So I'll see everybody tomorrow morning at 10 for the charge conference. Do you have them now, Jim?
I do, Judge. And just for the record, YYY, ZZZ, AAAA, and BBBB are 223A through D.
Yeah. Remember? That's how you wanted them.
In the same corresponding order. So you know what they are, Mr. Jackson?
Yes, he does.
In order. Okay.
223.
Thank you. My only other question, Your Honor, was regarding the parameters of closing argument. Last year, we were relegated to 1 hour. I would ask an hour and a half.
You're talking about how long before the closing?
I know, but what'd she say?
No, I got it, but now you can vote.
Tori.
I would ask for. I would ask for an hour and a half for a final summation, given the case, the length of the case, the amount of evidence that's been adduced. I think that's outrageous, and the court normally allows only an hour.
You might get an hour and 15 minutes out of
Oh,
it.
fuck you, Beth.
Let me see. You would not have got an hour and a half by asking for 2 hours. Mr. Brennan, what are you looking for? Do you want the same?
I don't have a position. I'll take whatever the defense is.
Let me think about it.
Yes,
All right.
Fuck you,
so
Beth.
we will see.
Thank you.
All right. So I'll see everybody at 10 o'clock tomorrow morning. Is there anything else we need to discuss?
No, thank you.
All right. We'll see you tomorrow morning.
You want to fucking undermine him by taking 15 minutes away from him? From what he asked? What the fuck's wrong with you? You have a fucking power struggle between your fucking legs. I can't stand this shit.
You wonder why they call you bitch. You guys know that song? Let's talk about that song for a minute. You wonder why they call you bitch. Let's talk
Wonder
about
why they call you bitch.
Yeah, I'm about to play that
Wonder
shit.
why they call you bitch. Wonder why they call you
Wonder
bitch.
why they call you bitch, Bev.
It's Tupac. So you guys, there's no rebuttal witnesses because do you understand? Hank just got spanked so hard that he is not bringing Welcher up.
Wonder why they call you bitch. Wonder why they call you bitch. You 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 wonder why they call you bitch.
Fuck you, Bev. Yeah. Okay. Well, the defense rests. You guys, Karen Reed 2.0 in the books, except for the closing arguments. Again, give it up for Bella. We would not be here Monday, Tuesday. Today is Wednesday for the past 3 days. She went to steak dinner and Valkyries. What do they call them? Valkyrie.
Valkyries.
Yeah,
No, they're Vocaries, honey.
The
The drinks. Are you finding a place that serves Vocaries? It's so difficult to find somewhere.
Yeah, well, Mitchell's does over here. But I got my.
So you
I got my
can
friends on the
see.
hunt.
You can see that I won the bet. But you're welcome. Let's just start with the first thing. You're welcome. My pleasure. Pleasure to be here with all y'alls. Love y'alls.
Everything has been fixed, and now I get to have fun and put up my
Hector.
No, I get to put up my new arm bars.
Oh.
I got
a Mikey.
3 new camera angles, so I can have multiple things going.
Good.
I got my new mic, my new arm. I got the works over here. Now I just need to call a Geek Squad guy. That way they can just
and get him to do it.
And then I got a new soundboard. Okay.
You didn't even, what happened to your old soundboard? Like, it was fine.
I got an old like DJ soundboard because I want to do some other stuff. Wah, 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 wah. I want to hit one of my buttons and it just goes right into like something sweet. Okay.
It's a Vocaray. It's my favorite drink. It's a New Orleans, you know how they speak French there. It's like a New Orleans, it's a really balanced, amazing drink, but not that many people know how to make it because it's like really high end. Like, but when they do it and they do it well.
It's very difficult to make.
It wasn't difficult, it's just difficult to make it balanced.
I want to talk to you guys about these jury instructions really quick. Just one last thing.
Yeah, tell us.
Both sides submitted what they wanted to be said. Inferences. An inference is a permissible deduction that you may make from evidence that you have accepted as believable. Inferences are things that you do every day, little steps in reasoning, in which you take some known information, apply your experience in life to it, and then draw a conclusion. You may draw an inference even if it is not necessarily or inescapable, so long as it's reasonable and warranted by the evidence. And all the evidence and reasonable inferences in this case together prove the defendant's guilt beyond a reasonable doubt. You draw such inferences every day. For example, if your son leaves your house in the morning with an umbrella, without saying anything, you can draw 2 conclusions. He thinks it's raining outside, and he intends to go out in the rain.
He beats the snowman for the Delphi trial. It beats the snowman analogy.
Those 2 conclusions are inferences about his knowledge and his intent. They are reasonable because you know that's what such behavior indicates. So we'll be talking more about this obviously tomorrow, but just kind of want to show you. This is Alan Jackson's and Aleshi's, and it's 35 pages, and Hank's is 17. We'll go over it tomorrow.
Double.
What they mean by the charging is, I think they're going to make a last push to get some of the charges, if not all of them. Like, you know, now that you've seen our stuff, blah, blah, blah. They can do that. They can make a push for the charges. That's what they're going to talk about in the morning at 10, outside the presence of the jury. They're going to be discussing, she's going to make a decision on the PowerPoint presentation. Is he objecting to cumulative, or like, I don't understand. Like, Renschler was the one that did the report. I don't understand how his report is hearsay but that would make everybody's report hearsay.
Make it make sense.
Also, tomorrow, we're going to break down every day and every witness that testified. And we're going to break down the over and unders to tell you guys all of that.
Do you think you won or Andrea? Do you already know?
It's super close. It's we have objections on the like how long. Here, let me see 1 second. Let me see. Let me grab my thing here.
Cherry Blossom, you'll eventually be able to change it back. I don't know the rules if anyone can help Cherry Blossom with that, but you'll eventually be able to change it back.
Okay, so like for example, number of total witnesses, it was 72 and a half. Obviously that was way under. We both went over. So we're both out on that. Total number of witnesses who mentioned the weather was 50 and a half. Obviously, we're right there on the cusp, but of having even 50 witnesses, but not all of them. So Andrea picked under. And I picked over, so I was hoping more witnesses would testify. So we'll do another. We didn't even have 50 witnesses testify in this case. I'd have to have every witness say something about that. So far, we haven't had any jurors removed, which was unless we get something happening, but we both said over, so we both be out on that. So I was just going through the over and unders that we were opposite on. Number of total trial days, opening to closing only. I said over 36 and a half days. She said under 36 and a half days. It's 31. Well, to closing, so it'll be tomorrow's. She gets it. Opening, closing only. Number of witnesses who say the phrase, I hit him. We both went under on that. Number of witnesses Jackson cross-examines, 31 and a half. So we're doing another tally because I said over.
Of course.
She said under. I need that one. So we're doing another tally on that. But 31 and a half as far as witnesses that Alan Jackson cross-examined. Alessi came in and swept up some. So number of witnesses that Little crosses. I said under 8.5. I got that one. She said over. Number of witnesses Yannetti cross-examines, 16 and a half. She said under, and I said over.
And
we're
you have to count it?
We're going to do another because it's coming close. So number of witnesses Alessi cross-examines, it was 9.5 was the under over. We both said over, so it's like doesn't matter. Number of witnesses ADA McLaughlin direct or crosses, 1.5 was the over under. I went with the under. Bitch, sit down. She didn't even get up. She did 1. And she didn't even ask a question, but it was under, so I got that one. Number of witnesses Lally directs or crosses, he actually went over and we both said under. Number of times Lally says, what if anything? I said over, 42 and a half.
He amended himself a lot this trial.
Brennan, let's see. Brennan's shortest direct examination of a witness, we both said under on that. So they both said under on her. Okay. Total number of times Julie Nagel mentions a McAlbert. The bitch didn't even testify. What a letdown. Number of times house long is said during forensic expert testimony. We both said over. Total number of different YouTubers in the courtroom. I said over 12 and a half and she said under. So we're doing another count on that because it's going to be close. Number of new trial witnesses. We both said over 11 and a half. So since we both said over, it's like, doesn't matter if it happened or not. Okay, under. Number of total witnesses who will view an exhibit from the projection screen. 49 and a half is the over under. How many freaking You know, I think that's basically what we had as far as witnesses. And not everybody viewed the screen. I said over, she said under. Number of trial days at the projector screen is used, period. It was 28 and a half, and I said over, and she said over as well, though. Number of total minutes that Lank is on the stand. Bitch didn't even take the stand. We both said over, though. Number of total minutes, Chief Helena Rafferty is on the stand. Bitch didn't even take the stand. I said over 60 and 65. She said under. So that's to her. Over. Okay, here. Number of times Trooper Proctor cusses on the stand. Didn't even take the stand. I mean, who could have ever expected that? Betting on the opening and closing. So here we go. The closing, we have the total number of objections and closing arguments. So she's predicting that there's going to be an objection during closing arguments. I said no. That's going to matter. We'll
on each side, or did you just say
in total?
General? In total. Okay.
Yeah.
You really said no. Okay.
We both said over to the number of sidebars. Total number of days Bev wears her hair up. Bitch let me down. Didn't
You knew you were gambling with that one, though. You knew it. You should have just gambled with Proctor being on the stand or not being on the stand. That would have been the balls out gamble right there. You could have come out. Boom.
I won this one, though. Total number of trial days Bev starts later than 9:12 a.m. Over under was 18 and a half. Bitch smoked it. Lana said the over.
What did Andrea say under?
Yeah.
She did?
Yeah. Betting on the McAlberts. Again, remember, so many people didn't testify. So number of times Kellen Albert says, I don't recall / I don't remember. We both said over, so doesn't matter. Number of times D&E is said during Chris Albert's testimony. I said under. She said over. Chris Albert didn't even testify. So good thing is I get that. But number of times Gemma Cabe looks at the jury. When you say like it's to the left, we both said over. We both got that. Total minutes Gemma Cabe is on the stand. It was over under was 280. I said the over. I got that. She said under. Number of times Gemma Cabe says her name Jen in third person voice was 4.5. We both said over, and she said it 4. Number of times any McAlbergans, that's the McAlberts plus Higgins, say Buttdow. We both said under. We got one. The name Buttdow came out once in Jennifer McCabe's testimony. Number of times Brian Albert says Chloe. We both said over. He didn't testify. Total number of minutes for Paul O'Keefe being cross-examined. We both said over a minute. He didn't even testify. Total minutes Bill Reed is on the stand. We both said over. Bill Reed didn't testify. So I'll be adding these up. Right now, we're at both 1.
You know that you started this by saying you were going to calculate this and talk about it tomorrow.
Okay, I can do that.
No, but it's good. You were doing it.
What else? I don't get it. I don't get how anybody could watch this trial from start to finish. And I don't care if you think she's innocent. I don't care if you think she's guilty. But there's two things. This wasn't a fair trial, and reasonable doubt. Like, you don't know. Like, you can't listen to those guys and listen to these doctors and say that you know more and that it's murder beyond a reasonable doubt. Like, that's like how anybody has arguments, like it's like the definition. It's like, how are you going to change what the definition of reasonable doubt is? How are you going to change what the definition of
here's an autopsy and here's a medical examiner that performed the autopsy, and she can't even decide, she can't even label it, a homicide. How then can a juror do that? I don't get it. It's bothering me.
It's so blatantly obvious to me that this is literally all you need to do, right, is prove one little thing of reasonable doubt. And like I keep saying, the last 3 substantial witnesses, it's reasonable doubt upon reasonable doubt. It's not even like expert witness opinions that are held to a really high degree. It literally is reasonable doubt all day long. So there's no way legally, factually, you can find Karen Read guilty by what the Commonwealth put forth in the second trial. And this isn't anything other than she's acquitted, and that's unfortunate. It's so unfortunate that she is going to be acquitted instead of exonerated, but I hope that it'll move. I hope she moves to be exonerated. But anything short of that is a travesty of justice for all of us.
Yeah, it's it's gross. I'm gonna bring up something really quick too, just because I'm in the mood.
Wonder why they call you a bitch.
Yes.
That one?
No, I got this right here.
Messing around.
No. This.
Oh, look at you sharing screen. Shoot.
Okay. So back to this really quick. You guys, I feel totally differently now.
Oh.
Based on, well, because when you get more evidence, you have to consider it.
Absolutely.
Okay, look at this.
I'm proud of that.
Right? So the one thing that I will consider here, and that we all should consider, is
what now we're looking at the spreadsheet that Lana put together with Jen McCabe's phone and watch. Data.
Yeah.
Potato.
Okay. So, okay. Take a look at this. So, she leaves the waterfall bar. She has her watch. She has her phone. This is her steps with her watch, right? And this is going to be her total steps with the phone, but watch. She gets out of the car. Do you see this? 12:18 and 50 seconds. 12:19 and 46 seconds. You see that?
Go ahead and make that the biggest thing on the screen.
It's not. Okay, hold on one second.
I don't know how to do that one.
Okay. Okay, so that's as big. Now watch this. Oopsies. Okay, right here. She gets out of the car for sure 100% at 12:18 and 50 seconds. You guys see that? Where it says 12:18.
Yes.
That is her getting out of the car at 34 Fairview. Okay? So what you can do here is, because as you can see how it only goes until 12:19 and 22 seconds? And see how it goes from 12:18 and 50 seconds to 12:19 and 46 seconds? See that? See how it goes? See how the watch walks for an extra 24 seconds?
Yes.
See how it's calculating that? Okay. Now, what we can for sure say is that if she wouldn't have been wearing a watch, now this is so big. This is like Lana brains. If she wasn't wearing a watch, all we would have is her phone data. Okay. But guess what we can prove from this? Because we do have a watch. We can do deductive reasoning. So what you do is, and it matters for John O'Keefe, because you could do the same thing with him. So right here, let me go how I'll show this is when she gets out, these steps here, right there, without a doubt, 49 of the 154, see that, are at 34 Fairview, 49. So when you look at John O'Keefe's he had 170, and it
Total steps?
It was like looking at something like this without this part over here, because he just had the phone, and his were right here. When he left Waterfall Bar, his were from okay, 12:11 to 12:21, and it's 170 steps. Okay, so just putting this over here so people can see. Okay, so as you can see, oopsies, this is just, they're saying that during that time frame, which obviously we know that his steps started when he was walking and leaving the Waterfall Bar, okay? But they go all the way to 12:21. Then at 12:21, more steps. It is fair to say that when he would have gotten out of the car, that some of those steps from like 12:21, when he would have gotten out of the car and walked towards the house, that just like how Jennifer McCabe, if you don't have the watch on, you just see this, okay, which clearly she gets into the vehicle and leaves Waterfall Bar, but she has to walk to get to the car, gets in the car, and then she has to get out of the car, which only because she has the watch, we know that she gets out at 12:18 over here.
And 50 sub-seconds or whatever, seconds.
What the heck just happened there? Right there. Okay, yeah.
Hit the 80.
So right there you can see that if we wouldn't have, we only know this because she had a watch on.
Right.
But if you just had this, okay, you'd be thinking you wouldn't know that part of those steps, 49 of that 154, is from the, what do you call it? Is from actually getting out at 34 Fairview. But because she has both devices, her watch and her phone, you can prove that. Because am I making sense? If you have 154 steps
yes,
with your phone, and it goes all the way to 12, 19, and 22 seconds.
And this is Jen McCabe's, you guys. So this is based on her on the left two sides.
Yeah.
Her watch and her phone.
And so we know that she arrives, and that here we know she starts taking, because this breaks it down individually. We know she starts taking steps at 12, 18, and 50 seconds. So we know this total right here has to account, okay? How you could argue it is that it has to account for 49 steps right here. Yeah. So out of that 154, 49 of them happened at 34 Fairview. Okay.
Okay, because that's when she got out of her vehicle.
Yes.
Was it 12, 18, 58 seconds?
Okay. Then now check this out. Ready? Then when you look at John's and you have 170 from 12:11 to 12:21, there is
and he doesn't have a watch, so it's not broken down.
Correct. But what you can figure out that if the Waze is wrong
by 3 minutes,
Mm-hmm. Then that would be, you're looking at part of the 170 is actually him getting out and walking towards the house. And then there's another from 1221 to 1224 that starts this. Everyone just wants to talk about the flight of stairs, but nobody talks about there was 80 steps. That gets lost in translation.
And what you mean by steps are steps he took, not steps of stairs, right?
Yeah, just like how her steps are like this.
Right.
Okay, those are like actual steps. So what actually we're dealing with here is that John has 80 steps, okay, from 1221 to 1224, but he also has a little bit extra up here. Like
he has some left over.
You can argue it. And then from 1224 to 12, this is what ends up happening is that this is where the 36 comes in. And so my argument here is if we believe that he met with the dog right when he was like approaching and went into the garage, okay, that's going to be part of this.
Part of the 80 steps?
100. And then this 1231 with the 36 steps, okay? Then that's where that's to me is somebody that took his phone out of his pocket, okay? And they were attempting at first to call Karen, and then they decided not to.
Or they took his phone and walked around with it in a frenzy and were freaked out because they needed
there's not enough time. No, there's not enough steps. You only have 36 steps. And so what I'm saying here, though, it's in between. It's just in a very short time period.
That could have just been 3 concentric circles really quickly.
No. This needs to be taken into a car and into a glove box. The reason being is because of the pocket state. You have to account for all of everything that's going on.
What time was the pocket state started?
The pocket state's at 12:32 and 9 seconds.
So then it doesn't account for that 36 steps.
No, it does, because this goes until then. 12:31, and it's like this. See, that's not putting this.
It's
12:31 and 52 seconds.
Okay.
Anyways, I'm right. I know that I'm right because of the math. And so your 80 steps here, okay? You have that's consuming with John getting out, walking over to the house. That's your 80 steps is inclusion of then boom, he gets hit. They would have had to totally fuck with his phone. Because he goes down for the count and he doesn't move again. Now, that's why I think that you need to look at it that he doesn't move again. That's the 12. No. So 1225, if he would get hit, that's when he doesn't move. Because the person right here that's with his that took those steps with like that, this is somebody else. That's not even John. That's my point. And that the reason that they answered then when she called at, hold on, let me put this, when she called him at 12:29 and it was answered, his phone was vibrating and ringing, and they picked it up, took it out, and it's a matter of, and they answered it. Just like this. And so the 36 steps wouldn't be with John. The 36 steps are with the person that took his phone after answering this call from Jennifer McCabe. Because he wouldn't have been able to answer it. That's why they had to lie about that. That's why this had to be such a big lie. Why couldn't you say that he answered that phone call, especially if he didn't get out of the car yet? And the reason is because they had to lie about that phone call because it wasn't John that answered. You have to look at all the
data.
Yeah, you have to look at all the moving parts there.
Yeah, you gotta like present it when you have it all up there and tell us about steps. Sherry
So-
D is such a sweetheart.
Yeah.
Thank
and so
you.
I think that if you break it down, that 12:31 and 52 seconds to 12:32 and the 36 steps that happen, that wasn't John.
Okay.
Remember how Karen Reed said, me and my team think that he died between 12:25 and 12:30? This is why. This is the math they're mathing. And if you're thinking that, then it's not off of the key cycles or anything stupid like that. It's off of John's 80 steps. No one's accounting for that. They're only thinking about like those 3 flights of stairs. You might get 3 flights of stairs if you're in a car, but you're not going to get the steps. That's where it's going to be skewed. So those are actually steps. So I think he was struck and fell back, did whatever, and that happened by 12:25, and then he was, he doesn't move, and then the phone's ringing at 12:29. Somebody gets it out of his back pocket, answers it, because it cleared pocket state, and then
What time does it clear pocket state? Are we talking about the 6 a.m. or like before that?
oh, they were still clearing pocket states here, and then once it clicks off that last time at 12:32, it doesn't clear pocket state for a while until the morning. Go over it more tomorrow.
Yes, do. Thank you guys so much for being here with us. And I think we literally, this is so egregious and so bold-faced, disgusting. They're not going to get away with it. Karen Reed is free. The travesty is that she has to be, literally, it has to be an acquittal, and she needs to get that turned into exoneration, not acquittal. Get an extra large steak. Okay, Sherry, I will. Love you, girl. Thank you, Lana. You want to say anything else about it?
I don't think Jen McCabe knew until there's no way that Jen McCabe would have called all those times back to back to back to back to back. They weren't looking for his phone. That's not what happened. And they wouldn't have been that quick-witted to be like, oh, hey, start calling him and we're going to act like what? Like that he just never showed up. Like that'd be super fast to say that you're already on that to even, I don't know. That's crazy. I'm not with that. I think Jen McCabe was calling because she was like, where the fuck are you? Like, we just saw you. But we'll talk about it tomorrow.
We just saw you pull up.
It's very interesting. This is very.
Well, I can't wait.
I wish Derek Ellington would have testified because I wanted more info.
I know you did.
I wanted it.
I know you did.
I
know you're salivating for it.
Yeah.
I mean, I would have loved to see it too, but I just didn't think that they were going to do that because they cinched it and they don't want to confuse. They've learned from the first trial. They don't want to confuse things. And I liked your argument about loose ends yesterday. It was a solid argument. I give it a 9.5. I'm a hard grader. So that's pretty good.
All right, good. We'll be back here tomorrow. Thank you guys so much. Sherry D, thank you so much. God bless America. It's not a steakhouse, but Duke's right on the pier. Oh, thank you.
Duke's on the pier.
The commentary today. I'm sorry, I forgot your name, Bella.
Lana.
You guys are great.
Yeah.
All right. Much love. We'll be back here tomorrow morning. Thank you,
Thank you, Lana.
moderator.
Thank you, moms.
Anybody win bingo today?
I didn't see a bingo win. Murky is the queen of it, but I didn't see anyone claim bingo.
Okay, we'll play another game of bingo tomorrow because Bev's gonna do a lot of talking. So we'll clear.
Yes, Cherry.
All right.
Cherry Blossom says this. I sent you. Oh, you're muted.
Oh, thank you. I'm gonna peace out. Bye, guys.
Bye. Thank you guys for